Ever get any money from Costello?
No.
And did you ever get any money from Meyer Lansky?
I never got money from any of those fellas.
None of those
None
fellas?
of those fellas. None of these that I've been reading about, and none that I knew. They never gave me anything.
None of the Shetties?
No.
You
I
did-
don't even speak to the... I mean, I met that Charlie once or twice. I don't even talk to him.
You don't like him?
I was conscious of the fact that he had a reputation for being an outstanding bookmaker.
You ever hear him referred to as the Prime Minister of the Underworld?
That term I did not.
Also known as Duck Corella. I refuse to answer on the grounds of made offensive. Got any business? I refuse to answer on the grounds of offensive criminal. You have any profession? I refuse to answer on the grounds of made offensive. Have any occupation? I refuse to answer on the grounds of made offensive. Are you a known racketeer?
An incarcerated individual's use of institutional telephones constitutes consent, and your calls may be provided to law enforcement agencies. Thank you for using Securus.
Good morning, folks. That little Securus thing is going to be real for somebody, I think, very soon, and that's our friend Senator Nicole Mitchell in Minnesota. For those of you that's first morning, I doubt it. I think everybody's retuning in to see how this soap opera turns out. That we're covering the trial of Minnesota State Senator Nicole Mitchell, who about a yearish ago, after the death of her father, she breaks into her elderly stepmother's home at 4 a.m. in the morning, dressed in all black, wearing a cap, carrying a backpack with laptops and crowbars. Breaks into the house, is discovered in the bedroom of the elderly lady. As she awakens, she gets out of bed and she steps on Nicole, who's lying flat on the floor. And at this point, she calls 911. Nicole runs to the basement, and police arrive, and yes, you know the end of that story. They arrest her. Great body-worn camera video from this. Nicole was given inconsistent statements. She says that she went there to check on an elderly family member, when in reality there is evidence that there is a dispute over the estate of her late father. She says on video that she broke into the house to retrieve a flannel shirt and some family photographs. On the scene that morning, on her testimony yesterday, which was epic. I'm sure we'll replay some of this today because we'll have deliberations, I believe, going on today. So if you hadn't seen it, I'll show you some of it. The epic, she gets on the stand to defend herself. Epic testimony. She is the school marm. She's just, I believe the term coined yesterday, she's a giver at heart. She's a caretaker at heart is actually what was said. She was just there to take care of look after the welfare of this lady. She had a checklist that said cell phone, delete text. And she said that meant I wanted to find her phone to make sure that she, at 70 some odd years old, didn't turn off the GPS. In case she's driving and gets lost, I want the police to be able to find her. My God, it's just so passionate what she did for this lady. And she's being prosecuted for it. It's kind of sad. But she breaks in the house to make sure that her phone is on GPS. She needed to delete some texts that were on the phone. I'm sure they were of some put Miss Carol in some sort of a jeopardy. The text that she needed to delete, but that was on her list as well. She also needed to link this cell phone to her laptop. Now, let me go back a little bit. Carol Mitchell is the stepmother. She was married to Nicole's father for over 40 years, so this is not a new relationship. And she's known Nicole for most of her life. And they give some testimony. It was a contentious relationship, stepmother-daughter relationship type of thing. Well, when dad dies, she steps in, man, because Carol is in advanced stages of Alzheimer's, is what the defense says. We watch the body worn cam. I don't really see that, but I'm sure it is. Nicole is a caregiver at heart. So what she says, I'm going to have to go with. She says that she's in advanced stages of Alzheimer's. She breaks into the house. Look, and let me tell you how deep it goes with with Nicole. She breaks in the house. She has the wherewithal to take with her a crowbar, because in Carol's paranoid state, she's locking the doors and using cripple bars that you can buy so that even if you have a key, you can't get in. Makes it difficult to get in the house. You know, she's a widow woman living at home. There's no reason to do that. That in itself is weird that Carol would block the doors, right? So Nicole, being the caregiver at heart, like we saw yesterday with our own eyes, she goes there with the tools to be able to get around that. But she also takes things like latex gloves, flashlight with a sock over it. Actually, we'll get to that in a minute because that's just another level of how caring she really is. She breaks in the house. She takes latex gloves. In her own words, sitting on the witness stand, she tells the jury and the world she took those rubber gloves to make sure the cat box was cleaned out in case Carol's diminished mental state did not allow her to clean the litter box. Nicole went there at 4 a.m, break in the house if she had to make sure that litter box was clean. She also had those rubber gloves because she's sure with Carol's diminished mental state, there's expired food in that refrigerator. This caretaker at heart, just no depth of the kindness and lengths that she will go to take care of others. She breaks in the house to make sure the kitty box litter doesn't have feces in it. She makes sure that all the items in the refrigerator have not expired. And if they had been expired, she had the latex gloves. She was going to clean this stuff out, every bit of it. Now, while she was in the kitchen, her father and Carol she's been in this house many times before. She kind of grew up there. They used to keep their phones on the kitchen counter. Now, the phone was key to this plan. She needed the phone to make sure the GPS was turned on. She needed the phone to make sure it was linked to a laptop that Carol had previously given Nicole's for her children. It wasn't the best laptop, but it did have Nicole's email on it. And it did have Carol's email account still on there, logged in. Nicole, being the caretaker at heart, went through those emails and was able to see Carol's medical records through a portal that was still logged in through her own email. She was able, through Carol's email. Nicole's able to look at these to see if she's making her appointments. Because Nicole wants to make sure she makes her appointments. Nicole was able to see through this email that there had been a couple of times where Carol had input the wrong PIN number to her bank card. So thank goodness. Carol did give this laptop to Nicole, because now Nicole is able to look at medical information to track Carol, this grown woman. Now this caretaker at heart is able to even track some banking transactions. Now I'm sure she couldn't get into the bank account. That would take two-part authentication these days, right? I mean, you need Carol's cell phone and the email to be able to verify that you could access your banking information on that laptop. But that's neither here nor there. Nicole, in her own kind words, the caretaker at heart, deep caretaking runs in her soul. She had to go into Carol's bedroom while she slept, to stand over her bed. And she said to make sure she was still breathing. And she did. But also, the other reason she goes in the bedroom, because that cell phone wasn't in the kitchen, and she needed to make sure that the GPS was turned on in case Carol gets lost. Can you imagine this? Carol, she's so paranoid as a single elderly woman, widowed of almost just at a year. She's locking her doors and putting bars on them so that people don't come in. She's paranoid. She's clearly, the GPS needs to be turned on. What happens if she's lost? The police won't be able to find her. So it was imperative to this mission that Nicole gets a hold of the cell phone. Don't worry about that two-part authentication and the fact that she took a laptop. By the way, folks, did I tell you how long she drove that morning? She leaves her home near St. Paul, Minnesota, and drives 3.5 hours to Carol's house. That's what kind of caretaker at heart she is. That's how deep her love goes for others and how much she's willing to do it. But she does it, just a happenstance, though. The laptop that Carol gave her traveled this 3.5 hours. Somehow or another made it inside the house, inside of a backpack. But she just needed to make sure that GPS was turned on the phone. You know, we all accidentally turn our GPSs off many times a day. And I'm sure it would be common for Carol to do it. I mean, she's older, you know, didn't grow up with technology necessarily. Oh, and she also needed to delete some contacts on Carol's phone. Evidently, there's some bad contacts on Carol's phone that she's probably had that number for more than 30 years, I would guess. 30 years worth of contacts in there. And Nicole just wanted to make sure that these contacts were deleted. Some at least needed to be deleted. Otherwise, how would other people see what Nicole sees? How would other people see this widow woman super decline if she didn't take out some of the contacts? Can you imagine calling a friend that you've had their phone number for 30 years and they go, "Hey, who is this?" What do you mean, who is this? What's wrong with you? Because we've known each other for 30 years. We've called each other thousands and thousands of times on this phone number. Yet I call you this one time. You know what? What they've been saying about you is having diminished mental capacity. I'm starting to see signs of this. So Nicole just needed to delete some contacts. Well, during this compassionate entry into the home to clean out the cat litter box, to make sure the food in the refrigerator hadn't expired, to make sure that the GPS is turned on Carol's phone, Carol wakes up. Now, Nicole didn't come there to scare her, and she knew, being dressed in all black, carrying a flashlight with a sock over the top to muffle the light coming off. Carol does the only thing a compassionate person could do Nicole does the only thing a compassionate person could do at this point. Lay on the floor and hope that the person's home you're in doesn't see you. It didn't turn out this way. Carol, being in her demented state, she's a little bit of a firecracker, she gets up and she stumbles across Nicole's body. So first thing she does, she picks up that phone that I'm sure the GPS was turned off on. Oh my God. And she calls 911. Now, Nicole at this point understands exactly what a compassionate person needs to do. You know, a caretaker at heart. This is exactly what they need to do. They need to run down the hallway back into the basement and make an attempt to get out of that house. Now, Nicole testified. You heard it in her own words. She was able to hear what Carol was doing. She was able to hear that Carol was on the phone, that Carol was calling 911. And being a caretaker at heart, you know what? Don't scare her now. Just let her call 911. So Nicole, now she is concerned about the backpack and the laptops. Evidently, that would have upset Carol. If Carol had known she'd brought a backpack into her home when she broke in, that's an issue. So she tries to get the backpack outside the window, but it gets stuck in a small basement window. She shoves on it, but she can't get it through. This is unfortunate for Carol because now Carol is going to be disturbed knowing that this backpack was in her home. Police arrive. We see this on body cam video. It's the police. She says, whoever it was in my bedroom. I stepped on them. She says this on 911 too. I stepped on them. They ran out and they're in the basement. I can hear noise under the stairs. This window that she's pushing the backpack in is under the stairs. So the first officer arrives. He says, "Yo, I'm the police. Announce your presence. I hear you in the basement. Announce your presence." And being the caretaker at heart, Nicole doesn't say anything. She's quiet. Not a word from the basement. Can't hear anything on the body cam. Second officer arrives. They go down to clear. And it's a nice basement. They walk past a utility room, and through this utility room, it's a small utility craft maybe room, but through it, where you think there might be another closet, there's actually a bathroom door there. They walk past that. They do a visual clear of the utility closet or room, and they go on into the basement. Carol is even at the top of the stairs, kind of directing. And at some point, Carol says, "There's a bathroom through my crafting room here." So the second officer goes there and opens the door. And there's Nicole. Nicole was waiting on law enforcement. Nicole did the right thing. She waited on law enforcement. She didn't try to leave. She wasn't trying to get the backpack out of the house and herself out of the house when officers arrived, because the officers could hear the noise under the stairs, the timing, not looking right for an escape. But Nicole was not trying to escape. Officers prone her out. She goes prone. She's compliant. She doesn't put up a fight because she's a caretaker at heart. Don't forget that. As they're securing what they believe to be a burglary suspect, the officers have not learned yet that she's a caretaker at heart. They believe she's a burglar. She's got a black cap on. She's got black from head to toe. She's got flashlights. She even has some flashlight gloves. You can put your fingers in it, and they got flashlights at the end of the tips. And it was at this point that the caretaker at heart once again said, Carol, it's me, Nicole. Carol, the defense claims she's in advanced stages of Alzheimer's. Carol snaps back very quickly. Oh, that's you, Nicole? Oh, my God. They take her outside. They put her in the squad car, treat her like a common criminal, to be quite frank with you. They got her under arrest. They got handcuffs on this senator. She's also a military commander in meteorology. She's everything we all want to be. This Nicole, Senator Nicole Mitchell. She's sitting in the back of the car. After her rights were read, they asked, well, what were you coming here for? She says, I came to get a flannel shirt and some photographs that were promised to me that I hadn't been able to get because she has advanced stages of Alzheimer's. Carol didn't tell the officers that she was a caretaker at heart. Carol didn't tell the officers that she was there to check on a mentally failing family member at 4 a.m. She didn't want the credit for that. She didn't want the officers to know how good of a person she was. So she just didn't want to rock the boat. And she says, well, I came to pick up a flannel shirt and a photograph and some photographs. And I came to do that by breaking in the window, sneaking in with dark clothing on, and I was just going to remove them and sneak back out. Oh, by the way, she parked her car. Like, when you go to your relative's house and you're checking on them, you park it a block and a half away around the corner and you come in through the back to their house. This is what, well, you know what? You guys may not do that, but then I would challenge your caretakerness. Are you a caretaker at heart if you don't do these things? I say not. I say not. This is the testimony that we heard yesterday from Nicole. Went on for some 6 hours. If you missed it, you just missed some great testimony. One of the reasons I tell you to never testify on your own behalf. But we did learn a lot of things about Carol. I mean, excuse me, I'm confusing these two and I shouldn't. We learned a lot of things about Nicole yesterday. She didn't want to say anything. She fears cops. She knows that cops are just looking to shoot someone, and that's what they were when they went in that house that night when she broke in. She was absolutely doing it. Okay, I believe we are back, guys. Let's go to it. We don't want to miss too much of this. The defense technically is still on. We'll see if they're resting.
And if you would approach the court administration clerk over here, we'll have you sworn in. If you'd please raise your right hand.
Do you swear or affirm the testimony you give here will be true? If so, say I do.
All right, then you may take a seat in the witness stand and watch your step on the way up. There's a slight incline there. Mr. DeCray.
Ms. Markey, I'm sure you're nervous, and so let me give you a couple of pointers for other witnesses that I have too. The microphone is very, very hot, and so if you lean forward, it'll crackle sometimes. It'll pick you up from this far away, so feel free not to worry to lean too far forward.
Okay.
And when we talk about whatever you're going to testify to, please use the people's first and last name if you can remember. Okay?
Yes.
Would you please state your full name for the record?
Cindy Lee Markey,
Can you spell your last name, please?
Markey.
Keep your mouth towards the microphone, because if you move it, it will grab. So
Okay.
it's okay. You're going to do great. Where do you live?
Moorhead, Minnesota.
What is your relationship to Nicole Miller? Nicole Mitchell, I'm so sorry.
I'm her aunt.
And how long have you known Nicole Mitchell?
50 years.
Over the past 25 years or so, when did you normally see Rod and Carol Mitchell?
Oh, pretty much every holiday. Birthdays, Mother's Day, Father's Day. We got together with my parents.
Where did you get together?
In Moorhead.
At some point, did you learn about Carol Mitchell having medical issues?
Yes.
Can you explain what those were to your knowledge?
Her and Rod, after Thanksgiving, one day asked to sit down with my sister Nancy and I, and they explained that Carol had been in for testing, and they'd kind of done a base at that point, and that she would be tested every 6 months, I believe, to start with, to see the progression.
The progression of what?
Alzheimer's. I'm sorry.
That's okay. Was there an example of forgetfulness related to Carol Mitchell that you noticed at your brother Rod Mitchell's funeral?
Yes. At one point, Carol and I were talking, and my daughter approached us, and Carol introduced my daughter to me.
This may seem like a silly question, but had you met your daughter before that day?
A few times, yes.
Did Carol Mitchell catch herself and realize she was confused during this interaction?
No.
Do you recall an example of forgetfulness related to Carol Mitchell and her purse?
In what?
Her purse, about losing her purse?
Oh, yes. She'd been up to Nancy's, and we'd had a holiday, and she left because she had to go home and take care of the cats. She was very worried about her cats. And she called the next day and wanted to know if she'd left the purse in Moorhead. And we told her no, we looked around, we didn't find it anywhere. And she called later and said she found it. It was at the bar she stopped at on the way home.
Did Carol Mitchell ever show evidence of paranoia related to paperwork in her home?
Paperwork, I probably couldn't talk to much. That was Nancy's area.
Okay, then please don't, because that's not, if you don't have personal knowledge of that.
I do know she was always saying she was missing things.
Can you
and then
speak
she'd
about
find
that?
it later. But what the paperwork was, I couldn't say.
Can you talk about that, your knowledge about that general, Carol Mitchell's general demeanor for asking about things or thinking things were missing?
Yes, she would send a text or call, and I mean, when I remember her charger, she couldn't find her charger anywhere. It's not where she always kept her charger. And she called a few hours later, and she'd put it in the bedroom. So, or she would not be able to find something, and then she would say that her friend Lori found it. So she'd always let us know she found it.
In the months leading up to the incident in this case, did Carol Mitchell's behavior towards you and the Mitchell family change at all?
Yes.
How so?
She started canceling plans that we would make. She didn't respond to texts for a couple days. And just, making plans and backing out and not remembering that she'd made plans and not being there.
How did that make you feel?
Very worried.
For who?
For Carol.
Did you check on her based on those concerns?
I would text and I would call. She would normally, within a couple days, reach out and say, oh, she was busy here or there. So I never drove down to check on her, no.
Did she say anything why she did not want you to do that?
No.
Do you recall her saying people were not allowed in her house anymore?
Yes, I got a text to that effect. That was, yes.
Thank you. Did you have some interaction with Carol Mitchell related to the interment of your brother Rod Mitchell's ashes in the spring of 2024?
Yes.
Did you reach out to Carol Mitchell about the ashes?
Yes.
Why?
We'd had a lot of deaths in the family, And we were going to make a special trip out to where we spread my parents' ashes. And that was out on Washington Island. And I'd asked Carol if we could have some of Rod's because I was taking my daughters and both of my sisters to bring out there. And we thought it'd be nice. And she said, of course.
And was this a text message conversation between you two?
Yes.
It didn't grab.
Yes, it was.
Thank you. And did you take a screenshot of those text messages?
Yes, I did.
Maybe move just a little bit up because I think we're missing you a little bit.
Okay.
I gave you bad advice. I'm sorry. Did you provide those screenshots to Nicole Mitchell's attorneys?
Yes.
I'm going to show you what's been marked as Exhibit 327. It's going to show up on the screen in front of you, and it's going to show up here for Mr. McDonald. Can you see that? Oh, yep. Oh, okay. 1 second. We've had some inner. It's and then we have one.
Can I just review it? Can I review it on? All right, we're having a little bit of issue with technology here as the documents seem, or the exhibits are being published before the being offered. And so one solution be to shut the system down, turn it back on and try it again. Or Mr. McDonald, when it flashed across, and I'm assuming you've received 327 before and have had a chance to review it.
I certainly have received this, Your Honor. I just don't have it pulled up this second. So if I could just review counsel's,
You may.
expedite this. Can you give some foundation for the tape?
Do you remember the approximate date and year of those text message conversations? Because on the screenshot, it didn't take the date on there.
I'm guessing it was within a week of the internment of the ashes. So that would have been a week before March 19th, 24.
2024?
Yes.
Or we would stipulate to the exhibit.
So it's being offered.
The exhibit is being offered as 327, and we would request permission to publish it to the jury.
All right, Exhibit 327 is received and you may publish.
Ms. Markey, what I would like you to do is I would like you to read this text message, but please, if you can tell the jury which person is which color, and then whoever it is, say, this person, read their text, and then the other person. Does that make sense?
Yes.
Okay, so whenever you're ready, please identify the two parties, the colors, and go ahead.
Okay. The light pink would be me and the dark pink would be Carol. Would it be possible to get some of the ashes to take to Washington Island? We are bringing Julie's, Erica's, and Lori's out in June. Carol responded, absolutely, and you could remind me how much the two checks were from Lori's estate. I see the tax lady on the 22nd and cannot find anything. I'm still a mess. I said I would look through her estate stuff tonight. And she responded with thumbs up, and I responded the next, looks like that night, $35,000 and $17,160.38. None of it is taxable.
You can put it down now, Your Honor. Thank you. So based on what you just read, her response initially was that you could have the ashes. Is that correct?
Yes.
Did that change at some point?
Yes.
Talk about that, please.
On the day of the internment, we were driving down and I was trying to get a hold of her to find out when was going to be the best time to get some of the ashes out, if she wanted us to come to her house. It was really windy that day. I really didn't want to do it outside. And she told me that no, her house was off limits and that I couldn't get any of the ashes anyway because the urn was already sealed. I tried to tell her that that's the way it comes and it's very easy to unseal it and reseal it. We'd just done that with my daughters when she passed away so we could bring some to my sister's lake home.
Do you think she was being mean to the Mitchell family, or do you think she had forgotten that she had agreed to it?
I think she was being mean.
You just testified that there were some text messages between you and Carol Mitchell about her house being off limits.
Yes.
Did you take a screenshot of those messages?
Yes.
Your Honor, I don't know if we have the same issues, but we could have Mr. McDonald look at this again, or we could try the technology, whichever you prefer.
Let's try the technology. Could you shut down at all? Okay. All right, let's just try it again here. And then you can go to blank screen quickly, Sarah.
So this worked this time. So I'm going to show you what's been marked as Exhibit 337. It should be on the screen in front of you. Can you see that? Is this a complete and accurate representation of the conversation with Carol Mitchell, and that you were just referenced?
Yes, it is.
Has the screenshot ever been altered?
No.
Your Honor, I'd like to offer Exhibit 337 into evidence and request permission to publish.
Mr. McDonald?
No objection.
All right. Exhibit 337 is received and you may publish.
So we just did this before, but I don't want to put any words in your mouth. So please identify the color and the party and read the message when you are ready.
The dark purple would be Carol. It says, just a note, I'm not doing anything at the house, so if you all want to gather, we could go to the Holiday Inn or whatever. Sorry to say, but my house is off limits.
You can put that down, Your Honor. Thank you. You mentioned a moment ago about the interment of your brother Rod Mitchell's ashes. As to the timing of when that interment happened, do you have any feelings or knowledge about that? With respect to Nicole Mitchell?
I know that Nicole could not make it that day because she had session. And she wanted us to wait till Good Friday to do it. And Carol told me she couldn't because she would have to change. Too many people had been invited already and she'd have to change it, so she could not change it.
How did that make you feel?
I kind of saw her side. I imagined a lot of people there. I imagined a lot of Rod's friends. I would imagine, Carol's family. I imagined she'd had a plan and it was going to be tough to change it that quick. And sometimes those things happen. So I guess I just thought that's the way it had to be.
Do you wish that Nicole Mitchell had an opportunity to be there?
Oh, yes.
Do you have any experiences in your life checking on a loved one that Nicole Mitchell knew about?
Yes.
Can you talk about that, please?
There was a couple times my daughter had some issues and she wouldn't be answering the phone for a couple days and I would get concerned about her. I did have a passcode to get into her house, but if she was mad at me, she would deadbolt it and then I couldn't get in. And after a couple of days, I'd be very concerned and I would find a way in.
Why would you do that?
Concerned that something had happened. concerned that she wasn't well.
And Nicole was aware that you had done those things?
Yes.
I want to loop back very quickly to the interment. You just testified that Carol Mitchell had invited very many friends of hers to the interment. Do you remember how many people actually attended the interment?
There were 4 people and myself.
Thank you. Do you have a sister named Lori Sandry?
I did, yes.
So that answers my next question. Is she alive or deceased?
She's deceased.
When she died, did she die with a large estate?
Yes.
Did she intend for part of that estate to go to Nicole Mitchell?
Objection, speculation.
Your Honor, we just saw text messages about it.
No argument here.
Okay.
You can approach.
Large estate. To your knowledge, what was the process for distribution of that estate?
We were to split it. We were to split it between the 5 remaining siblings. I had a sister at that time that was in a nursing home. So instead of the money going to her, it went to her son. Other than that, it was split between the siblings.
What is your knowledge about those splits either supposed to be going to Nicole Mitchell or any written documentation about part of that money going to Nicole Mitchell?
Part of the money did, each of the nieces and nephews got money.
So Nicole Mitchell got a portion of money.
She got a portion of money,
To your knowledge, how much was that?
$10,000.
Okay. To your knowledge, was there anything else that Nicole Mitchell was supposed to get from your sister Lori's estate?
At the time of Lori's death, no. How can I put that? If Lori had died after Rod, all of Rod's share would have gone to Nicole.
And was her death unexpected?
Very.
With that foundation, I'm going to ask the question that was objected to previously. To your knowledge, was an additional part of your sister Lori's estate intended to go to Nicole Mitchell? Had she not died surprisingly before Rod Mitchell?
Yes, it would have ended up going to Nicole.
And Your Honor, I would like to ask you to republish Exhibit 337.
You may.
Your Honor, I was incorrect. 327.
327. You need to make the request.
Yep. That was my fault. I'm sorry. Now, I just asked you if a larger portion of your sister Lori's estate was intended to go to Nicole Mitchell, and you said yes. Do you remember approximately how much was supposed to go to Nicole Mitchell?
If Lori had outlived Rod, it would have been about $250,000.
On this text message, it identifies 2 checks from Lori's estate. Do you see that?
Yes,
And at the bottom, you had testified earlier that you responded to that, and you had 35,000 and a little over 17,000.
yes,
Were those part of the checks that were intended to go to Nicole Mitchell?
yes.
Okay. You can put that down, Your Honor. Thank you. So did that $250,000, or even if conservatively, that a little over $50,000 actually go to Nicole Mitchell?
No.
And you said it before, but just to be abundantly clear, why not?
Lori had died very suddenly, did not have a will. She had to do a will last minute, and it was just done very quickly. There were mistakes made in it.
So what happened to that money?
The money went to Carol because legally she was Rod's heir.
Did Carol Mitchell know the money was meant for Nicole Mitchell?
Objection, speculation.
If there were
Sustained.
Can we approach, Your Honor?
You may.
I'll withdraw and move on, Your Honor. Did Nicole Mitchell know that money was meant for her? To your
Objection,
knowledge?
speculation.
To your knowledge?
To my knowledge,
Hang on,
because
let me rule on the objection here. Speculation, the objection is sustained.
You're going to give us a moment. We're going to try to find the exhibit that Mr. McDonald produced but doesn't know the number of, so we can put it on the screen.
Well, interesting so far. I'm not sure the state or the defense is getting in what they want to get in on this. I think they're trying to make the case that Carol, it's already been established she's the evil stepmother without a doubt, but Carol is withholding money and of course making Nicole a victim. She's a caretaker at heart. She should be victimized. And that somehow or another there was some money owed her that Carol didn't allow to flow through to her, but they're not really able to get that in there because it seems like maybe this allegation is pretty much speculation, meaning that a conversation between two people on a text message doesn't necessarily make it true. And the only foundation you have there is to cross-examine or examine the one person that you have on the stand. You can't ask them what the other person meant or what the other person felt. You could say, how did you understand that? Well, I understand the text to mean this, which really was also, it was speculation on both parties in the text message string. So I don't know. I want to say this. I think that them calling another witness after Nicole Mitchell, if Nicole Mitchell's testimony had been strong yesterday, you would have left it at that, because that's the last thing you want the jury in the mind of attorneys, the way they think. This is the last thing that you want to leave the jury with, fresh in their mind, Nicole Mitchell's testimony. But I think it's telling that they called this witness that really, they almost don't have foundation to even talk about what they want to talk about. They're struggling with it now. And that's why they're in recess, trying to figure out wordsmithing to be able to leave a message there. But I think it's telling that they call another witness after Nicole's testimony. Those of you that saw it yesterday, I just don't. I think she was better off not saying anything. I think her testimony was damning to her. And she, once again, helped prove the elements of the offense. It looks like we're going back.
Carol?
Assuming this is Carol Mitchell, CM, will you please read this to the jury?
Hi, Pam. I'm so worried Nicole is determined to take me to the cleaners, I think. That hearing on July 5th is supposed to be virtual, but I'm going to call my lawyer tomorrow and see if maybe I and you, if you can, be in the lawyer's office to watch it. I don't care if she gets that CD of Rod's and those 2 checks from Rod's sister, Lori, that passed away from her estate. Nick can have them too, but the house and everything else is mine, and she will have to.
You don't have to read anymore. I want you to leave it up there for now. The second part of that, I don't care if she gets the CD of Rod's and there are 2 checks from Rod's sister, Lori. Who do you believe that she is in that text message?
I'm sure she's referring to Nicole.
So Carol Mitchell is saying that she believes that Nicole Mitchell can have her father's $160,000 CD and $53,000 in checks. Is that correct?
Correct.
And just to be abundantly clear, Nicole Mitchell never got any of those checks, did she?
No, she
or
didn't.
any of that money?
No, she did not.
And to your knowledge, did Nicole Mitchell ever contest Carol Mitchell for that money in any sort of a proceeding?
No.
Thank you. You were put that down.
What was that? 98, states 98.
In your interview with our investigator, you gave a statement to the effect that Nicole Mitchell and Carol Mitchell's relationship has never been good. Do you recall saying that?
Yes.
Despite that, do you think Nicole Mitchell loved Carol Mitchell?
Yes.
Do you think Nicole Mitchell would ever want to hurt Carol Mitchell?
No.
Do you think Nicole Mitchell was trying to help Carol Mitchell after Rod Mitchell's death?
Yes.
You testified earlier that Rod Mitchell was your younger brother. Is that right? Or your brother? I'm sorry.
My older brother.
I'm sorry. Were you and Rod Mitchell close?
Yes, we were close.
Did you know Rod Mitchell well?
Oh, yes.
So yesterday, the prosecutor asked Nicole Mitchell a question on cross-examination that I want to pose to you. How do you think Rod Mitchell would feel about Nicole Mitchell breaking into his house?
Oh.
It doesn't seem like a difficult question.
It's a 2-pointer. He would not be happy about it. Also not be happy if we all gave up on Carol and didn't check on her.
No further questions, Your Honor.
Mr. McDonald.
A dumb answer.
Good morning, Ms. Markey.
Good morning.
When you spoke to the defense investigator that there was no qualification, you said their relationship has never been good from day one, correct?
Correct.
You described them as two very strong-willed women, two very strong-willed women who butted heads on everything. Is that accurate?
Yes.
That's what you told the defense?
From what I saw, yes.
Okay. Did Nicole Mitchell tell you that she was driving up to Detroit Lakes in the middle of the night?
No.
Isn't it true you told the defense investigator that Nicole, quote, will not talk about what happened?
Correct.
Okay. And you were also asked, quote, why did Nicole go over there? And you responded with, quote, not a clue.
Yes, at that time, not a clue.
Did you also state, expand on that to the defense investigator?
I don't believe I did.
Do you recall stating, this is you speaking about defendant's actions. What the hell? What were you thinking? What's going on?
Well, yeah, that would have been my thought on it.
Thank you, Ms. Markey. I have no further questions.
Mr. DeCrae.
Very briefly, Your Honor. Ms. Markey, do you stand by the follow-up questions I just asked you about your thoughts of Nicole Mitchell and her love and affection for Carol Mitchell?
Yes.
And when you said to our defense investigator that you thought, what the hell did you do, Nicole? Is that because you didn't know the full story? Because as Mr. McDonald mentioned, she hadn't said anything to you about the full story?
Correct. I just got a text from Carol that morning saying someone broke into my house. It was Nicole. And that's all I really knew.
No further questions, Your Honor.
Mr. McDonald.
Ms. Markey, in April 2024, did Nicole Mitchell ever reach out to you and inquire about medical information about Carol Mitchell?
Did you reach out to me? No. No.
No further questions.
Mr. DeCrae.
Nothing, Your Honor.
Okay, then Ms. Markey, you may step down. Again, watch your step, please.
Just a caretaker at heart. I don't see any evidence that refutes this. Good morning, Fidgy. Glad you could join us.
Good morning, Joe. I've been looking forward to this.
We should be getting to the close. I believe that's the end of the defense witness list that they anticipated to call. We should be getting close to closing statements. Let's hear it.
How many, since I missed it this morning, how many people did they call?
Just one. That was the, this is only single witness we've had this morning. You just caught the tail end of. And I'll be quite frank, there wasn't much she was able to establish. She didn't have any real information, just conversations she's had within the family. Of course, this is just wargaming. I suspect that they all know that Nicole's testimony was very poor yesterday.
You just come forward over here to the bench in front of the courtroom clerk.
Oh, they're calling another.
We'll have you sworn in. So please raise your right hand.
And I'll say again that they understand that Nicole's testimony was not good. They're going to try to put some witnesses in between to cloud the water and dull the memory.
Watch your step. There's a slight incline there.
I don't think they'll be successful.
Good luck to them.
Just a caretaker at heart. Pure.
Unadulterated.
I mean, who else would break into your house to clean your litter box, man? That's like the depth of kindness.
She's a savior.
Just so you know, Mr. Brody,
Just a saint.
when you're talking, kind of
I
stay
just
away from the mic. It
underappreciated.
crackles if you get too close. And to the best of your ability, to answer questions about anybody in this direct examination, please try to use their first and last name.
I'm going to guess that this is a defense
What's your name for the record?
Jay Brody.
investigator.
You might have to get a little bit closer to the microphone so it grabs.
You got to get him some water
Jay
first.
Brody.
Thank you. Can you spell your last name, please?
Brody.
Where do you live, Mr. Brody?
Mauston, Wisconsin.
Say that first sentence again.
Mauston,
Okay.
Wisconsin.
I thought you said Boston. Okay.
M-A-U-S-T-O-N.
What is your current occupation?
I'm the superintendent of the 126 Combat Weather Flight, Volk Field, Wisconsin.
Is that what the Wisconsin?
Oh,
Her National Guard.
she's a veteran of meteorology. Steely-eyed killers in those type of units, folks. Steely-eyed killers.
Nicole was our commander at the 126 Combat Weather Flight. Co-workers originally, and then, naturally through co-workers, friends.
How long have you known Nicole Mitchell?
6 years.
How often would you see Nicole Mitchell through the Air Guard?
Roughly once a month. It was
Typically a little more than that because when she would
Once a month. Tell me how well you know her for 6 years, once a month. What is that?
As a commander, right? She was his
seen her, what,
boss.
How often?
I've seen her 36 times my whole life.
Outside of the garden.
I'd say at least once or twice a week.
Over the course of those conversations, have you ever spoken to Nicole Mitchell about her stepmother, Carol Mitchell?
Yes.
Can you describe those conversations?
Yes, absolutely.
Objection hearsay, Your Honor.
To prior consistency.
Can he describe that bang? What's going on there? That looked like a really sharp bang. Was it 4 inches recessed from the hairline? Oh, they must have something hot to talk about.
Yeah,
Once
I'm liking the
again-
haircut too. How you take that big clump of hair in the front, you just twist it out.
I think the defense is struggling. There's no reason to call this guy. This is once again. Let's muddy the water a little bit. Throw some clouds and some smoke in a mirror over here. Hopefully, the jury will forget some of Nicole's testimony. Which, by the way, folks,
yes.
Can you describe what Nicole Mitchell told you about her concerns?
Yes. Maybe long-winded, I guess, because it was kind of an evolution of, naturally we talk about a lot of things as started with work and they would be turned into our personal lives. And so she had expressed concern that.
think he's trying to date this chick?
Displaying evidence of missing things, and she was worried about her well-being. She was concerned for how she would take care of herself, and that she was missing some certain things, let's say appointments and things like that. So sorry, trying to summarize that, but so I could go into great detail about a lot of examples, but that was the general.
That's a pretty decent conversation you have for a guy that you see once a month.
Conversations begin shortly after Carol.
Well, she
Nicole
did
Mitchell's
say there
father
was someone she talked to there. This is that guy, I'm assuming, who had dealt with something similar to Alzheimer's.
The conversations about Nicole Mitchell's concerns for Carol Mitchell.
I bet he's not as caretaker at heart as Nicole is. I bet he never broke into his family member's house to check their cat litter box.
Carol Mitchell was
Well, white liberal woman, they're just the saviors of the world, Joe. I don't know.
Yeah, got to save all those ignorant people out there that aren't smart enough to do it themselves. It's sad.
That's exactly right.
Super sad.
Like I said,
Thank God they exist. I mean, where would Carol be without Nicole Mitchell today?
I don't know. Probably not in fear of someone breaking into her house.
She'd have expired food all in her house.
And so,
unclean litter boxes at 4 a.m.
Poor cat doesn't have a clean place to crap. This is insanity. We can't live this way.
Like she would have plans to take the boys up to go visit them, and then Carol would have forgotten that they had plans.
Well, you forgot that your hairline receded, dude. Do something with it. Going back or something sideways.
Was trying
There's
to
other things you
Carol
can do with
Mitchell
that.
with any of that?
Absolutely.
Say that one more time.
Absolutely.
I can't stop
Did Nicole
fixating
Mitchell
on
tell
that
you whether or
hair.
not Carol Mitchell was
Bothers me.
accepting
Look
of
at
her
it.
help?
All bunched up there at the end like he did that on
She
purpose.
did. Nicole would tell
He
me about it, and
he literally took that saying
would,
to heart.
be
Do the
received
do.
You know, I don't like it. Something about when he sat down, they're trying to give him instructions. He'd get him a drink of water. I don't know if I like this guy.
struggling with something.
Well, at least he didn't break out into hives.
Hang on, keep this in mind. The jury is sitting to his right.
Allow it.
What do you
Did
think?
that
What
back
do you
and
think that
forth
hair looks
seem
like
to
on the
have an
profile?
impact on Nicole
Nobody's hearing
Mitchell?
anything they're saying. Everybody's focused on it's like, what is up with
Did
this
Nicole
hair?
Mitchell's concerns seem to dissipate as time went on, or
Tubby,
grow
stop with
as
the
time went
product.
on?
You know what? This could be a defense tactic. Let's
Did
distract the
Nicole
jury with this
Mitchell
guy's
ever
hair.
tell
So
you
when they go back to
about
deliberations, they're going to say,
Carol-
what was up with that guy's hair? They'll just focus.
Strike that. You asked her that already. I'm sorry. Did Nicole Mitchell tell you about Carol Mitchell's plan for her father's internment on a date that Nicole Mitchell was unavailable?
Yes, Nicole told me about.
Well, damn. Well, y'all had some detailed conversation about Nicole's life when you once a month visits.
In your perception, how did Nicole Mitchell take that?
was very upsetting for Nicole. She wanted to very much be part of anything that involved.
Well, we're listening to him drone on about how wonderful Nicole is that she broke into Carol's house. What's involved in the National Guard training there, Joe? Have any idea?
Conversations with Nicole Mitchell both.
The National Guard goes through all the regular Army training that regular Army or regular service members do. And they just only do it once a month. Now, you'll have specialty units, and I would say meteorology is one of these that there's a lot of skills that are pushed into the National Guard that we only need at certain times. So it's cheaper to just maintain it at a Air National Guard type of unit. So I can see meteorologists being like that. So they
only meeting once a month, and
I'll say their initial training is as good as is the same. In fact, it's the same. You'll go to basic training with regular Army or regular service members. You'll go to your AITs, advanced individual training, follow-on schools. You'll all be active duty schools. But you're going to have to mute music when you do.
I'm sorry. Yeah, doing it now.
Her father's estate.
But I think where they fall short is that they just don't do it every day like a active duty service members will. They meet once a month and talk about how compassionate Nicole is for her family members.
10 years?
Compassionate.
Have you deployed?
Yes, sir.
How many times?
How far away did she live from Carol? Was it 3 hours or 2?
How many different commanders do you think you've served under?
So she got to see Carol live, right?
Have you trusted every single commander?
Well, every opportunity she could, she'd drive up there. Even if she had to break in, she was going to go take care of Carol. She was there.
Caveat, because
she's like a postal worker. Neither rain nor sleet.
Or locked door will stop her from her mission.
100%. What has Nicole Mitchell done to gain your trust?
Very early on, before I took the full-time position with the unit, there was events because of my personal life that have in the past with other commanders caused issues, mainly related to my daughter who has a terminal illness. And so immediately one of our first interactions was Nicole Mitchell going to bat for me with our higher headquarters command over some issues with my daughter's hospitalization and things like that. And so
once again, more examples, folks, of she's a caretaker at heart. She's just helping people left and right.
Than what I had dealt with other commanders. And so that was the very initial moment, because she cares more about her people probably than herself.
You got to break in your house. She'll do that to take care of you.
Yeah, like I said, that was the initial reason and what earned that trust for me.
And to your knowledge, was that sort of advocacy for her subordinates something that was only limited to you, or did it apply to everyone under her command?
No.
Everyone.
She'll break in your house too.
Was there anything else that made Nicole Mitchell trustworthy to you?
Absolutely, a lot of things, and all of them tying in to the unit. I shouldn't say all of them tying into the unit. Like the majority of them in the professional relationship.
This is the weakest witness ever. He's got to be the last one. There can't be one that's weaker than him on their list. This has got to be the last one.
He's kind of the glitter to their case, unnecessary and just kind of annoying. And what is up with that hair?
I don't know. I'm telling you, look when he turns a little bit away, you get a profile. That's what the jury's seeing. The jury's seeing this, whatever's happening there at the front of his hair with the receding hairline.
Joe, we're really awful for just making fun of someone, but
pointing out the obvious, Fidgy, that the court of law is to bring the facts forward, not your emotions.
Within the unit.
Within the unit that we forecast the weather.
So many.
This defense is a unit.
Events and things like that. She would.
The whole defense theory is a unit, that's for sure.
She was thinking of morale and camaraderie, and she built that within the unit.
She built camaraderie within the meteorologist.
We have a climate survey that comes out every year.
Corps
that goes out for all of the commanders.
Imagine that as their commander.
The highest within the state for the Air National Guard.
It's probably the closest relationship I've ever had of one person that I see once a month.
Very, very easy to
over 6 years. Yep.
Sorry, that's derailing a bit, but
He'll be coming to her funeral.
she would pull together events for us, like go into escape rooms after we were done with drill. Or
Oh, we get to go to escape rooms. I bet that was fun.
We had a holiday party that was it was tickets to get into, and she bought them for the entire unit because she wanted them to.
She paid for the tickets. That's why she needed Carol's money. She was doing good things for our servicemen.
Well, it's like Robin Hood. Whatever money she got from Carol was going to go to good things.
Like escape rooms.
You
Escape
thought
rooms and
Nicole
parties
Mitchell was a
for
good person and a
people
good
with bad
commander.
haircuts.
Absolutely.
I have no further questions, Your Honor.
Yeah.
Mr. McDonald.
You had no questions when the guy
Good morning,
sat down,
Mr.
but
Brody.
I'm glad that you're.
Thank you for your service.
Oh, here we go.
Mr. Brody, you testified that Ms. Nicole Mitchell was very upset after the internment situation.
Yes, sir.
And when this case started, Ms. Mitchell was your commanding officer, correct?
Yes, sir.
Would you consider her a good leader?
Absolutely.
And a good leader make sure that their troops are outfitted for missions. Is that fair to say?
Yes, sir.
Make sure they have the proper equipment.
Yes, sir.
Make sure they have the proper attire.
Yes, sir.
And you testified that Nicole Mitchell is a trustworthy person.
Yes, sir.
Would you consider her an honest person?
Yes, sir.
As a leader and a commander, you imagine
It's a trap.
people are put in a lot of stressful situations.
Oh, yes, sir.
Okay, so if she says something in a stressful situation, we can believe her.
If she
He
says
agreed
something in
on
a
that.
stressful
Gotcha.
situation, we can.
You testified she's an honest person, correct?
Gotcha.
Yes, sir.
And she's a good leader. So if she's in a
Oh, hang on a
stressful,
second, Mr. McDonald. Let the witness ask the question. Mr. Brody, you nodded your head if you'd please
sorry, Mr.
provide a
Brody.
verbal response to the last question.
I'm sorry?
You nodded your head to a question. We needed a verbal response, but Mr. McDonald didn't allow you to answer. So we're moving along here quickly. So why don't you back up, Mr. McDonald, a question or two, and let's
I apologize,
let the
Mr.
witness
Brody.
answer before you begin.
Sorry, Your Honor, and Mr. Brody. Mr. Brody, you testified that Nicole Mitchell is a trustworthy person,
Yes, sir.
and you just now testified that she is an honest person.
Yes, sir.
And you testified that as a commander and a leader, from your experience, those individuals are put in stressful situations.
Yes, sir.
Okay. And they have to make decisions and answer questions in stressful situations.
Yes, sir.
And if they're asked a question in a stressful situation, we can trust that their answer is honest.
Not necessarily.
What's that?
Not in my experience, sir. Very many commanders that I have come across, especially in stressful situations, do not make the correct decision.
They'll lie.
People.
Well, I'm talking specifically about
Objection, Your Honor.
Nicole.
He's badgering the witness.
Well, he's not a good
It's
judge of
allowing
that,
the
is he?
witness to complete the answer. Mr. McDonald, if you'd wait for the witness to finish.
Sorry, Your Honor.
You may complete your answer, Mr. Brody.
Yeah, not necessarily. I believe that it's all in context.
Yeah, your testimony is in
But
context.
in the context of Nicole Mitchell, she's an honest person and we can trust her answers.
I mean, depending on the context, sir. I have experienced many commanders in dire situations, in combat situations, in not even
Man,
that
you're-
extreme.
You're a weatherman.
And
You've
how
never seen
people
anything
handle
combat.
Those
Be quiet.
situations is different for the individual. So it doesn't undermine their trust or my trust in them or their honor because people handle those situations differently.
Have you ever been under Miss Mitchell's command in a stressful situation where she lied to you?
No.
No further questions.
Mr. DeCray.
You testified that at some point, Nicole Mitchell was your commanding officer. Is that correct? Is she your commanding officer anymore? I think you have the.
Sorry.
It's okay. So her status as a commanding officer has no influence on your testimony today.
Correct.
would you agree that someone's honesty is related to the context of the situation and not the person?
Absolutely.
No further questions, Your Honor.
Mr. McDonald?
No further questions, Your Honor.
Mr. Brody?
Ouch.
Are we literally talking about that people are only expected to be honest when they're not under stress?
Well,
About?
that question was kind of, okay, you knew her to be honest, but in another situation, she's probably not, right?
Well, they're going
And
back
he
to
just confirmed that.
Hang on, that was very key there by the prosecution. The defense was flailing in the wind. Prosecution did a pretty good job there. Remember when she said that on the scene, I came here to broke in to get a flannel shirt and a picture. This is significant because in order for it to be burglary, if she broke in to clean the litter box, it's trespassing, maybe a breaking and entering, much lesser charge. For it to be burglary, you have to break in with the intent to commit another crime. Whether you were successful at that crime doesn't matter. The state's got to prove your intent. And she said, after being read her rights, no way to get this thrown out. She said, I did this. I went into that house to get a flannel shirt and some family photographs that had been promised to me. That's what she said. Now, on her testimony, now I broke in to clean the litter box and the refrigerator and make sure that the GPS is turned on the phone. That's what she said in her testimony. If you'll remember yesterday, the prosecution said, okay, well, you said this on the scene, so the defense even brought it up. You said this on the scene, so which one is true? Both sides understand how significant that statement is. If the jury believes that she went there to take a shirt, take a single photograph, it's burglary, right? So
Right.
That's what this guy's saying. Well, you serve with her. You say she's an honest person. She's all this. She's a caretaker at heart. And then in the well, hang on. But then in a stressful situation, you would expect them to be able to, because that was her excuse. Well, I was stressed. I was stressed is the reason I said this crazy lie. I just lied. I lied there on the scene. 100%. I lied. I didn't go there for this shirt. I didn't go there for this. I went there to clean the litter box and check the refrigerator expiration date on the food in the refrigerator. That's why she broke in the house. And remember, folks, if the jury believes that, this is not burglary. If the jury believes she went there to take a thimble out of the kitchen, it is burglary. Let's see what's going on here.
At all to anyone involved in it. Do not read about this case in the newspapers or listen to news about it on radio, television, social media, or internet. Do not talk about any of the people or any subject involved in the case with anyone. Do not share information about the case in writing, by email, by telephone, on the internet, or by another means of communication. You must not email, blog, tweet, text, or post any.
I've given the jury some instructions before they leave. I think we've closed. We're going to go into closing statements, which should be epic, folks. Should be epic. But going back to that last guy's testimony, I think the state wins this. They made him look like that. He didn't look great. He didn't really have anything to say. That hair is really, I'm not lying either, by the way. That hair is going to stick in the jury's mind. At least 2 or 3 of those people won't be able to get that hair profile out of their mind. And it's just weird when people will stick with things like that. But 100% I believe that to be true.
I'm like that.
But he stumbled on that, like, basically the prosecution got this idiot to say that, well, if my commander is really stressed and they lied to me, then I still consider him an honest person. Now, if I've ever had a commander lie to me, you're done, man. And I've served 12 years in the Army. I can't imagine a commander giving crucial information that they knew outright was a lie because they were stressed. That would be, as soon as the upper command realized this, there would be a no confidence vote on this, and that commander would be gone. I'll tell you that from experience. Same with law enforcement. Let's say there's a shooting and the law enforcement officers, you're going to be rattled. You're going to be rattled. That's a serious, that don't happen every day. And would you forgive a police officer because he was rattled and lied? Of course you wouldn't. And nobody's going to believe her that she was rattled, so she made up something that wasn't true. That's what she's saying. No, absolutely never entered my mind to taking a flannel shirt or taking one thing from Carol's house. I went there to clean the litter box and check expiration dates on the refrigerator. Who can forget this? I think she's toast.
I think she is. and I would like to see the prosecutor reiterate something. Reiterate two things. One, the hacking into her health app, that to me, that was beyond, and then to turn around and tell people, oh, I didn't want to scare her because she's afraid of her information being on the net in case someone hacks into it and scams her. Like you. And the other thing I would like to see, I know that sounds like a very small thing, but it's something that would stick with people. It would creep them out. I'd like to see the prosecutor say something about Carol's statement of standing there staring, or Nicole's statement of standing there staring at Carol while she was asleep.
Well, now let's talk about closing statements in a trial. Opening statements in a trial, there are some rules. You've got to, you can only talk about things you've laid foundation for, or you will lay in an opening statement, you will lay foundation down for to talk about. And that's on the state side. The defense has got a little more latitude when it comes to their opening, and they'll have a little more latitude on their closing. The state will be able to talk about anything that they've laid foundation for, which in this case is pretty solid foundation, in my opinion. But they're also allowed to make some assumptions, give some opinion about the evidence that the jury's heard. I expect you to hear it over and over and over again, used like a trope, that Nicole Mitchell would have you believe that she broke into this elderly widow's home to clean the cat box. Nicole Mitchell would have you believe that she broke into this elderly widow's house at 4 a.m. through a basement window to make sure that all her food had not expired in her refrigerator. Nicole Mitchell would have you believe that she broke into this elderly woman's home at 4 a.m. through a basement window to make sure that the GPS was turned on her phone. I would beat that. I expect to see that, actually. I would beat that home for the jury, because the more you say it, the more ridiculous it sounds. And the defense is just going to pull on the fact of how good and caring Nicole is. They'll talk about her being a senator. They'll talk about her being a commander. They'll talk about her achievements. They'll talk about her adopted child. Because that's like, people when they get an animal, oh, it's a rescue. Nobody ever just gets an animal. My dog's not a rescue, by the way, folks. I bought him from a guy that had puppies. So he's not a rescue. Somebody should probably rescue from my dog. But you know the type of person I'm talking about. Every animal they got, oh, it's a rescue. She adopted a little boy, and it's a rescue. But they're going to pound on that. They're going to pound on all the good things that she claims to be, that she went there to check on the welfare, albeit a silly plan, but it had good intentions, is where the defense is going to roll with this. But I think the state has every opportunity to kick this in the guts and beat the guts out before it ever gets to the jury.
Well, I mean, she does have a chance. Joe, I'm sitting here while you were talking and while you were driving, explaining how driving home what a saint she is. I'm a Catholic, and we have procedures within our church so that she can be canonized. And, doing a 4 o'clock in the morning, she drove 3 hours. She did a 4 o'clock in the morning welfare check. She was going to do some light cleaning for her. She stared at her while she was sleeping because it was so sweet. Yeah, she's a saint.
Look, I'm not going to disagree with you. Saint Nicole, it could be the burglar saint, because she's done something similar in the House. There was a bill that it was squashed, thank goodness. But in Minnesota last year, they considered requiring every homeowner, every person that owned a gun for self-defense, that if they didn't have it in their hand, they weren't awake and in positive control of this firearm inside their own home, it had to be locked into 2 lockbox containers, the weapon in one and the ammunition in the other. So it needed to be unloaded, locked in 2 different containers. This was an act that it would have helped people like Senator Nicole. Senator Nicole Mitchell, it would have helped her. It's a safe burglar act. Think about if you've got to go to 2 different boxes while the burglar's in your home. It gives them an opportunity either to defend themselves prior to you getting a gun, because the burglar needs to defend themselves if they're in your home, or gives them an opportunity to, say, run in the basement and get out before you're able to retrieve your weapon and defend your home and your life. So I think that was shot down, but Senator Nicole, her side, the Democratic Party in Minnesota, they pushed very hard for that. They wanted to make burglars safe. Just because evidently this happens a lot in Minnesota. People in Minnesota are burglarizing and breaking into people's houses for good reasons. They're breaking in to make sure that people's cat boxes are clean. They're breaking in to make sure that people don't have expired food in their refrigerator. And, they don't want to alarm anyone, so they're dressed in black when they do that. I think it's very common, evidently, in Minnesota. Otherwise, why would you have a bill to make sure that somebody doesn't inadvertently kill a burglar that's there to clean your cat box? Cleaning your cat box, no reason to die.
I'm down here in the South. I'm down here in Georgia, Joe. And we have like constitutional carry, and we're very pro 2A, right? And I almost wish that we weren't, because if we were not so pro 2A and pro constitutionality, then we too could have people who enter our house and clean it for us at night.
I know. It's the same way here in Texas. I can't get anybody to break in and do my laundry and fold it. If I lived in Minnesota, I'm sure I could get somebody like Nicole to come over at 4 a.m. and do that.
You're right. Maybe we need gun control.
We need to get some gun control down here so that we can have caring people break into people's homes to make their lives better. This is ridiculous. I wish we were more like Minnesota. I really, really, really don't.
I know. I'm going to start advocating for it. And, we could start with tampons in boys' bathrooms.
Okay, you're going too far. Let's hear what this guy's got to say, this criminal defense attorney, because we're kind of all we're going to see. Let's see what we can get an opinion from him.
That, though, for the defense standpoint, negate some of the things the prosecution have set up, just with again, we keep coming back to the multiple body cameras and what they show. Is all this stuff effective to negate what the jurors have seen on that video?
It shouldn't, I don't think, but it could, right? Because that's what jury nullification is all about here. I think it's arguing that this intent thing with 4 times to say why you're really there, and for Nicole to admit, I lied. I lied 4 different times, or didn't tell all the truth, whatever you want to put it at. So I think that really hurts her. But I think if I was the state, I would be conceding, Nicole is a nice person. She does a lot of great work in the world. Thank you for all of that. Those are all factors that are outside your decision-making process, jury, about what sentencing is all about. That's for a judge to decide. You simply decide guilt or innocence, or guilt or not guilty. You shouldn't say innocence, because that's just simply the state didn't prove the case.
With some time to fill, I know we queued up a little bit of the aunt from this morning. It's a couple minutes, maybe listen back.
Kind of a significant part of her testimony.
Yeah, I thought so. Kind of the relationship between.
There was no
again,
significance
this is
to
an
her
aunt, so
testimony,
her
but let's hear
brother
it again.
Rod, meaning Nicole's father, Carol's husband. Ryan, is that tape ready to go? And then Marsh, we can get your reaction. It's a couple minutes long. This is the aunt's soundbite from her testimony earlier this morning.
All right, let's play that now.
In your interview with our investigator, you gave a statement to the effect that Nicole Mitchell and Carol Mitchell's relationship has never been good. Do you recall saying that?
Yes.
Despite that, do you think Nicole Mitchell loved Carol Mitchell?
Yes.
Do you think Nicole Mitchell would ever want to hurt Carol Mitchell?
No.
Do you think Nicole Mitchell was trying to help Carol Mitchell after Rod Mitchell's death?
Yes.
You testified earlier that Rod Mitchell was your younger brother. Is that right? Or your brother? I'm sorry.
My older brother.
I'm sorry. Were you and Rod Mitchell close?
Yes, we were close.
Did you know Rod Mitchell well?
Oh, yes.
So yesterday, the prosecutor asked Nicole Mitchell a question on cross-examination that I want to pose to you. How do you think Rod Mitchell would feel about Nicole Mitchell breaking into his house?
Oh. He would, it's a 2-pointer. He would not be happy about it, but he would also not be happy if we all gave up on Carol and didn't check on her.
No further questions, Your Honor.
Mr. McDonald.
I wanted to play that sound bite for Marsh, because I know we talked about yesterday. You flagged that as sort of a bad question that the state had asked Nicole Mitchell on the stand yesterday, such an open-ended question about would her dad be proud or what would he think of what you did? And then there's the aunt, clearly the defense sort of, it's their case. They get the last chance to kind of respond, to bring it back up through another loved one. I'm just kind of wondering, as a lawyer, your reaction to how that little exchange played out there.
Like I said, that's a totally inappropriate question, in my opinion, for them to have asked yesterday.
Oh, right.
It's pure speculation. What do you think a dead person would be thinking now about what they're doing, right? That's just pure speculation. You can talk about facts, but you can't talk about the speculation. Now, but having said that, the defense attorney did a really smart thing there, because, again, this is partly about theater. It's what you're doing in front of a jury. One thing I learned in law school is trial is not an evidence class, right? It's, you want to win, you want to be a good guy, present a good story. So the point here is that when the defense attorney prefaced this question by saying, I'm going to ask you the same question the prosecutor asked you yesterday. By doing that, it prevents the prosecutor from objecting to the case as speculation. Because how can you say, that's an improper question? It's okay, I asked it yesterday, but now the defense can't ask it today. That would look really bad in front of the jury. So I thought the defense set up the positioning of that question really well.
That's true, because that question was allowed yesterday. I don't recall if the defense even tried to object to that one. Probably because they knew it would open the door for them to ask the same speculative question again today and turn it around.
Right. And again, this is a big chess match, right? So you're thinking about a piece in your board that you're going to move tomorrow. So that's kind of with this aunt coming in today. They waited to drop that hammer today.
Do you think there's room for another witness here from the defense? Where are we? I know it feels like we've buttoned this up, but I know they have a couple private investigators, a couple we don't exactly know their relationship, but seemingly more personal kind of character type witnesses. Do you feel that's it from the defense coming out of this break? Again, it would seem odd that they didn't, because if they come right back after this long break and then they rest, but maybe it is just to get into the closings. I don't know. I'm just thinking about optics for the jury. You know, what are we doing here likely, Marsh?
Yeah, I just, again, think of this as a sales presentation, right? That's what each side is doing. They're selling a position to a group of 12 people. And we get it. We've had enough people talk about she's a great lady and good heart and leader and millions of things she does. It's great. I just, unless it's something totally unrelated, I just don't get why we would do that.
Yeah, I've seen that in a case even recently where you come back from a break and they rest, you know, or and so you think, oh, we took a break, they didn't rest. And then you come back, whether it's a break or after lunch, and then they surprise you with they've rested. And you're like, why didn't you say that before? But part of it could be taking the time to make the decision whether or not they're done. So
it's also time management. I've seen that happen more than a few times.
To get in here that we needed to do, that's a big deal. There's something we forgot. I don't know how you get it in at this point unless you have a new witness, but that's just that. So when we go back in, first thing I want to see is if that podium is set up in front of the jury, because they're gonna say we rest, and assuming the state doesn't have a rebuttal witness or recalling somebody, the state's going to get up and start closing arguments. Again, remember, we have 3 of those. State goes, defense goes, state goes the second time.
I would imagine that typically closings might be a little bit longer than the opening statements. And again, it's closing arguments, opening statements. I mean, you state what you're going to present, and then at the end you argue to connect all the things that you presented together. Typically, they go a little bit longer than the opening statements, but I can't imagine that these would be, more than half an hour maybe each side. What do you think?
I think that's a good guess, because again, we're coming down to the word intent, right? We agree with all the other elements of the case. It simply was it an intent to commit a crime when you entered that property, right? Or is it possession of burglary tools, right? So there's a very narrow space of facts that are in dispute. So it's everything they can pile onto that issue, trying to convince the jury of their side of the case.
Yep, and then the jury would, we're assuming that we're getting to closing argument some point here in the next maybe hour or two, maybe, and then the jury gets the case this afternoon, and then it's always just a guess how long this might take. We've seen deliberations that take hours. We've seen deliberations that take...
It cannot take long. I'm telling you, if they're going to acquit her, it'll be fast. If they're going to convict her, I think it'll be fast. we'll have a decision today, I believe.
And the judge has to read all the jury instructions, which I will confess, when I was done with the trial, I'd be exhausted by the time we rested, did our closings. And you have to sit there and act like you're really interested during these instructions by the judge, which can get pretty dry sometimes. I mean, they're very important and crucial, but sometimes at that point it's hard. So depending on when we get to that, the court could say, go to lunch, come back, I'll read you your jury instructions and then go off and deliberate. Or they could get through everything and say, now go to lunch, and when you come back, you're on your own.
And Marsh, we spoke about it at the very beginning of our coverage this morning at 9 a.m. about this jury. I mean, they're not sequestered, so they would go home for the weekend wherever this case leaves off. We are being told by courthouse officials that the jury, should they get the case kind of later in the day, would be allowed to deliberate to perhaps even as late as 9 o'clock. What you know about juries, and I don't know if small town jury is any different than what would be the same here in the metro or not, but the idea that just human nature would be to probably want to put a bow on this by the weekend. I think it'd be hard for everybody to come back on Monday and still have to kind of get.
Yeah, they're just kind of blah, blah, blah. And I don't see a jury taking a long time on this case. The attorney here actually said something that's very true. There's only a narrow scope of things that are in disagreement, and that is the intent of breaking in the house. Both sides have said that. The only dispute is that did she break into the house to steal the pictures and flannel shirt, like she said, the time when it was fresh in her mind, or did she break in there to clean the litter box? And folks, I'm going to tell you, if that's what the jury has to decide on, nobody breaks in the house to clean someone's litter box. That just doesn't happen. And I think that she thinks she's clever when they ask, like, when you start going to the inventory of the bag. Okay, so why did you have this note in here? Well, I had that note to remind myself to make sure that the phone was taken care of, that the GPS was on. Even though it doesn't say GPS anywhere on that note, it really just talks about deleting text messages, deleting contacts, and connecting phone to a laptop. That's the only thing that says. But she's crafty enough, and you're not smart enough to understand that she's going to explain to you what that is. So she's doing some gymnastics to wave that one off. Then you go to, okay, well, what did you have the latex gloves in there for? And I'm going to give her that. It's like, oh, I did that so I could clean the litter box. You had enough wherewithal to take gloves so that you can clean this lady's litter box at 4 a.m. that you're breaking it. Nobody breaks in the house to clean your litter box and sneak out so that you don't know that they're there. That's the other thing. She wanted to do all this so that Carol was none the wiser, that she could do it and get out. And even her neighbors wouldn't have been able to tell her, like, oh, I saw Nicole's car here because it's parked down the street at 4 a.m. I don't think a jury can believe it. I don't think with a straight face, anybody sitting on that jury could vote not guilty on this. And I don't think that the defense has been successful to portray her as this kind-hearted caregiver at heart to give her a pass on breaking the law. Because essentially what you're saying is, like, if it was like passionate enough, heartwarming enough, or you were breaking the law for such a good crime, I mean, for a good cause, then a jury could, as he calls it, nullify. Jury could let you off. So, you know what? Yeah, maybe you did break the law, but I'm going to say not guilty anyway, because hell, I might have done the same thing. There's nobody sitting in that jury saying, yeah, break in and clean your litter box. I can see me doing that. Nobody can see this. I think it's ridiculous.
Well, Joe, on a serious note too, I mean, when she had that list of things to do to the phone, how many people do you allow to touch your phone?
I don't allow anyone, because you could access my financial information from my phone. You can access financial information from my computer. And I'll go back again, the two-part authentication, they're skipping over that. Actually, my 17-year-old daughter we were talking about that this morning, the case, and I got through the list of delete text messages connected to the phone, and I explained what the emails were, the emails for the medical portal and the emails from the bank saying that PIN numbers had been improperly inputted. And before I could get the story out, now she's 17, she understands computers better than maybe I do, but she said two-part authentication, and like done a little smacking thing with her lips and walked off. But she gets it. This woman wasn't there to turn her GPS on. She wanted that phone. And here's the thing. Why take the laptop with you that has the email account, that has Carol's information on it? Why take that back with you? And why connect it to the computer? Because connecting the computer is what she's talking about, is the two-part authentication, so that she can access her bank records and other things that she would require two-part authentication for. So nobody believes her story. And of course, no one is going to allow you to, I might let my daughter use my phone, or somebody that I trust, but not someone who breaks in my house. Hey, here's my phone. Hey, will you delete some text messages for me?
I've been with my husband for 17 years, and he's touched my phone one time. And I've never touched his. I mean, there's never a reason.
You don't know how many times he's gone in the middle of the night to help you out, and you didn't even know it. Probably cleans your litter box too. Didn't even know it.
I hope not. I don't have cats, and I'm not a furry.
He's probably breaking in neighbors' houses at 4 a.m. to clean some litter boxes, because that's what good people do, Fidgy. Good people. If you're a real good person, you're breaking into people's houses to check their expiration dates, to make sure their phone's up to date on all their apps, and to clean litter boxes. If you're not doing that, I mean, really, what are you doing with your life? What kind of person are you, really?
I think I might start a maid service where we don't come during the day or when you want us to.
You don't know.
So that it's more convenient. Yeah, we only break into your house at 4 o'clock in the morning.
You never know when we're going to be there. You're just going to wake up and your shit's done. Like, man, this is a great maid service. Making the bed's a little tough, but they can make it happen. It's insane. It's insane that they use this as a defense. And I think this attorney we're listening to here, he's being very political. He's giving a lot of credit to the defense side that I think doesn't exist. And I think the defense knows it. Otherwise, we wouldn't have seen any more witnesses this morning. If Nicole had been able to get on the stand and really lay it out there, pull on those emotional heartstrings and grab that jury, that's where the defense would have ended. But they didn't. They just kept calling witnesses till they had no more. They put Cupid doll on the stand there to talk about, I seen her once a month, and I trust my commanders when they lied to me. If they lied to me for the right reason, that's okay. Get out of here, man. What he looks like, right? That he's got that one bang that comes down 4 inches from the hairline. And the worst part of it, it's got like a flare at the end. So I'll go back again. Remember, that jury was sitting directly to his right. They see nothing but the profile of this man. And every one of them not hearing what he's saying, they're watching that. They're like, why would you do that? Just cut that off. Or comb it back, maybe. Why would you flare it up?
I hope he's not married, because if he is, his wife failed. That is part of our job, to make sure that y'all don't look stupid when you walk out the door.
He's not married. That's why Nicole, the one person he sees once a month that went to bat for him because of his personal situation, he was trying to rub up on that. He was trying to be. He had affection for Nicole. Otherwise, no other man in his right mind would sit up there and say the things that he said. Well, if my commander lied to me in the right context, then I would be okay with that. No one is okay with being lied to because you were scared. That's essentially what you're scared. So you lied. Oh, I'm cool with that. No, you're not. You're a coward.
Well, and every time you bring up lies, like a commander lying, I think, but we're okay with our politicians doing it.
Politicians are different. We don't expect a politician to. They don't have the. I'm not looking for morality out of them, but when it comes to being like a command, we're going to talk military. Yes, your candor is something. It's like one of the 9 leadership competencies is to speak with candor. That's truth and frankness. This is why you see this, especially in combat arms. You'll see guys that civilians think, oh, they're so harsh, so direct. No, we want to be that way because we get that information out quick. Just because it's bad news, me telling you how sorry I am doesn't make it less bad news. It's just wasting time. Here's the bad news. Now let's figure out what to do with it. But lying is never accepted. It's not accepted by a command. It's not accepted by subordinate soldiers or subordinate service members. It's conduct unbecoming. There's no context that you were scared enough that you lie. And here's the thing. She told a lie to save herself. She told the truth when she was on the scene. And most people believe that. Why'd you come here? And she thought it was minor. She didn't understand the law, even though she has a law degree. She thought it was minor. Well, it was just, what's a shirt cost? A used shirt, $5? some pictures of reproduction on pictures. What's the cost on those? Maybe another $5. We're talking about a $10 theft. It's minor. It's a misdemeanor. Now you do that $10 theft where you broke into someone's house. Ooh, that's a burglary. And she didn't realize that on the scene with her smart law degree, as she speaks of. Once she realized that was a burglary and her statements on scene were damning as hell, that's when she had to come up with, like, why'd you have latex gloves to clean the litter box? And I did. I know I said I went there to take shit, but I really didn't. I just went there to clean the litter box. The whole story's ridiculous. There's nothing believable. Okay, let's go back and see
where we stand.
I felt would be helpful to you in listening to and understanding the evidence presented. In these instructions, I will necessarily repeat and expand on those principles. Your function as a jury is to try the issues of fact presented by the charges filed in this court and the defendant's responding plea of not guilty to those charges. In performing that duty, you should not be influenced by sympathy for the defendant or by passion or prejudice against her. You must not allow yourselves to be prejudiced against the defendant because she has been arrested, or because criminal charges have been filed against her, or because she has been brought before this court and this jury to stand trial. None of those circumstances is evidence of her guilt. Do not infer or speculate from any or all of them that she is more likely to be guilty than not guilty. The verdict resulting from your deliberations must be based solely on the evidence produced in court during the trial and the law as stated in these instructions. Both the state and the defendant have a right to expect that you will conscientiously and dispassionately consider and weigh the evidence and apply the law, thus reaching a just verdict irrespective of the consequences of that verdict. You must consider these instructions as a whole and not single out any certain sentence or individual point or instruction. The order in which the instructions are given has no significance relating to their importance, and you should infer none. You will have a written copy of these instructions during your deliberations. I have not, by any ruling or expression during the trial, intended to indicate any opinion regarding the facts or the outcome of this case. If I have said or done anything, or if I should say in these instructions or do anything which would seem to indicate such an opinion, you are to disregard the same. The lawyers are officers of this court and have a duty to assist me in interpreting and applying the law, and to assist you, the jury, in determining the facts. They have performed that duty by presenting the evidence to you in an orderly manner, by examining and cross-examining the witnesses, by making such objections as they deem proper, and by presenting their client's cause fully and fairly. The lawyer's arguments are intended to help you understand the evidence and to apply the law, but neither the arguments nor other remarks of the lawyers are evidence in this case. If during the trial a lawyer or the court, for that matter, has made any statement about the evidence which does not coincide with your recollection of it, you should wholly disregard that remark and rely solely on your own recollection of the evidence. Likewise, you must disregard any statement by a lawyer about the law which differs from what my instructions are concerning the law. In regard to impeachment evidence, you may also consider evidence of a statement by or conduct of the witness on some prior occasion that is inconsistent with the present testimony. Evidence of any prior inconsistent statement or conduct should be considered only to test the believability and weight of the witness's testimony. In the case of the defendant, however, evidence of any statement she may have made may be considered by you for all purposes. It is the court's exclusive responsibility to give you the rules of law that apply to this case. You should follow the law as given in these instructions, even if you believe that the law is or ought to be different from what the court declares the law to be. You must apply the law as given in determining the facts and in reaching your verdict. That is the duty under the oath taken by you at the beginning of this trial. However, it is your exclusive duty as jurors to decide the disputed questions of fact. It is also your responsibility to determine what inferences or conclusions may be drawn from the facts as you find them to be. In performing your function as judges of the fact questions, you should consider all of the evidence that you have heard and observed here in the courtroom during this trial, and you must disregard anything about the case that you may have read or observed elsewhere. During your deliberations, you are not to consider any possible penalty that may be imposed due to your verdict. The court alone decides what is an appropriate sentence if the defendant is found guilty. The jury is only to determine whether the defendant is guilty or not guilty of the charges against her. You are the sole judges of the truthfulness and the credibility of the witnesses. You are the sole judges of the weight to be given to the testimony of the witnesses and the other evidence received in this case. We all have feelings, assumptions, perceptions, fears, and stereotypes about others. We have some biases we are aware of, and others we might not fully be aware of, which is why they are called implicit or unconscious biases. No matter how unbiased we think we are, our brains are hardwired to make unconscious decisions. We look at others and filter what they say through the lens of our own personal experience and background. Because we all do this, we often see life and evaluate evidence in a way that tends to favor people who are like ourselves or who have had life experiences like our own. We also have biases about people like ourselves. Bias can affect our thoughts, how we remember what we see and hear, whom we believe or disbelieve, and how we make important decisions. As jurors, you are being asked to make an important decision in this case. You must, number one, take the time you need to reflect carefully and thoughtfully about the evidence. Number two, think about why you are making the decision you are making and examine it for bias. Reconsider your first impressions of the people and the evidence in this case. If the people involved in this case were from different backgrounds, for example, richer or poorer, more or less educated, older or younger, or of a different gender or gender identity, race, religion, or sexual orientation, would you still view them and the evidence the same way? Number three, listen to one another, resist and help each other resist any urge to reach a verdict influenced by bias. Each of you have different backgrounds and will be viewing this case considering your own insights, assumptions, and biases. Listening to different perspectives may help you better identify the possible effects these hidden biases may have on decision making. Number four, resist jumping to conclusions based on personal likes or dislikes, generalizations, gut feelings, prejudices, sympathies, stereotypes, or other unconscious biases. The law demands that you make a fair decision based solely on the evidence. Your individual evaluation of that evidence, your reason and common sense, and these instructions. One final instruction before considering the particular law that applies to this case. Our system of justice is structured on two very basic and fundamental concepts. They are applied in every criminal case, and it is your duty to apply them in this case in determining your verdict. They are the presumption of innocence and proof of guilt beyond a reasonable doubt. The defendant is presumed to be innocent unless the contrary is proved. That presumption continues throughout the trial. The defendant is not required to prove her innocence. The burden of proof rests upon the state to establish the guilt of the defendant beyond a reasonable doubt. Proof beyond a reasonable doubt is not established merely by the greater number of the state's witnesses or the greater volume of the state's testimony. Proof beyond a reasonable doubt is such proof as ordinarily prudent men and women would act upon in their most important affairs. A reasonable doubt is a doubt based upon reason and common sense. It does not mean a fanciful or capricious doubt, nor does it mean beyond all possibility of doubt. It does not mean that the defendant's guilt must be proved to an absolute or mathematical degree of certainty. In order for you to properly understand the evidence, I will identify for you the essential elements of the crimes for which the defendant stands accused. Count 1, burglary in the first degree, occupied dwelling. It defined, under Minnesota law, whoever enters or remains in a building without consent and with intent to commit a crime, or enters or remains in a building without consent and commits a crime while in the building, is guilty of a crime if the building is a dwelling and another person, not an accomplice, is present in it. Elements. The elements of this crime are, first, the defendant entered or remained in a building without the consent of a person in lawful possession. A person is in lawful possession when the person has a legal right to exercise control over the building. Such a person is in lawful possession of the building even if the person is not physically present at the time of the entry. The entry need not have been made by force or by breaking in. Entry through an open or unlocked door or window is sufficient. Second, the building is a dwelling. Dwelling means a structure suitable for affording shelter for human beings that is used as a permanent or temporary residence. Third, another person, not an accomplice, was present in the dwelling when the defendant entered it or at any time when the defendant was in the dwelling. Accomplice means a person who intentionally aids, advises, hires, counsels, conspires with, or otherwise procures another person to commit a crime. Fourth, the defendant entered or remained in the dwelling with intent to commit the crime of theft. With intent to means that the defendant either had a purpose to do the thing or cause the result specified, or believed that the act, if successful, would cause that result. Theft means that the defendant intentionally and without claim of right took, used, transferred, concealed, or retained possession of movable property of another person without the other person's consent and with the intent to permanently deprive the owner of possession of the property. The elements of theft are, first, the defendant intentionally took, used, transferred, concealed, or retained the property. Intentionally means that the defendant either had a purpose to do the thing or cause the result specified, or believed that the act performed by the defendant, if successful, would cause that result. In addition, the defendant must have knowledge of those facts that are necessary to make the defendant's conduct criminal and that are set forth after the word intentionally. Second, the property was movable property. Movable property is property whose physical location can be changed. Third, the property was the property of Carol Lynn Mitchell. Fourth, the defendant knew or believed that she had no right to take the property. Fifth, Carol Lynn Mitchell did not consent to the defendant's taking, using, transferring, concealing, or retaining the property. Sixth, the defendant had a purpose to deprive the owner permanently of possession of the property or believed the act, if successful, would deprive the owner permanently of possession. It is not necessary that she intended, or it is not necessary the intended crime was actually completed or attempted, but it is necessary that the defendant had the intent to commit that crime at the time the defendant entered or remained in the dwelling. Whether the crime was intended must be determined from all the circumstances, including the manner and time of entry or remaining in the dwelling, the nature of the dwelling and its contents, any items the defendant may have had in possession, and all of the other evidence in this case. Fifth, the defendant's act took place on or about April 22nd, 2024 in Becker County. If you find that each of these elements has been proven beyond a reasonable doubt, the defendant is guilty. If you find that any element has not been proven beyond a reasonable doubt, the defendant is not guilty. Count 2, possession of burglary or theft tools. Defined, under Minnesota law, whoever has in the person's possession any device or other instrumentality with intent to use or permit the use of the item to commit burglary or theft is guilty of a crime. elements. The elements of this crime are, first, the defendant had in her possession a device or other instrumentality. The law recognizes two kinds of possession: actual possession and constructive possession. A person is in actual possession of an item if the person has the item on the person or is exercising direct physical control over the item at a given time. A person is in constructive possession of an item if the item was in a place under the person's exclusive control to which other people did not normally have access, or if found in a place to which others had access, the person knowingly exercised dominion and control over the item. Possession, as that term is used in these instructions, has been proven if you find beyond a reasonable doubt that the defendant had actual or constructive possession. Second, the defendant had the intent to use the device or other instrumentality to commit burglary or theft. The crime of burglary is committed when a person enters or remains in a building without consent with intent to commit a crime, or enters or remains in a building without consent and commits a crime while in the building. Intent to means that the defendant either had a purpose to do the thing or cause the result specified, or believed that the act, if successful, would cause that result. It is not necessary that the defendant had a particular building in mind, so long as the defendant intended to use the item possessed to gain access to a building or to property within it. In determining the defendant's intent, you may consider all the circumstances, the nature and character of the device or other instrumentality, the manner in which it was kept, the quantity in the defendant's possession, the time and place of the defendant's possession, and all of the other evidence in this case. The crime of theft is committed when a person intentionally and without claim of right takes, uses, transfers, conceals, or retains possession of movable property of another without the other person's consent and with intent to deprive the owner permanently of possession of the property. Intent to means that the defendant either had a purpose to do the thing or cause the result specified, or believed that the act, if successful, would cause that result. It is not necessary that the defendant had a particular theft in mind, so long as the defendant intended to use the item possessed to commit the theft. Third, the defendant's act took place on or about April 22nd, 2024 in Becker County. If you find that each of these elements have been proven beyond a reasonable doubt, the defendant is guilty. If you find that any element has not been proven beyond a reasonable doubt, the defendant is not guilty. During your deliberations, you will have physical exhibits that were received into evidence with you in the jury room. You will also have dedicated equipment and an access code to review the digital exhibits. Do not hesitate to send out a note asking for help if you have any technical problems reviewing digital exhibits. Ladies and gentlemen, you also have 2 verdict forms, actually 4, 2 relating to each count. And they're read in no particular order, but they have a title on the top that says State of Minnesota, County of Becker, in District Court, 7th Judicial District, State of Minnesota Plaintiff versus Nicole Lynn Mitchell Defendant. In the far right column, it carries the court file number. And then the first reads, verdict of not guilty as to count 1. We, the jury, find the defendant, Nicole Lynn Mitchell, not guilty of the charge of burglary in the first degree. There's a section there for the foreperson to sign and date. It says City of Detroit Lakes, Minnesota. As to count 1, the second verdict form again has the same heading. State of Minnesota, County of Becker, District Court, 7th Judicial District, State of Minnesota Plaintiff versus Nicole Lynn Mitchell Defendant, has the court file number, and it says and reads verdict of guilty as to count 1. We, the jury, find the defendant, Nicole Lynn Mitchell, guilty of the charge of burglary in the first degree. Has a section for the foreperson to sign or a line to date and says City of Detroit Lakes, Minnesota. Count 2, as to the 2 verdict forms, has the same heading as all others. And it reads verdict of guilty as to count 2. We, the jury, find the defendant, Nicole Lynn Mitchell, guilty of the charge of possession of burglary or theft tools. And then there's a section for the foreperson to sign and date, City of Detroit Lakes, Minnesota. The second verdict form as to count 2 is the same heading that I previously read to you, and it reads verdict of not guilty as to count 2. We, the jury, find the defendant, Nicole Lynn Mitchell, not guilty of the charge of possession of burglary or theft tools. Again, a line for the foreperson to sign and to date. All right. You'll have the verdict forms in the jury room. As I mentioned, after you've arrived at your decision, the verdict form for the defendant reflecting that decision should be completed and signed by your foreperson. You should then notify the bailiff that you've arrived at a decision. In order for you to return a verdict, whether guilty or not guilty, each juror must agree with that verdict, meaning your verdict must be unanimous. You should discuss the case with one another and deliberate with the view to reaching an agreement, if you can do so without violence to your individual judgment. You should decide the case for yourself, but only after you have discussed the case with your fellow jurors and have carefully considered their views. You should not hesitate to re-examine your view and change your opinion if you become convinced it is erroneous. But you should not surrender your honest opinion simply because other jurors disagree or merely in order to reach a verdict. Counsel, do either of you wish to call to the court's attention any errors or omissions or corrections to the charges?
No, Your Honor.
No, Your Honor. All right. And Mr. McDonald, are you prepared for your closing?
Yes, Your Honor.
All right. You may do so.
Yeah, that's prosecutor.
This should be good.
May it please the court?
It pleases. Let's go.
I know I did something bad. Or rather, the defendant knew she did something bad, but now she wants to lie about it. The defendant is a doer, a person who takes charge and gets things done, a senator and a military commander, for God's sakes. When Carol Mitchell buried the defendant's father's ashes, knowing the defendant couldn't attend, a line was drawn in the sand. The defendant did not communicate with Carol Mitchell from that date forward. On the evening of April 21st, the defendant couldn't sleep, and she was ready to take action. She wanted to take back whatever was left of her father's possessions. Getting these items back became her mission. Sometime around midnight, the defendant planned, packed, and dressed for her mission. She put on her best black ninja suit, threw in her pry bar, her muted flashlight, and even her special pair of flashlight gloves. She drove 220 miles to Detroit Lakes. Not even her own moral compass could deter her from her mission. Mr. Ringstrom summarized the issue for you to start this case. The defendant either entered to steal something, or the defendant entered to check on Carol Mitchell. The three things I asked you at the start of this case will lead you to the truth. Trust your eyes and ears. Do not get distracted. Use your common sense and good judgment. If you do these three things, you can be confident in a decision to convict the defendant. Now, during her testimony, the defendant admitted She said things to, quote, save her own skin. She also testified that sometimes you have to lie to protect people. And yesterday, you saw a fine example of that. Her testimony yesterday was carefully crafted to protect the one person that she cares the most about in this case, herself. Now, there is no doubt this began as a tragic family situation. Rod Mitchell's sudden passing was shocking and an ignition point to an already delicate relationship between the defendant and Carol Mitchell. Sadly, Carol Mitchell's Alzheimer's either slowed or hindered the turning over of Rod Mitchell's priceless mementos that the defendant wanted. However, disputes are settled in court now with crowbars, ladies and gentlemen. Remember, Carol Mitchell is not on trial here. The defendant and the defendant alone is on trial. And now is the time for you to decide the facts. And as tragic as this family situation has played out and how the defendant has handled it horribly, remember that you are not to be influenced by sympathy for her when you make your decision. I'd like to take a moment and walk through the elements and show you how the state has satisfied its burden to each count. Count 1, burglary, the first element. The defendant entered or remained in a building without consent. The defendant admitted that on the stand. She said, I didn't have consent. You can also consider her mode and manner of entry, the early time of the morning. Second element, the building was a dwelling. It's not in dispute here. It's been proven it was Carol Mitchell's residence, 709 Granger Road. Third, another person, not an accomplice, was present in the dwelling. Seen a plethora of body cam footage. You know Carol Mitchell was inside the residence that morning. Defendant admitted that element as well. The fourth element, the defendant entered or remained in the building, dwelling with intent to commit the crime of theft. It's the meat and potatoes of the case. Circle back to it. The last element, that this occurred on April 22nd, 2024. Admitted by the defendant, all sorts of evidence to that effect. Count 2, burglary tools. The defendant had in her possession a device or other instrumentality. You heard her testimony yesterday. She packed up that pry bar before she left Woodbury. Told you how she used it to pry open the egress window. Again, the second element, the defendant had the intent to use the device, the meat and the potatoes of the case. Circle back to it. And again, April 22nd, 2024. So with that, ladies and gentlemen, I'd like to talk to you about the many lies of Nicole Mitchell. You've all had to deal with people lying to you in your life. In order to catch people in lies, you have to focus on the little details. And when you do that, their stories begin to crumble. First, her overall claim of love and concern for Carol Mitchell. Enduring love and concern. Her aunts, the people that she trusted the most, how did they characterize this relationship? Well, Nancy Lund said they never had a stellar relationship. Cindy Markey said they never got along from day one. Two strong-willed women. It's your reason and common sense tell you, ladies and gentlemen. Second, the medical data. The defendant hacked into Carol Mitchell's My Sanford chart on the evening of April 20th. Never mind the fact that she was not authorized to view Carol Mitchell's private medical data, but whatever she saw was so concerning, so disturbing, that she waited over 24 hours to pack up her quote, welfare kit, and she told nobody. Third, the defense has repeatedly classified this as a welfare check. Now you've seen all the evidence, the time of night, the outfit, the tools. What does your reason and common sense tell you? Again, she was so concerned for Carol Mitchell that early morning, she did not call or inform anybody. Did not call law enforcement, did not ask for a welfare check. And remember, she had not communicated with Carol Mitchell since that fight on or about March 15th. And their last text exchange was a nasty one. Fourth, defendant testified that the neighbors knew her so well, she had to park on that side street. She couldn't risk being spotted. Didn't want them to notice her. Cross-examination, forgot their names. Don't know them. Fifth, flashlight gloves. Something probably never seen before in your life. Now, the defendant never really offered an explanation why those were in her welfare check toolkit. She just merely said they were bought for camping. Oops. Forgot to explain that one. 6, why latex gloves were packed with her. She testified that she wasn't sure what she would find. Implied maybe that she was worried about cleaning up feces. Does that make any sense? Did she pack any bleach, any paper towels? The defendant over-explaining things is a classic example of her lies. 7, her explanation of why she had to use the basement window. She testified, I had a key. I looked through the window and I saw the door jam device. But yet, she told you she packed that pry bar before she left Woodbury. Who packs a freaking pry bar? Just in case. Reason, common sense. 8, the defendant testified that she, quote, has a key for this house. There's no key that's been offered into evidence. The only proof of the defendant having a key is her testimony. This is convenient testimony by an admitted liar, ladies and gentlemen. Do not buy it. 9, flashlight had a sock on it. It was my child's. Continue to over-explain. You can check. I think his name is on it. Ladies and gentlemen, you can check when you deliberate. You can examine that flashlight. I couldn't find a name, but if you can. 10, defendant claims she was never lying next to Carol Mitchell's bed. Ms. Schotterhoff, can I have? I'd like to replay the 911 audio for you, ladies and gentlemen.
Somebody just broke into my house. Ran down into my basement.
What's your address?
709 Granger Avenue.
Granger Road in DL?
Granger Road. Yeah.
Becker 30 car for Activeburg, Granger. 3746 individual broke into their house and ran down in their basement, 709 Granger Road.
I don't know if he's breaking out the back window or what.
Did you get a look at him at all?
No, it was completely dark. I tripped over him. He was on the floor next to my bed. He ran downstairs into my basement.
Okay. Did you hear him breaking out the window in the basement?
I'm not hearing anything right now.
Okay. What, did it sound like he was breaking something?
I don't know. Maybe the window's already open down there. There's a basement, a drop window that can crank open. I don't know. here.
All right, I'll stay on the line with you. Don't worry. I have officers en route right now. If you hear anything, just let me know what's going on, okay? Are you armed?
Oh, I have a little steak knife in my hand right now.
Steak knife? Okay. All right.
I don't know where they could have. I don't see any, my yard lights haven't come on outside or anything, you know, the motion light in the back or anything.
Did you notice any vehicles or anything like that?
No, I haven't.
So it sounded like this individual broke in. RP got up and almost tripped over whoever's lying down inside the house before they ran into the basement. Okay, am I speaking with Carol?
Yes. I don't know what the hell's going on. Oh my God.
Did you hear anything at all?
No.
There's a drop window. She doesn't know if he got it open yet or not.
On the back side of the house, yeah.
What's that?
On the back side of the house, yes.
Okay.
I just turned the small light on in my backyard and I'm trying to look out over that window. And
Did you hear or see any vehicles drive away?
no, I haven't. I just heard something in the wind downstairs now.
Female police, she's murdered.
Okay.
She believes she heard something else in the basement.
Is that police?
There's officers that just came outside your residence, yeah. You just came in.
Okay. Hold on 1 second. Janet, here. There's a shop window in the back side of the house, and I don't know if he ran down there.
Okay, I'll go down there. You stay back here. All right, Carol. You can.
Should I hang up?
Yep, you can hang up.
Okay. Thank you.
Yep.
Then, ladies and gentlemen, a few days later, Chief Todd returned to Carol Mitchell's home.
Was in your bed was just leaves and dirt. So,
While we're up here, could you show us your bedroom and where the person was that you stepped on?
yeah. It's down there. She was laying right here with her head.
Let me get up here with my body camera so you can describe it. Okay?
Okay, I sleep here.
Yep.
And she was laying right here. Her head was at that end and her feet at this.
Okay. Is there anything that you keep?
3 drawers under there, but there's
What do you keep in those drawers?
socks, underwear.
Okay.
You know, I checked to see if there was any. This is just an empty box. I was checking to make sure that's just, you know.
Okay, just
But I did keep, for a long time, I kept my pistol.
Okay.
And I'm sure.
So what, you leaned up, you stepped out of bed, and you actually.
Something woke me, and I sleep with earplugs.
Mm-hmm.
So I couldn't figure out what it was that woke me.
Yep.
If it was a loud sound, or if what. So I just. What was that? And I stepped on, and I stepped on a body, and it moved.
Yeah.
And I went, what the hell? And I jumped on like this and grabbed, because I thought it was like a little kid. or something. I didn't think it. And then when it was bigger, well, at first I thought, a man had broken, but it was too small for a big man. So then I thought it was a little boy or some teenager got in or something. And then she shot out, ran out down the hall through the kitchen and down into the basement.
Okay. I'll follow you now. Thank you.
Basement?
So, and you definitely saw this person hang a left and go down?
I was right behind her. And I still thought it was a boy. I never, until you guys told me it was Nicole, I didn't know. Okay.
Carol Mitchell might be battling Alzheimer's, but this event will be something forever etched in her mind. She told the 911 dispatcher she stepped on a body. She told it again to Chief Todd. Again, it's the little things that prove lies. Then, ladies and gentlemen, we come to the testimony yesterday that she lied to the officers 4 times because she didn't want to upset Carol. Yet, we've heard from 2 defense witnesses, Nancy Lund, honest, trustworthy. Jay Brody talked about her raving reviews as a commander, her honesty, trustworthy. Then we look at the context of the defendant's testimony yesterday. She said she was very stressed out, never had a gun pointed at me before. Yet she wants you to believe that she was capable of this quick lie, this plan, because she didn't want to upset Carol Mitchell. I encourage you to review the defendant's demeanor on the body camera footage. I submit to you she was telling the truth on April 22nd, 2024. And if you believe that she was telling the truth to the officers, then you know she had the intent to steal. She told you. She told the officers. Again, maintain number 12. She maintained that the lies to the police were so she didn't upset Carol Mitchell. But yet you look at her statements, many of them are after she separated from Carol Mitchell. Back of the squad and at the jail. Then, ladies and gentlemen, number 13, we turn to the defendant's elaborate story of what she did in the house. Remember all the things she checked on, the important kitty litter box and deep freeze inspections that justified this home break-in? I'm going to play Officer Wolfie's body cam for you at about the 21:35 mark.
What's your name? Are those laptops in your backpack yours?
Yes.
Okay. She's saying she's missing 2 laptops.
I can show you one. It's got like this Minecraft game on it.
What's the other one for?
I have one for work.
Okay. And then she's saying something about inbox. That was a question. It was in question last time. So.
I literally had just got in the house. I hadn't had time to do anything.
Okay. All right.
I'm clearly not good at this, but
yeah. So, sounds good.
Again, she
Hadn't had time to do anything. Again, another classic over explanation. Item 14, regarding the checklist in her backpack. She testified that delete texts and contacts actually means that she wants to make sure Carol didn't delete people from her phone. That's her checklist, her shorthand. Another over explanation. What does your reason and common sense tell you? I'd like to circle back to the most important issue here, the defendant's claim that she was lying to the officers on April 22nd. Ladies and gentlemen, don't forget She's had 15 months to think about this and prepare for her testimony yesterday, to craft her story around the evidence. Officer Sternhagen is a highly trained officer, and I submit to you, he would have noted deception by the defendant. Defendant's spontaneous and truthful statements to law enforcement on April 22nd, 2024 are extremely damning to her. So yesterday she had to come up with a story. What the defendant said in those tense moments after being detained by the police is the truth, period. She said she was there to take items, and that readily proves her intent to commit a theft. I ask that you find her guilty. Thank you.
Mr. Ringstrom?
Thank you, Your Honor. What they say is related to the context of the situation. So Mr. Brody testified to this morning. When we search our own consciences, when we know that we are fundamentally honest people, we all know that we have told white lies. Nicole Mitchell, a month ago, told a white lie to her children because something terrifying happened, and she did not want to terrify her children. Does that call her character into question? The thing that she said to those kids was not true, but she said it because if she had told them the truth, it would have caused a trauma that few children would ever experience. At the beginning of this case, before opening statements, when we were asking you questions to determine who would sit in this jury, one of you being questioned was asked about Alzheimer's patients. And she told us, and she told you, in her experience, that sometimes you say things that aren't true so that you don't aggravate the situation. We all know the difference between a white lie and a meaningful, damaging one. The problem is that this happened in the context of something that was a terrible mess. A mess that Nicole made, but it was a mess. And the state wants you to fixate on that because the actual evidence in this case is contrary to what they want you to believe that those white lies were about. And let's really think about what the state absolutely needs you to believe. The state needs you to believe that Nicole Mitchell, a person who has spent 30 years in the military, a legislator, a mom, a lawyer, and a daughter herself to two separate moms, each with Alzheimer's, would drive 3 hours to take a shirt that had already been promised to her, that she would throw away her entire life for some things she knew she was going to get anyway. If somebody believes she was there to steal, she never would have left the basement. That's where Rod's things were. If somebody believes she was there to steal,
she never would have gone upstairs. Going upstairs means welfare check. The state can't have it both ways. The moment you understand the real reason she was there, the welfare check, Nicole's white lies make perfect sense. And the state has focused on things that are not relevant to the accusations in the instructions. That Nicole Mitchell exercised poor judgment about how she did the welfare check. She told you as much. That's not a crime. The state wants you to feel bothered by that and create the illusion that somehow that's a reason to convict her of these crimes. She's not charged with lying. Once Rod Mitchell died, no one else on the planet knew Carol Mitchell truly better than Nicole Mitchell did. And she knew that Carol was deleting texts and isolating herself from people who cared for her. I resent, and I think you should too, that some of the testimony about how Carol and Nicole Mitchell had an acrimonious relationship somehow means they don't love each other. Has anyone had an acrimonious relationship with someone they love? Is that really beyond reason and common sense? I suspect if you on the jury are like most of the rest of us here, most of your most acrimonious relationships are with people you care about and people you love. It's because the love binds us, and sometimes we don't get along. So what? One thing that is often true about a prosecutor's case, when they don't have the right facts, they will misstate the law and ignore the facts that create reasonable doubt. The state told you to use your common sense. The expression common sense is in the instructions the court gave you. But the standard is reason and common sense. If we use pure reason, we look like logic robots and we can make silly mistakes. If we use pure common sense, we activate our biases. The other set of instructions that you were told you about. You must use both if you are faithful to the instructions the court gave you. Do not let the state deceive you from that. Sergeant Glander testified that you cannot ascertain a person's intent from damage to the window. He agreed that a point of entry of the window could be consistent with other things, trespassing or damage to the property. You can't ascertain a person's intent from that. Now, there was testimony from 2, possibly 3 state's witnesses, law enforcement officers, about the mistakes that they made in the investigation. And the implication was that everybody in this case is to get grace except for Nicole Mitchell. It's okay that law enforcement makes mistakes. We are fallible human beings. It's not okay if those mistakes cut against the citizen accused. And let's be really, really clear about this. There is only one side being tested here. There is only one case here. It is the state's case. And there is something that criminal defense attorneys who protect people's rights are always afraid of. That when they call witnesses, which we don't always do, that it creates the illusion in the minds of the jury that there's a case here and a case there, and that we have to prove something. We have to prove nothing. every piece of evidence that we brought up, whether it was through cross-examination, which is evidence, whether it was calling witnesses, whether it was introducing an exhibit, is solely to do one thing, to point out the reasonable doubts in the state's case. There is only one case here. That is what you are here to evaluate. The state decides what charges to bring. They decide what tests they're going to take. It is such an important test that the standard is extremely high. And the way they have to pass the test is by meeting the standards imposed by multiple parties. The court obviously has a special role, and you will get a copy of the instructions. These show the exact standards that the state has to meet to pass this test. The defense is tasked with pointing out every single mistake that the state made. And the jury is tasked with judging every single piece of evidence, deciding what weight to assign to every single piece of that evidence, including no weight at all if the jury decides that. Looking at every single reasonable doubt that the defense points out and finding reasonable doubts on their own. The fact that I may not talk about a reasonable doubt here doesn't mean it doesn't exist. You get to investigate and find your own. And that is part of your professional charge here. That is professional. It's part of your obligation here to find those reasonable doubts. What has the state spent the most time trying to prove? That Nicole Mitchell came up in the middle of the night. That she wore dark clothing and a black cap. That she parked on a side street. And that she came in through a window. That's the how, which we know and basically everybody agrees on. But the state has, in my estimation, pretty shamefully tried to convince you that the why doesn't matter, that the intent can be ignored. But the intent is everything. Now, before I get into an argument, my argument for you, we're going to talk about some of the reasonable doubts that are clear. Carol Mitchell is clearly and obviously struggling with Alzheimer's. It would be an act of unkindness and unhelpful to go through it in any aggressive way. It was clear from the beginning. It was clear based on what Jonathan Keel said that Rod's death really set it off. But I want to talk about a few of them to make sure that we remember that this really is a problem, that this really was something that Carol's struggling with. And some of them are little. Carol says it's a lavender pry bar. It's very big, but of course in reality, it was much smaller and blue. I had never seen that before in a trial in my career. This woman who's doing the best she could literally says that's not the crowbar. Carol testified to you that Rod Mitchell died in 1993. That is the kind of mistake, literally a generation apart in terms of when he passed, that attests to the deterioration. Nicole Mitchell was not added as a contact in Carol Mitchell's phone until March 10th, 2024. This is exactly what Nicole Mitchell feared. That Carol Mitchell deleted texts and deleted contacts on her phone. We know this for a fact. Right? There's text messages introduced that show they had communication. Special Agent Vic Mark testified that when he looked at Carol's phone, there were no text messages between Carol and Nicole. It's just patently mistaken. We know that they were there. And this raises a mistake, a scary mistake, a mistake that endangers Nicole Mitchell's future, that they did not extract that phone. Special Agent Vic Mark testified that he had Carol Mitchell's phone, that he didn't do an extraction. He never even testified whether he asked her if he could do that. So we don't know all the exchanges. We don't know whether she'd been scammed. What we do know is what Nicole Mitchell experienced through her exchanges with Carol Mitchell, through her exchanges with people that are close to her. And the evidence has shown that nobody is actually deeply taking care of Carol Mitchell. It is poignant to me that if you were to talk to Carol Mitchell and you didn't know her and talk to her for a minute or two, she would seem like a completely put together human being. That it takes time to see the breakdown. It takes time to see the forgetfulness. Pam Muxfeld wasn't really taking care of her. Pam Muxfeld didn't see it as a big deal when Nicole contacted her. Pam Muxfeld testified to you that in her estimation, it wasn't quite what other people thought. Jonathan Keel hadn't taken her to medical appointments. He lives in the cities. Mr. Jim Headland, the friend of the late Rod Mitchell, he had made a commitment, a promise to help her, but it was clear from his memory, from his abilities, he wasn't in a position to genuinely help her. Dee Lindholm, Pam Muxfeld testified that her mom, Dee Lindholm, was too old to be power of attorney, much less manage someone else who was struggling with Alzheimer's. And certainly not her neighbors or friends. I made a duty for someone who's a neighbor or a friend to take up for someone. Another reasonable doubt is that Nicole clearly believed in her heart that Carol was struggling. We have seen this evidence. We have seen that no one was stepping up for her. It is a misrepresentation by the state. He misrepresented it in his cross-examination of Ms. Mitchell yesterday. And I submit that he misrepresented it in his closing today. That Nicole didn't express concern about Carol Mitchell's paranoia or Alzheimer's when she was in custody for that period of time. Nicole Mitchell does tell Officer Sternhagen about Carol's paranoia. Nicole Mitchell does bring up Alzheimer's repeatedly. It does come up. We expect state witnesses to tell the truth and to tell the whole truth. And it is problematic when every single law enforcement officer who testified on direct did not admit that Nicole Mitchell had none of Rod or Carol's belongings until after I asked them that question. That is a fact that should have been readily presented to you straight away. It should not have been hidden from you. Nicole Mitchell didn't have any of these possessions And I ask you, when you go back and you're deliberating and talking, these other things about a laptop, which we know had nothing to do with this. The bobber, which wasn't there, had already been sent to Nicole. These other things, they're not part of it. But Nicole Mitchell didn't have any of these things. Every law enforcement officer asked said, well, one, they were all reluctant to testify about it. I didn't see this, I didn't see that. There were no piles of items or mementos staged by these windows. There was no bag of anything. And there were certainly none of these things in Nicole Mitchell's backpack. You just keep coming back to the basement. That's where Rod's stuff is. Why on earth, if somebody intends to steal something, would they not just do it and leave? The state needs you to ignore that. Nicole Mitchell says, I'm clearly not very good at this. Clearly, she's not. She failed to help to get Carol the help that she needs. If Nicole Mitchell had been good at this, she would have been able to take pictures. She would have been able to document things, make good notes. She would be able to make sure that Carol Mitchell's location was known to the other people who actually lived in the area. So at least that they would have been on notice. We know Nicole Mitchell wasn't good at this because Carol doesn't understand what's going on, and no one is fully helping her to this day. When Carol Mitchell testified, she was being asked very simple questions, very easy questions. You may recall she was searching through the courtroom for answers, and the judge did have to remind her she wasn't able to do that. She's not getting the help she needs. The note that the state lost, but fortunately was preserved in a flash on a body camera. The note shows what Nicole Mitchell intended to do, and it shows that she was right. Checking for deleted texts, she was right. And nothing on that note says anything about the state's claims of intent. Can you imagine if that note had said, go find a shirt, go find mementos? Good Lord, that would be the whole case. The note shows Nicole Mitchell's intent to go check on Carol Mitchell. And in the context of all this relationship, this strained relationship, her love for her stepmom, a love for her stepmom that was different than the love for her own biological mom. She was also loyal to Carol Mitchell because Carol loved Rod, Rod loved Nicole, Nicole loved Rod. It was entangled. She was loyal to her dad and by extension loyal to Carol, above and beyond her loyalty to Carol Mitchell. Jonathan Keel really seemed to struggle to testify about a lot of things. He actually didn't remember a conversation he had had just a few weeks before with an investigator. I mean, a few weeks before this trial. But he did tell Sergeant Glander, and Sergeant Glander put in his report, there was never a disagreement and that Carol had been holding items of Rod's for Nicole and her boys, knowing that they would want those items. So let's think about the only item that really seems to be at issue here. The flannel shirt. The flannel shirt was hanging all by itself. The flannel shirt was hanging by itself with a bunch of other clothes. The flannel shirt had not been taken off. It hadn't been crumpled up. It hadn't been put in a bag. It hadn't been put by a window. It was hanging there. Nicole Mitchell had wanted that shirt. That would have been a pretty easy thing. She turned the lights on. She went to the house, used the bathroom, and turned the lights on. It would have been so easy to take this shirt, and it wasn't touched. When we think about intent, let's think about the facts. There's an expression in the military that we don't rise to the circumstances. We fall to the level of our training. That's why the more specialized someone in the military is, the more training they need, because when things get crazy, you've got to be able to think clearly. Nicole Mitchell intended to check on Carol Mitchell, and of course, everything exploded. And it was her fault that it exploded, but it exploded. And law enforcement was right to deploy their firearms. But that doesn't change the fact that that's a traumatic experience. When Correction Officer Eric Scott testified, he said that Nicole Mitchell at the jail, so this is like 40 minutes later, did not seem to be intentionally uncooperative, but more seemed to be able to not be able to focus on the directives given her. This is a surreal experience for Nicole Mitchell. We can blame her for causing the circumstances. It is surreal. The state's really fixated on this finger flashlight. I've always thought of it as a silly thing. It's not a flashlight I would want to buy, but I talk to people and they think it's a perfectly good idea. She said she had it for camping. And importantly, it is absolutely in evidence it was purchased before Rod Mitchell died, like February of 2023. So we're literally talking about a year and 2 months before this incident. So it looks fancy, it looks weird, it looks specialized. It's just a thing she had. She brought 2 flashlights. She brought this flashlight. She brought this flashlight that has a sock on it that's held there by a rubber band. This is not my exhibit. I've never been able to touch this flashlight. But Mr. McDonald invited you to look for her son's name under the sock. It's his exhibit. Do it. Do it. As we talked about, it is okay that law enforcement make mistakes sometimes, but it's not okay to hold those mistakes against the citizen accused, against Nicole Mitchell. The state didn't secure the backpack. They didn't secure the keys. They didn't secure the note. The state wants to hold it against the citizen accused who can't execute search warrants, who can't seize things, who can't find records using government power, that she doesn't have these things. It is the state's responsibility to preserve evidence. We talked about this a little bit, but let's really go through it. In the 37 minutes between when Nicole Mitchell has law enforcement contact and when she gets placed in her cell, she knows that law enforcement's going to keep talking to Carol and telling Carol Mitchell what Nicole Mitchell says. Why does she know that? For the same reason you know that. Because we have body camera videos where Carol Mitchell is literally milling around this situation. Carol Mitchell and Nicole Mitchell are having a dialogue. It's going back and forth. Nicole Mitchell knows very well that whatever she says to law enforcement is going to get back to Carol Mitchell. can see the officers going back and forth inside and outside the house. If Nicole Mitchell tells them the truth in that moment, then Carol Mitchell will find out. She has to maintain that white lie to protect Carol Mitchell. As somebody who is a criminal law practitioner, I know very well that alleged victims don't drop charges. Doesn't work that way. Does not work that way. That is a sentiment, a feeling that a lot of people have. Maybe it's from TV, maybe it's because it used to be more common in years past. Nicole Mitchell believes that Carol Mitchell can drop the charges. And she still believes that telling this white lie about these things is the right thing to do until she is in the jail. And the officer, when she asks, can she drop charges? The officer says, that's not a thing. You watch that video again. That is the moment. That is the instant Nicole Mitchell stops talking about it. That's the instant she realizes that this family spat, that this confused mess that she created is not going to go away when Carol Mitchell realizes what's going on. When she realizes that this white lie is not going to do what needed to be done, it's not going to protect Carol Mitchell, it's not going to protect her, it's not going to serve the interests of anyone, she's done talking. And she had a personal experience about it. She knew from personal experience that people can drop charges. It's problematic in a case like this when the state uses its power to get pieces of evidence that tell part of the story, but not the whole story. That tell part of the story that they want, but not the story that the jury deserves. That there was a search warrant for what they call the audit log of Carol Mitchell's Sanford My Chart, but not a search warrant for Carol Mitchell's medical records. Nicole Mitchell testified to what she saw on that Sanford My Chart account. And that is absolutely unrebutted testimony. The state failed to get those records. They failed to let anyone in this case see them. And the evidence that we have is the evidence that came in through Nicole Mitchell. I'm embarrassed to admit this, but someone pointed out a reasonable doubt to me that I hadn't thought of, which is that Nicole Mitchell had been to this residence like at least 5 times following the death of Rod Mitchell and before the incident. 5 times. She was down in the basement to reprogram the television, first to set up the Roku and then to reset it and put the DVD player, install the DVD player with the television. 5 times where opportunities to retrieve these things would have been so easy. Carol's not remembering much. The state wants to impute this bad intention, but also impute this sophistication. If that was a person's intention, why on earth wouldn't you just do it when you had permission to be there in the middle of the day when Carol Mitchell wouldn't have noticed when you're downstairs? This is evidence against this intent claim. This is a doubt based on reason. And we will talk about what a real reasonable doubt is. But any one reasonable doubt as to the element of intent is enough. We need to keep exploring for each and every one. As I said, you are entitled to assign any weight to the state's evidence, including no weight at all. You can evaluate it within its context. The reason we have reasonable doubt is actually not what most people think. Reasonable doubt exists to protect a jury. You are here to evaluate whether the state has met this extremely high burden. And by being subject to this extremely high burden, they have to prove to you that every single doubt based upon reason is ruled out, that there can be no doubts based on reason. And why? Because a jury who is sworn to sit in judgment of another human being has to live with their verdict for the rest of their lives. That is the main reason for proof beyond a reasonable doubt. We are glad, we as a society are glad that proof beyond a reasonable doubt protects citizens accused, that only those where the burden has been met can be marked with that guilty conviction. But its core purpose is to protect the jury, because the weight on a jury of a wrongful conviction lasts forever. 18 years ago, the 35W bridge collapsed down in Minneapolis. It was a pretty new bridge. It was designed with modern techniques and modern materials, but it had a structural weakness. It was a structural weakness that would have been easily noticed if the right people had thought about it. It was always a deficient bridge, but no one fully noticed it until it was too late, and 13 people died. A prosecutor's case is like a bridge. If there is any reasonable chance that the structure could fail, then it has to be scrapped. It doesn't matter if it's mostly good. It doesn't matter if it looks good. It doesn't matter how much it costs. It doesn't matter whose reputation is on the line. It doesn't matter who desperately wants you to believe that the bridge is sound. If there is any reasonable question about its integrity, then it should be scrapped, because the stakes are just too high. However, when a faulty criminal case is built by the state, and they have convinced a jury that their faulty case is really good, that mistake usually sits silently. It sits silently with the accused, who knows the truth, but is left to sit alone for years with its weight. The mistake also sits silently with the jurors. Because as much as the state wants to make this about Nicole Mitchell, it is not. It is solely about whether the state built a bridge so absolutely sound that they eliminated every single reasonable question about its integrity. So much that we would send our children and family across this bridge. Now, you're not bridge builders. You are inspectors. How does it feel to be an inspector who confidently thought the bridge was sound, only to see people fall to their death? Jurors in the past sometimes didn't listen to reasonable doubts and convicted, only to learn years and sometimes decades later that a human being's life was taken away by a wrongful conviction. How do we know this? We know it for a fact because of what are called DNA exonerations. Those defendants looked guilty. They looked guilty to juries just like you. Some of those defendants testified and were made to look inconsistent by prosecutors. Some of them even falsely confessed or had the meanings of their words twisted by the state to look like a confession. But the jury used their common sense instead of the reasonable doubt standard, and they convicted. You see, that's why it doesn't matter how much evidence the state piles up. A doubt based on reason and common sense is the way to avoid this. And that's why the reasonable doubt standard is so crucial. Those defendants who were exonerated looked guilty to those juries. Because those juries sat in a courtroom where endless state witnesses piled things on and made the accused look as bad as possible. The problem is, and this is where we talk about some of the instructions. If all you have to use is common sense tells you where there's smoke, there's fire. When you combine reason and common sense, then you have to rule out the possibility of dust or fog, or the smoke came from somewhere else. When you combine reason and common sense, the government has to rule out the reasonable possibility that Nicole was checking on her stepmom, that she may have even seen things of her dad's and ignored them, that she was focused on making sure Carol's phone was functional so that she wouldn't get lost and experience a tragedy. You can tell when the state wants you to ignore reasonable doubt because they will sneer at the defense and imply it's ridiculous. If they could rule out all the reasonable doubts, they would calmly do so. This decision is a decision that you cannot take back. There are two ways for a state to prove a case such that a jury is to find them guilty. They can prove beyond all possibility of doubt, and that is instructed to be guilty. Or they can prove beyond a reasonable doubt. And the court also instructs a jury to find them guilty if it is beyond all reasonable doubts. But anything less than that is not guilty. This is not like college. This is the toughest test in the legal system. Yes, it is hard to prove this. Why? Because of the effect on the jury and effect on the citizen. We do it this way because this is how we put a check on the state, a check on the government. Whether any of you think this is unfair, this is the way it has been for a very long time. And the danger comes when people don't take it seriously. Because as we talked about before, when there are reasonable doubts, there could be wrongful convictions. This is what it looks like. The state should always want to take up that burden. talk a little bit about burglary and burglary tools. The state asked you to consider why Nicole Mitchell had the pry bar. And she told you, because the screen door was sticky. She already admitted she was going to go in without permission. And she said that it actually bent when she kind of had to pivot and do this other thing in the basement window. The defense is always afraid when there are two charges like this, because a jury might want to split the difference and give something to the state, something to the defense. But as the burglary accusation goes, so goes the burglary tools accusation. Where there's no intent to steal, where there's reasonable doubt as intent to steal, there's no burglary. And where there's no burglary tools. As you look at this case and realize that there is reasonable doubt as to intent as to burglary, this pry bar is just a pry bar. Again, they could have, charged Ms. Mitchell with anything that they wanted, with anything else related to this pry bar. But when she is not guilty of burglary, she is not guilty of burglary tools. As I wrap up, I am reminded of something that Nicole said yesterday about an exchange that she had with her family, and I think it was in December of 2022. I didn't remember this. Some of you may have. That an elderly woman with some dementia got lost here in Detroit Lakes. And a state trooper figured out, he heard it on dispatch, and he immediately came back. He wasn't detailed to it. He just decided to check, and he kind of used his investigatory ability, and he found this lady in like November or December sitting on the riprap on the side of the lake, getting close to freezing to death. When we hear these stories, when we experience these tragedies, they resonate with us. They stick inside us. They shape how we behave. As a peacetime veteran, I can't help but having reverence for combat veterans like Officer Sternhagen. It's just wired into me. Nicole Mitchell feared the loss of people in her life. Those stories stuck with her. They shape us. The good things shape us, the bad things shape us. And with that cascade of tragedy and terrible news stories about near misses here in our community, it makes sense that she was so activated by all this. One of the hardest things for some juries to accept is that the questions the judge needs them to answer aren't really the questions they want to answer. Maybe you want to answer questions that aren't in front of you. Sometimes juries kind of wish they were more like a TV judge, like Judge Judy. You hear everything, you look at all the evidence, and you decide you did this right and you did this wrong, you did that right and you did that wrong, and I'm going to give you this and give you that, and this is what I'm going to order. To kind of put it all in a ball and fix it. You haven't been given that choice. You haven't been given that choice. You haven't been given the opportunity to decide what should happen because Carol Mitchell was justifiably terrified. You haven't been given an opportunity to decide how much Nicole Mitchell should pay for that window. You haven't been given an opportunity to decide What should happen to Rod Mitchell's shirt? You haven't been given an opportunity to decide how Carol Mitchell should be cared for. But you should feel comfortable knowing that your job in evaluating the state's work here, it still allows other disputes, other courtrooms, and other places. This job, the job that you have been given, is beyond important. A criminal jury is one of the only political bodies, and that's what you are. You are an assembled political body here to evaluate the state's work and decide whether it met the very high standard that we have had for hundreds of years. And once you are done, you as a political body will dissolve and you will have executed your duty. Yes, it is a heavy weight. It is extremely important. When you are deliberating, if one of your fellow jurors says, well, she said she was there for some of her dad's things, so she must be guilty, remind them that the state is required to rule out any other possible purposes of those statements. It is not our job to prove the opposite. This is the state's case. It is our job to show you the doubts, and it's your job to apply them to the state's case. The state doesn't want you to look at their bad facts. That's why none of the state's witnesses admitted on direct that none of Carol or Nicole Mitchell's stuff was found. Carol or Rod Mitchell their stuff was found with Nicole. You know, not guilty verdicts actually serve the state very well too. It is a crucial reminder to the state to do better, to choose carefully what criminal accusations to make, to think clearly about what justice is and how it is rendered. Ladies and gentlemen, there will be more cases. We, as citizens, want the right cases brought. We want them to be prosecuted in the right way. Not guilty verdicts tell the state to try again and do better. And that is important. This is my last opportunity to speak with you. In a minute, I'm going to hand Nicole Mitchell over to you. And I won't be able to do anything else. The state gets an opportunity to come up here and tell you a completely different story. And if that happens, I want you to be thinking about your responsibility. Why isn't he ruling out every single reasonable doubt? Now, both the possible verdicts on the verdicts forms are framed in terms of guilt. That's what the chart was about. Guilt is proven beyond a reasonable doubt. Guilt is not proven beyond a reasonable doubt. There is no third verdict that you will see. There is no third verdict form for innocence. It's not a question here. If somebody brings that up, please remind them. Did the state prove guilt beyond a reasonable doubt or not? You don't have the third choice, not in our system. The state needs you to believe that Nicole Mitchell would throw away everything, that she would throw away her career, that she would throw away her family, that she would throw away her ability to be a foster mom for a shirt she knew she was going to get. as we discussed at the beginning of this case, unless the state's evidence can rule
All right, this
out
guy's trying real hard. Do you guys have an opinion on how he's doing? Are you swayed? Has he planted reasonable doubt in your calculus?
I'm bored to death with him. Like, he came out good. He came out kind of dynamic and all, and I guess he's made a few good points, maybe. You know,
All
but
right, well, let's hear these rebuttals. Oh, hang on. They're doing an approach. They're going to talk for a second. Go ahead and finish up, Pidgey. Sorry.
yeah, but it went on way too long for impatient people to suffer through. It went on way too long to track everything he was saying.
Nicole Mitchell.
You know,
I agree. I think there's a tactical sense to that, and that is use all your time. I don't know what each side has. There's a time limit. It's equal. So I think it's the defense that you try to use that up, because when you're not talking, the state's talking, and they're not talking in your favor. So a lot of it kind of comes out as filibuster. I will say that if the jury is bored with it, that means the jury's probably already made up their mind. They're not really listening to what he's got to say. But the defense gets that opportunity. And I won't beat in fact, I think she's probably got a pretty decent defense team. They've had much to work with. And of course, we don't know how the jury's going to find. I know if I was sitting on the jury, I think my mind's made up. But I think her defense has done as good as they can do with what they've got. I mean, here's what he tried to do. He tried to sever her statement, saying, "Well, the state's got to find there could be alternative meanings to that. You can't just listen to it and assign your own meaning to what the person said." And there's some truth to that. And the way law enforcement does that, they'll go back to under the circumstances they came in contact with her. In totality, what does that statement mean? Well, in totality, she broke into a house. She's wearing all black. She secreted herself from police, and then when caught, asked, "Why'd you do that?" "I came to get a flannel shirt and pictures." I think it adds up to. I can say that's the intent. It's what she claimed to be the intent, and there's evidence absolutely supporting it, in my opinion.
he had one mistake I really feel kind of stood out, and it was sort of towards the end, and maybe that's why. But he was trying to say, someone pointed out to me that a reasonable doubt, and he went on about her being in the house like 5 times since her father died, and that backfires alone, because obviously that's not a great relationship, and she's one hell of a caretaker at heart to do it kind of in the ethereal realm instead of the physical realm. And but he was like, "Well, why didn't she take the shirt then? Why didn't she do these things then?" Well, exactly. Why didn't she? Why did she have to break in at 4:00 in the morning? That kind of blew his point right there.
Well, take it. And honestly, that could leave infer an innuendo that you're right. Her intention wasn't to get the shirt in the pillow. I mean, in the photos. You look at her note; it was to tamper with her devices in some manner, and then she's discovered standing over her, as in Nicole's words, but in Carol's recollection, twice and seemed to be pretty solid that she was laying on the floor. Now, of course, she could have started that way when Nicole and when Carol stirred, she laid down on the floor, which is almost similar to what Nicole said. Why is she in the bedroom? Then it leads to other innuendos. Her intent is not good by the method of the way you find her. You broke into someone's home, so I think we automatically lean towards your intentions aren't good if you're doing that. If you wanted a shirt, go spend some time with Carol and talk her into it when she's in a good mood or whatever, if that's the real issue. But his statement, you're right, could lead the jury to go the other way, because now the state hasn't pounded on it, but you've seen it in the video. And I think it's all come to our own mind. Standing over the bed in the middle of the early mornings, broke into someone's house. And if she dies, here's the other thing. If she dies, then Nicole gets all of it, or she gets her share. There's a large portion that's delineated in Carol's will that goes to her. So I don't think it's out of the realm of possibility that Nicole Mitchell went there to end this lady's life, put a pillow over her face. And then you've got Carol herself saying that, well, we used to keep the pistol in this drawer, but I don't do that anymore. So was she there to get the pistol to shoot Carol? if you take out I was there for the shirt in the photographs, then it leads you down the road of where your intent. We know your intent was nefarious by your method of entry, correct? Wouldn't we all agree with that? So if your intent's nefarious and it's not to get something as benign as a shirt and a photograph and not harm this lady, then it's to harm her. Or it's
what were you doing in the bedroom? I mean, the shirt was in a bathroom, right? It was hanging by itself in the bathroom. Isn't that what
the defense closing arguments explained that all of it's in the basement. She couldn't have been there to steal the shirt. And here's the defense's problem. The defense has got to get over that statement. I came here to steal the shirt and the photographs because that meets the elements of the offense. If the jury believes that, they have to find her guilty of burglary because there's no other portion of this: unlawful entry, breaking in, the black clothing, the planning, the backpack. None of any of that's in dispute by the defense because they've got nothing to dispute that with. Their only dispute is it's not burglary because she didn't break in. She broke in to clean the kitty litter box. She broke in to check the expiration dates on the food in the refrigerator, but she did not break in to steal anything. So the defense has got to get over that. The problem is when you take the stealing out, it doesn't remove the whole nefarious totality of evidence that something was nefarious. So if it wasn't to steal something as benign as a shirt and a photograph, and you're upstairs where these items are not, then what were your intentions? Your intentions were nefarious. It was 100%. I don't think the jury is going to walk away from this thinking that this is truly a welfare check, as she posted on our Facebook.
No, I think his point is to try and reduce the sentencing, honestly, because if they let her off.
Well, now hang on. It can't be. The attorneys are smart enough to know that the jury is not just determining. Mute.
Sorry.
The jury here is only to determine guilty or not guilty. Did the state prove the case or not? So this is the first phase. There'll be a whole nother hearing if she's found guilty for the sentencing. There's where you'll really get some emotion. You're going to be able to bring in people that talk about Carol's mental state after the fact. That she couldn't stay in her own home. She's afraid to be in her home, and I think that's going to be damning for Nicole as well. She did harm her, didn't hurt her that night, but she has harmed her. I mean, there's a big effect on an elderly widow who should have a peace in her life, and she doesn't because of this act. So going back to that again, they're not trying to influence sentencing right now. They're trying to plant some reasonable doubt on the defense side. I just don't think that they have any seeds that are going to sprout.
No, and if I was the jury there, a lot of what he put into that very long closing was just lawyer stuff, like, reshowing okay, this is what this looks like. If you find her guilty, it's up in these two fields. If you don't find her guilty, look at all these fields where you cannot find her guilty. Look, I've highlighted them green. So that's in your head. You know what I mean?
And that's it. And that's a common tactic when they've got media and it's available for them to show that you have many opportunities not to find my client. In other words, you got to thread the needle to find my client guilty. There's many opportunities to find him not guilty. And they're really looking for one. If you could get one to stand by their conviction for a not guilty, then at least you get a hung jury, and then it'd be back up to the state to actually retry you again. So in some cases they won't. If their case is so weak that they can't convince the first jury, then they have no confidence they can convince a second, and they could actually. It's a tactic.
Yeah. What do you think the state is going to rebut with? I think they should show the body cam video again and show how coherent and really drive that home that Carol was. And I'd drive home the MFA, the two-factor, that she was after her phone to get to that financial. She'd already hacked the account. She's after her phone. I would drive that back home.
I don't know that they've established enough foundation for them to bring that up in the closing. You can't just talk about anything. You've got to talk about what you've laid foundation in the case that the jury's heard. So I don't know.
Think the list?
Well, hang on. No, I don't think they have. They haven't directly made that accusation that she was there to take bank numbers. They haven't made that. The innuendo's been there. In the evidence, one could come to that conclusion on their own by reading it. So I say this. I think they will leave the jury with, in Nicole's own words, I came here for the shirt and the photographs, making it a burglary. Because if you believe that, then it's a conviction. If the jury believes her words there, it's a conviction. I do think they'll go back to the note. You notice they brought it up in the first part of the closing, but it was there was some stuff missing that I thought should have been there. So I think we'll see that on the second round, because remember, the state gets the last word. The state will have the last word to the jury, unless they say they don't want it. They have the opportunity to rebut. So I say that. I think they will. And I think you'll see the jury be left with Nicole's own words. I broke in for the shirt and the photographs. This makes it a theft. Burglary's sealed. Burglary tools is already sealed. Fine burglary. Burglary tools are already sealed. Obviously, you use the tool to get in. That makes it a burglary tool. So if they believe her statement, and let me finish. So I think they'll leave with that. I think you will see the note come back again, and I think that he'll hammer home, why would you delete contacts? This is nefarious in of itself. I'm not saving someone by going into their phone and deleting contacts. And I'm going to say it like this. Take it in perspective with a woman of her age. She's been an adult longer than cell phones have been around. So she's had a cell phone as long as cell phones have been bouncing around, relatively. She has contacts in her cell phone, like I have contacts in mine from 2005. Because I get a phone and I put my contacts in. I get a phone and put my contacts in. When this lady goes and gets her another phone, the people at the store move her contacts over. This has happened years after years. So you and I, Fidgy, we've known each other for 40 years. And we've been texting each other and we've been calling each other on cell phones with your number. And I know you as Fidgy in mine, and you know me as Joe in yours for the last 30 years. If you ask me what your phone number is, I would have to go to my phone to find that. If same for me, you would have to go into your phone to find my phone number, because we have them in the contacts, and they've been that way for years. One day, after I've been accused of having some mental, I'm diminished mentally after the loss of my spouse of 40 years. One day you send me a text message and I say, who is this? Would you think that would that reinforce the fact that my mental capacity is diminished, and maybe somebody needs to step in, like a court, to find me incompetent?
No. I just
no, you're missing my point. I think deleting the contacts are a very nefarious deed. I think she needed other people to say she's as diminished as I say she is, because no one else is saying that at the time. We see the lady on the video. I'm not saying she's not suffering from Alzheimer's, but she's not a blibbering idiot that can't clean out the cat litter box. In fact, her house was immaculate, if you go back and watch the video. So everything that Nicole is saying, nobody else is seeing. In Nicole's mind, she needed to see that, and she needed Carol to be deemed incompetent, because once she's found incompetent, it's almost like dying before you die. Transfer your wealth over to an executor. Might as well give some of that to Nicole. She's getting some of it anyway, and then Nicole can control and keep her in a nursing home that serves ice cream on Fridays. I think that's where this was going.
I think so too. I think she was setting her up, and that she was, Nicole was nefarious. I don't think, I've kind of changed my mind. I don't think she was going to kill her. I think she was after that cell phone in the bedroom that would have been on the nightstand next to Carol.
And she says that she entered the bedroom because she said, normally my father, when my father was alive, they charged the cell phones in the kitchen. So she goes to the kitchen to specifically to find the cell phone. It's not there. She said that's what led her into the bedroom. And then she was just so happy to see Carol breathing that she just had to take that in for a moment. She added that. But no, I think she's after the cell phone. Now, the purposes, it could be both. In fact, I think it is both. Delete text messages. Why would you delete text messages? Why?
To make them, to either hide evidence or to make them seem like what they're talking about didn't ever really exist.
Or if I bring the computer that you gave me that have access to your email and I pop up trying to access your bank account and ask me for two-part authentication, it's going to be your cell phone that you've had for years, and I'm holding it in my hand, and they send me the code, then I can now engage the device that I just engaged to be able to access your bank account information. Then I should delete that text they just sent me. Make sure the ringer's off before you get this text message, because you don't want to wake her up. All that leads to nefarious. Now, the state I don't believe, has established a foundation to really pound that, but I think the innuendo will be brought up in the rebuttal closing by the state, and I think they'll go back over list and give maybe a tighter narration of what we think those items mean.
Yeah. Hey, you know what those items mean. Let's talk about something that means something. You have a tip jar, Joe. And anyone listening, if you go over to Joe Lanew's page, you can find that tip jar and go ahead and kick him a couple of bucks because he's paying for this show out of pocket. So if you enjoy the show, and yeah, I'm trying to get Joe to do more of these shows, then go throw him a buck or two. Buy him a cup of coffee, a bullet, whatever you want to buy him, but throw him a buck or two. He would surely appreciate that, even if I did just call him Shirley.
Well, you did call me Shirley.
Yeah, I did call you Shirley. Shirley Lanew. If you go over to Joe Shirley Lanew, you can tip it. Also, if there's a case you want to see, a non-federal case, because they don't broadcast those. If there's a case you want to see, make a request. And there's some cool ones coming up, and we'd like to hear from you as to what you all want to see, and while you're at it, go ahead and join the grand jury community. And Joe, I'll let you talk on that.
Yeah, first, Fidji, I appreciate the mention on the tips. Folks, it is appreciated if you do that. Fidji is working real hard behind the scenes to start picking up more of these cases that take all day. Actually, I enjoy doing them, and we'll find some to do more in the future on this. It seems like we've got some positive feedback, and it's fun and interesting. But yeah, with that, there's a little bit of a cost to put this together. We do it out of love. Don't get us wrong, but if you enjoy the show, a tip would be appreciated. It's both on YouTube and X. Real easy to find. I got a Venmo link and a Cash App link. Would appreciate that. But yes, we are looking. Fidji's convinced me that we need to find more of these that are interesting. I will say that not all cases are interesting. Some of these are real snoozers. Somebody like me, I enjoy watching it because I'm watching the tactics in there. But sometimes the storyline's hard to follow with the way cases are put on. But we'll find some. They're out there, and with modern technology, and they're streaming more and more of these every day. So we'll catch them.
Well, we make it fun, so we make those cases interesting. So we're going to give each other shit and give them shit and kind of laugh the whole way. So join us on that.
Now we've got Fidji's done some digging, but if there's a local case going on, like this case here, this is not national news. This is a local case out of Minnesota that we were made aware of with some of our fans that are in Minnesota. Matter of fact, so. Yeah, if you know of some that are going on around you, shoot me a DM. I'll dig in to see if it's televised, or there's a feed that I can grab a hold of, and we'll put it up and talk our comments about it for sure.
And while we've got your attention, Joe's going to tell you about the grand jury community.
I tell you what, we have. Let's talk about the grand jury first. We do this live stream every Friday night, 9 p.m. Eastern, 9 to 11 p.m. Eastern. We take 5 volunteers from the social media platform X. We seat them as jurors, grand jurors, actually. And we show police use of force videos, the body-worn cam, the typical stuff that you see. Of course, it has no comments. I get these directly FOIA requested or releases directly from the agency themselves. We show them, and then we ask them to see this through the lens of a grand jury, the reasonable person, and make a decision as to whether they would justify the officer's use of force or deem it unjustified, which would mean an indictment. But here's a promo for tonight and tonight's guest.
You ever get any money from Costello?
No.
And did you ever get any money from Meyer Lansky?
I never got money from any of those fellas.
None of those
fellas. None of these that I've been reading about, and none that I knew. They never gave me anything.
None of the Shetties?
No. I don't even speak to the. I mean, I met that Charlie once or twice. I don't even talk to him.
You don't like him?
I was conscious of the fact that he had a reputation for being an outstanding bookmaker.
Did you hear him referred to as the Prime Minister of the Underworld?
That term I did not.
Also known as Duck Corella. I refuse to answer on the grounds of main attempt to got any business? I refuse to answer on the grounds of attempt to criminal. You have any profession? I refuse to answer on the grounds of main attempt. Have any occupation? I refuse to answer on the grounds of Are you a known racketeer?
An incarcerated individual's use of institutional telephones constitutes consent, and your calls may be provided to law enforcement agencies. Thank you for using Securus.
Yes, folks, that's the grand jury tonight. If you haven't caught one of these shows, you should. I think it's it's grand jury game show style. It's a mock grand jury. We're not solving any real problems, but I think it will give you some context as to what happens in a grand jury and legally how we ask grand jurors, just like you heard the jury charge, the jury instructions in this case, how we ask jurors to see things. So very interesting show, we think, and we've been doing this for a little while now. We've almost got it down where it's pretty decent to watch. So catch us with that. And along with that, Pidgeys want me to push. We have a on X, you can volunteer to be a juror, to join our we have a jury pool community, and it's just a community. The only thing in there is grand jury things. We don't do a whole lot other than that. But every Tuesday, I will put a post up inside that community requesting anybody that's got the time available and wants to volunteer to be on a Friday episode. Every week, folks, I do 5 new jurors. We don't have jurors that have served before because we want them fresh. And what's interesting is to listen to how they deliberate and come to their decisions on some of these cases. Some of them are tough. Some of them are not.
And
some are tough.
And while only the jury and certain people can be up on the stream, we do host a space alongside of that where you can come in and watch videos and give your own opinions on the grand jury and what you think of the case and was it too much force? Was it not enough? So, join us on that too, because we really do discuss that.
I think we got the rebuttal going.
It's the same burden no matter how many times Mr. Ringstrom repeats it to you or how many scary stories he tells you. It's not a magical formula. It's not an insurmountable burden or one unique to Ms. Mitchell. It's the same burden used in all criminal matters. Each and every working day across America, people are convicted applying this standard. That's why.
Sounds like they're having some audio issues in the court.
Yeah, it does.
Doesn't mean a failed burden of proof.
Does dude look like Bert?
Says it is. If you have a doubt,
Bert,
the judge instructed you that it must be based
Sesame Street Bert.
It cannot be fanciful or capricious. Can't be far-fetched. Ladies and gentlemen, watch the body cameras. We are confident in the bridge that we have built. Drive the biggest semi you want across it. Carol Mitchell is not on trial here. Her testimony was a painful reminder that cruel diseases like Alzheimer's they move a lot faster than our justice system. Jonathan Keel may have expressed a belief that Carol Mitchell wanted the defendant to have these items. And that it's very possible that Carol Mitchell herself may have wanted her to have them. But the fact of the matter is they hadn't been turned over yet. They were in her house. The defendant broke in to take them. Mr. Ringstrom said that the state, his client was made to look inconsistent. We didn't do that, ladies and gentlemen. She did that herself. She did that in her direct testimony. Told you she's a liar. Repeatedly, you've heard about how the defendant didn't have any belongings on her person. She got caught right away. Of course, she didn't have anything on her. She got interrupted. You've heard about how the defense has stated that the defendant has expressed concern and did on the body cameras. Rewatch that footage. The context of her statements about Carol's disease are not in the manner of concern. They're used as a matter of excuse or resentment. Handcuffed and facing the reality of her actions, ladies and gentlemen, the defendant makes the following statements. I'm just hoping this mistake won't completely fuck up my life, my God, my military retirement shoot. Knowing that her career and liberty are on the line, the defendant again manages to show concern for the one person that she cares the most about, herself. The defendant told you yesterday that she will lie to protect people. This includes lying to escape responsibility. Remember this as you deliberate. Ladies and gentlemen, please take all the time you need. Review any exhibits you wish. However, I want to leave you with one final thought. If you are all in agreement that the defendant was being truthful on April 22nd, 2024, when she spoke to law enforcement, then your verdict can be swift. I ask for justice for Carol Mitchell. Find her guilty.
Ladies and gentlemen, that concludes the closing arguments of the attorneys. And as you probably observed, there are 14 of you, soon to be 12. In any trial that is expected to go beyond a day, alternate jurors are utilized in the event of illness or some unforeseen event that may result in a juror being unable to fulfill their duty. And before your deliberations begin, we excuse the alternates. And before I release the names of the alternates, I want to make a few comments. Alternates will sometimes feel disappointed they don't get to deliberate. I find that some alternates are relieved that they don't have to go through the deliberations. Whatever your feelings may be, I am fully aware that your time is valuable. But please understand that your time and dedication to this trial is invaluable to our system of justice. You were needed. You fulfilled your duty. And for that, we thank you. Mr. Steve Carlson, Ms. And finally, once again, I want to thank you for your time, commitment, and dedication to this trial. You may be excused now. So, ladies and gentlemen, upon retiring to the jury room, select one of your members to act as the foreperson, who will preside over your deliberations in a good, businesslike manner and will sign and date the verdicts. You have been allowed to take notes during the course of the trial, and you may take those notes with you to the jury room. You should not consider these notes binding or conclusive, whether they are your notes or those of another juror. The note should be used as an aid to your memory and not as a substitute for it. You should not give greater weight to a particular bit of evidence solely because it has been reduced to writing. The foreperson is instructed to return these instructions and all verdict forms to the court at the conclusion of your deliberations. If we could have the jury attendants and the bailiffs come forward to be sworn. Please raise your right hands.
Do you swear or affirm that you will keep these jurors together, separate from all other persons, and that you will not allow anyone to communicate with them or overhear their deliberations? That you will not make any comment to them about the law or facts in this case, and that you will not disclose to anyone, except this court, anything which you may learn from their deliberations? If so, say I do. I do.
All right, if we could escort the jury to the deliberation room, all rise for the jury.
All right, there we go. And again, this happened about 10 minutes ago because we were on a 10-minute tape delay here. So it's 12:48 now. So it was 12:38 when the jury went out to begin their deliberations. You see this a lot in cases where it's lunchtime when they begin. And, you know, I've seen cases where they actually take a break for lunch before they even do anything. And other times, you know, you see the lunch being brought in typically. And, you know, you hear that, no, it was a working lunch. They wanted to get on with it. So they're going to eat their meal while they're starting to pick their foreman, et cetera. So who knows what'll happen in this case, but certainly on a Friday afternoon, they probably want to start getting to it. So here you go. We just had a very brief rebuttal from the Becker County prosecutor, the county attorney, to the defense's closing argument. I didn't get a whole lot out of that, but let's bring in Marsh Hallberg one more time, so you can get to your lunch too. But what did you make out of that? It was pretty brief. Nothing really jumped out at me.
And prosecutor actually followed the rule, right? He just talked about the law from it and done. I mean, there was nothing that was gained by that, but I've never seen a prosecutor waive a reply. So I think, you know, what was it, 2 minutes long? I mean, it wasn't long.
I mean, the only thing I flagged again is just a reiteration that Carol Mitchell, Alzheimer's sufferer, stepmother, is not on trial.
Yeah.
This is a trial about Nicole Mitchell. You know, a lot of the case. I mean, there's the house burglary, break-in, and there's Carol Mitchell, right?
Mm-hmm.
Yeah, it was a short rebuttal. I kind of thought I wanted to see more maybe, but there is a term, quit while you're ahead. I think the state's met its burden of proof actually pretty easily.
Yeah, I still would like to see him drive home a couple points right there at the end.
Well, that's just us wanting entertainment. I don't know that, you know, you can't overplay your hand. That's another fear for trial attorneys.
Well, you know, during their closing arguments, I think the defense had a couple of things they said that kind of, in my mind, kind of shot what little bit of water they had left in the boat. They made the comment of, if she was been in the house X number of times, why didn't she just get the stuff while she was there? And that she knew the person for X number of years. You know, why would they need to break in? But that doesn't change the fact of what she did. I mean, you and I have known each other for years. Doesn't matter how many times I've been in your house. If I break in, I still break in. And obviously, if she broke into the house to steal those items, she didn't want anybody else to know that she was taking them. And I think those two statements really stood out to me.
I think when you apply the whole thing we talk about, totality of the evidence and circumstances, I just don't see a way that you can find her not guilty. I just don't. I think the elements are pretty soundly proven. The defense wants you to just take the statements out of context and ignore all of their evidence. She brought a pry bar. She broke in the window and she goes inside. She's dressed in all black. She parks around the corner. She looks like a burglar out of the movies. It's ridiculous. She's got a flashlight with a sock over it so that you don't see flashlighting flying around inside the home. She's discovered inside the complainant's or the victim's bedroom. I just don't see how. I don't see how the defense can dig out of the hole. I don't.
Yeah, I don't either. It's going to be either they have mercy on her or they don't. But I see them just being across the board. She's guilty. And good riddance.
Yeah, for sure. Why don't we take a little bit of a break? I'm going to grab some lunch. And I think the jury's at least an hour. They've got to pick their foreman. They're probably going to get some lunch. And a lot of times they can bring lunch into them if they want to work through it, but they don't have to. But I think we're at least an hour before I think we'll get a decision today. I don't think this goes another day. In fact, in true deliberations, I think your first straw vote's going to reveal that everybody's in a consensus.
Should take bets on when they'll come back. I think they'll probably come back about 3 o'clock their time. Give it a couple hours, make it look good. Come back with a guilty verdict.
I don't think the jury's not trying to make this look good. I think that way that works is, for those that may not know, you get a foreman picked. You'll go over the jury charge again. All this takes 30, 40 minutes. You know, or so. But once that's done, the foreman is going to, it's suggested that the foreman take a straw poll at the very beginning to see where everyone's at. So they go through each count, everybody votes. If they've got a unanimous vote at that point, they don't, unless somebody's got an issue that they want to talk about, then that's it. That will be the decision. But if they take a straw poll and they've got just one person that says not guilty on any one of the elements, or has an issue with any one, or not sure on any one of the elements, that's when they'll start discussing it back and forth and try to make some sort of determination. But the straw poll comes out 100% first time. I mean, there's your answer.
Yeah, I have an errand I have to run. I'm kind of sketchy to do so because I don't want to miss the verdict.
Sorry, I was typing a response. But I don't know how long your errand's going to take, but take your phone with you, watch the feed.
Yeah.
If not recorded, you'll come back and watch it. But I'm predicting a short deliberation, and I'm predicting guilty on both counts.
I hope so. I really do hope so. I hope so for the people of Minnesota. You don't need to be represented by someone who makes such poor judgments for their own greed.
Well, it has nothing to do with her being a senator or her being a commander in the meteorologist, field. It has to do with, you have a right for people not to do that in your home. You have the right to feel safe when you sleep, that you're not going to wake up and somebody's on the floor, whether it's a family member that you're in a dispute with or not, whether that person really meant you harm or not. You don't really know. And you know what? Carol today doesn't know. She doesn't know if Nicole was there to kill her. I mean, it's reasonable to think that maybe so. It could be. You have the right not to have that fear. You have the right that inside of your home, you're safe. And if anybody breaches that, then the government's going to do what the government should do and punish that act. And I think that's what it comes down to. She didn't have a right. Here, let's talk about what Nicole didn't have a right to do. Nicole didn't have a right to determine how Carol set up her estate. She didn't have a right to determine whether Carol went to her doctor appointments or not. She can be kind and caring and ask like any other person, but she didn't have the right to intercede into that. She doesn't have the right to intercede into what Carol does with her finances or who is her power of attorney. She doesn't have those rights. But I would interject that Nicole thought she did, because she is just such a smart person. And like most, and I hate to say, but like most white liberal women, they interject themselves into other people's lives when you have the right to do what you want to do. And if that's not a great decision for you, then so be it. You're the one that's going to live with it. Nobody has a right to push these things on you. But she broke into that home to intercede into that and to force the fact that this woman was going to do what she wanted to do no matter what. Now, is that killing her? It could have been. Is it to steal her financial information? Sure. There's evidence for that too. Is it to steal a flannel shirt and some photographs that belong to Carol? Yeah. All three. There's evidence for all three of those. Either way you look at it, it's burglary, and you have the right for that not to be happening in your home. And you have the right for other people not to interject themselves into your life by force. And this is what we saw at Nicole. That's my opinion.
Well, and through her own greed, she basically took advantage of someone who was debilitated. I mean, maybe Carol isn't in deep Alzheimer's, but Nicole is trying to paint her that way, so she's definitely making her a victim, right? Trying to make her look crazy. What kind of Rosemary's Baby crap is that? With the contacts and that type of thing. And then I definitely feel like she was there to steal the financial information. Absolutely. And, this has been going on for 11 years. She's been at the house 5 times. Even tried, didn't we make the point the other day? She even tried to get her to move the funeral, even though that date had specific meaning to Carol. Screw her and her marriage of 50 years. I want what I want.
Well, she was pretty plain about this all the way through, that she wanted to help. The aunt are going to help her with her fine. We're just trying to help you. Give us your legal documents. You don't have to worry about this. We'll take care of everything. This is not right. People just because she's elderly, just because maybe even she has dementia or the early signs of it, obviously. And she lost her husband of 40 some odd years. She has the right to determine what happens to her life after that. Doesn't mean everybody else gets to jump in and determine what happens to you. You have the right to figure out how you want to spend your last years. Do you want to go into an assisted living place? Cool. If you want to, I've got no problem with that. You shouldn't be forced to that. There shouldn't be people in your life driving you to that, because honestly, if you care for someone, then that's more convenient for you to have them in where somebody else is taking care of them, if that's what the case is. And it sounded like maybe we missed this. A lot of people may have missed this in the testimony, but it sounded like they had a plan in case Carol got to the point where she needed some assistance. By the way, she still lives today unassisted, so she must be doing good. But they had a plan, and it was going to be for Carol's sister to do that. But what did Nicole say about that? Oh, no, that's a horrible plan. That's not good enough for me. I'll stand aside. White liberal woman's here to let you guys know exactly how you need to run your life. I'll run it for you because you're not smart enough. And I'll go back again. I want to say one more thing, and then we'll break for the lunch. Go back to the closing arguments by the defense where they talked about she was just confused. That's why she said she thought that Carol, loving her the way she does and would understand what she was doing, would just drop charges later. So it didn't matter whether she admitted to a crime or not, even a crime that she didn't commit. She lied to the police officers when she said, "I'm here for the shirt and the photographs." I think that was a tactical error on that side. Because you spent a whole day, the defense spent a whole day telling us how smart Nicole is, how accomplished Nicole is, how driven Nicole is, how meticulous Nicole is, that she has a degree in meteorology and she has a degree in law. She is an attorney. And you're going to tell me an attorney doesn't understand, after being read your rights, that everything you say can and will be used against you in a court of law, that you don't understand that you probably need to be telling the truth, probably nothing at all. You should say nothing at all at this point. I think that they can't go one way, that she's so sophisticated and so much better than the rest of us, and then use her defenses that she was ignorant and naive to the law for which she holds a degree. I think that was a tactical error on the defense, and that just doesn't add up in most people's heads, in my opinion.
Well, and this is probably a minor point, but it kind of aggravates me that if you listen to Nicole's experience, it's more to do with like children, right? She's fostered some kids and things like that. It is not to do with the elderly and Alzheimer's. They are not the same thing. The elderly with Alzheimer's are not children. And the fact that Silverhair, I'm sorry, I can't remember her name. Silverhair had 5 years experience taking care of her own mother-in-law and was the power of attorney in Carol's case. I mean, that makes me just want to punch Nicole. She's going to drive me to violence, too.
Yeah, she's meddler. She's just poking her nose in everybody's business. They've got somebody else as the power of attorney, but she didn't like that because that person's not good. What she's saying is, it should be me. I should have control of this. When you're dead, I'm getting a large portion of this because that's the way the will was set up by Carol. So you should just give me control. Give me control of your life right now, because the rest of you aren't as educated and smart as I am. You don't know how to run your life. I agree. I think it's insulting. It's insulting that she even had that attitude, and she was arrogant enough to sit on the witness stand and detail it. She was very detailed about how this is a bad plan. They don't know what they're doing. I checked her emails on the computer that she gave me because she didn't log out on that. So I'm watching you got your nose in everybody's business. I think Benjamin Franklin said it best when he said, "Just mind your own damn business." But yeah, you're right. It's disturbing how much she poked her nose in business, and it makes me dislike her quite a bit.
It's almost sociopathic. I don't care about anyone else. I care about what I want. And that's the only thing that matters.
Oh, no, 100%. Listen to her testimony. The only thing that matters is her. She is the most important. And I liked how she even insinuated that Carol was mean to her adopted child. I don't believe that.
Get the hell out of here.
She's mean
Was
to
her
her.
adopted child acting like a brat? Maybe that's why she.
Well,
Maybe
no,
Carol was
maybe.
like,
Yeah.
get him to stop that.
Yeah, but he just broke her heart. I just didn't treat him the same. Shut up,
No.
lady.
Yep. Wasn't relevant.
Look, man, I don't care what she needed from Carol. You go knock on the door and you ask for it. And if it's entitled to you, then you file suit. She's an attorney, folks. She's an attorney. She absolutely knew what she was doing was wrong. But she is shocked that she's being held accountable. I'm pretty pleased with it myself. But I say, and we're talking like this. This jury may come back and be not guilty. We agree that she is hand to the chest. She is just a caregiver at heart, and let her go.
I would be shocked. I would not only be shocked, I'd be disgusted and disappointed with that jury if that's how they found.
Well, and here's the thing. You know what? I won't be. I don't question jurors. They go back there. They sleep with their decision. We don't. They had no other distractions. They sat in there with a notepad and listened patiently through all the evidence that was given. And if they decide that they're not comfortable with convicting her, then I'll stand behind. I'll be honest. I will. I'll stand behind that. I think that that's just the way it ought to be.
Right.
Do
absolutely.
we want to hear the replay on the deliberations? I mean,
Well, why don't you go ahead and replay that, and that way, if people are sticking around, if they hear the judge come back, we won't have to call them back, right?
Yeah, we're going to let them, so we get they kill it for the day or they have a decision. But let's listen to the closing arguments. This is the state's.
Father's ashes, knowing the defendant couldn't attend, a line was drawn in the sand. The defendant did not communicate with Carol Mitchell from that date forward. On the evening of April 21st, the defendant couldn't sleep, and she was ready to take action. She wanted to take back whatever was left of her father's possessions. Getting these items back became her mission. Sometime around midnight, the defendant planned, packed, and dressed for her mission. She put on her best black ninja suit, threw in her pry bar, her muted flashlight, and even her special pair of flashlight gloves. She drove 220 miles to Detroit Lakes. Not even her own moral compass could deter her from her mission. Mr. Ringstrom summarized the issue for you to start this case. The defendant either entered to steal something, or the defendant entered to check on Carol Mitchell. The three things I asked you at the start of this case will lead you to the truth. Trust your eyes and ears. Do not get distracted. Use your common sense and good judgment. If you do these three things, you can be confident in a decision to convict the defendant. Now, during her testimony, the defendant admitted she said things to, quote, save her own skin. She also testified that sometimes you have to lie to protect people. And yesterday, you saw a fine example of that. Her testimony yesterday was carefully crafted to protect the one person that she cares the most about in this case, herself. Now, there is no doubt this began as a tragic family situation. Rod Mitchell's sudden passing was shocking and an ignition point to an already delicate relationship between the defendant and Carol Mitchell. Sadly, Carol Mitchell's Alzheimer's either slowed or hindered the turning over of Rod Mitchell's priceless mementos that the defendant wanted. However, disputes are settled in court now with crowbars, ladies and gentlemen. Remember, Carol Mitchell is not on trial here. The defendant and the defendant alone is on trial. And now is the time for you to decide the facts. And as tragic as this family situation has played out and how the defendant has handled it horribly, remember that you are not to be influenced by sympathy for her when you make your decision. I'd like to take a moment and walk through the elements and show you how the state has satisfied its burden to each count. Count 1, burglary, the first element. The defendant entered or remained in a building without consent. The defendant admitted that on the stand. She said, I didn't have consent. You can also consider her mode and manner of entry, the early time of the morning. Second element, the building was a dwelling. It's not in dispute here. It's been proven it was Carol Mitchell's residence, 709 Granger Road. Third, another person, not an accomplice, was present in the dwelling. Seen a plethora of body cam footage. You know Carol Mitchell was inside the residence that morning. Defendant admitted that element as well. The fourth element, the defendant entered or remained in the building, dwelling with intent to commit the crime of theft. It's the meat and potatoes of the case. Circle back to it. The last element, that this occurred on April 22nd, 2024. Admitted by the defendant, all sorts of evidence to that effect. Count 2, burglary tools. The defendant had in her possession a device or other instrumentality. You heard her testimony yesterday. She packed up that pry bar before she left Woodbury. Told you how she used it to pry open the egress window. Again, the second element, the defendant had the intent to use the device, the meat and the potatoes of the case. Circle back to it. And again, April 22nd, 2024. So with that, ladies and gentlemen, I'd like to talk to you about the many lies of Nicole Mitchell. You've all had to deal with people lying to you in your life. In order to catch people in lies, you have to focus on the little details. And when you do that, their stories begin to crumble. First, her overall claim of love and concern for Carol Mitchell. Enduring love and concern. Her aunts, the people that she trusted the most, how did they characterize this relationship? Well, Nancy Lund said they never had a stellar relationship. Cindy Markey said they never got along from day one. Two strong-willed women. It's your reason and common sense tell you, ladies and gentlemen. Second, the medical data. The defendant hacked into Carol Mitchell's My Sanford chart on the evening of April 20th. Never mind the fact that she was not authorized to view Carol Mitchell's private medical data, but whatever she saw was so concerning, so disturbing, that she waited over 24 hours to pack up her quote, welfare kit, and she told nobody. Third, the defense has repeatedly classified this as a welfare check. Now you've seen all the evidence, the time of night, the outfit, the tools. What does your reason and common sense tell you? Again, she was so concerned for Carol Mitchell that early morning, she did not call or inform anybody. Did not call law enforcement, did not ask for a welfare check. And remember, she had not communicated with Carol Mitchell since that fight on or about March 15th. And their last text exchange was a nasty one. Fourth, defendant testified that the neighbors knew her so well, she had to park on that side street. She couldn't risk being spotted. Didn't want them to notice her. Cross-examination, forgot their names. Don't know them. Fifth, flashlight gloves. Something probably never seen before in your life. Now, the defendant never really offered an explanation why those were in her welfare check kit. She just merely said they were bought for camping. Oops. Forgot to explain that one. 6, why latex gloves were packed with her. She testified that she wasn't sure what she would find. Implied maybe that she was worried about cleaning up feces. Does that make any sense? Did she pack any bleach, any paper towels? The defendant over-explaining things is a classic example of her lies. 7, her explanation of why she had to use the basement window. She testified, I had a key. Looked through the window and I saw the door jam device. But yet, she told you she packed that pry bar before she left Woodbury. Who packs a freaking pry bar? Just in case. Reason, common sense. 8, the defendant testified that she, quote, has a key for this house. There's no key that's been offered into evidence. The only proof of the defendant having a key is her testimony. This is convenient testimony by an admitted liar, ladies and gentlemen. Do not buy it. 9, flashlight had a sock on it. It was my child's. Continue to over-explain. You can check. I think his name is on it. Ladies and gentlemen, you can check when you deliberate. You can examine that flashlight. I couldn't find a name, but if you can. 10, defendant claims she was never lying next to Carol Mitchell's bed. Ms. Schotterhoff, can I have? I'd like to replay the 911 audio for you, ladies and gentlemen.
Somebody just broke into my house. Ran down into my basement.
What's your address?
I forgot. 709 Granger Avenue.
Granger Road in DL?
Granger Road. Yeah.
Inspector 30 car for active Berg, Granger. 37, party states individual broke into their house and ran down in their basement, 709 Granger Road.
I don't know if he's breaking out the back window or what.
Did you get a look at him at all?
No, it was completely dark. I tripped over him. He was on the floor next to my bed. He ran downstairs into my basement.
Okay. Can you hear him breaking out the window in the basement?
I'm not hearing anything right now.
Okay. What, did it sound like he was breaking something?
I don't know. Maybe the window's already open down there. There's a basement, a drop window that can crank open. I don't know. It's just here.
All right, I'll stay on the line with you. Don't worry. I have officers en route right now. If you hear anything, just let me know what's going on, okay? Are you armed?
I have a little steak knife in my hand right now.
Steak knife? Okay. All right.
I don't know where they could have. I don't see any, my yard lights haven't come on outside or anything, you know, the motion light in the back or anything.
Did you notice any vehicles or anything like that?
No, I haven't.
So it sounded like this individual broke in. RP got up and almost tripped over whoever's lying down inside the house before they ran into the basement. Okay, am I speaking with Carol?
Yes. I don't know what the hell's going on. Oh my God.
Did you hear anything at all?
No.
Well, what if there's any exits in the basement? There's a drop window. She doesn't know if he's got it open yet or not.
side of the house, yeah.
What's that?
Down on the back side of the house, yes.
Okay.
I just turned a small light on in my backyard, and I'm trying to look out over that window. And
Did you hear or see any vehicles drive away?
no, I haven't. I just heard something and I went downstairs now.
Female believes she's murdered.
Okay.
She believes she's heard something else in the basement.
Is that police?
There's officers that just came outside your residence, yeah. You just came in, I think.
Okay. Hold on one second. Janet, here. There's a shop window in the back side of the house, and I was going to he ran down there.
Okay, I'll go down there. You stay back here. All right, Carol. Yep. You can.
Should I hang up?
Yep, you can hang up.
Okay. Thank you.
Yep.
Then, ladies and gentlemen, a few days later, Chief Todd returned to Carol Mitchell's home.
Was in there, but it was just leaves and dirt. So,
While we're up here, could you show us your bedroom and where the person was that you stepped on?
yeah. It's down there. She was laying right here with her head.
Let me get up here with my body camera so you can describe it. Okay?
Okay, I sleep here.
Yep.
And she was laying right here. Her head was at that end and her feet at this.
Okay. Is there anything that you keep?
3 drawers under there, but there's
what do you keep in those drawers?
Socks, underwear.
Okay.
You know, I checked to see if there was any. This is just an empty box. I was checking to make sure that it's just, you know.
Okay, just.
But I did keep, for a long time, I kept my pistol.
Okay.
Here. And I'm sure.
So what you leaned up, you stepped out of bed, and you actually.
Something woke me, and I sleep with earplugs.
Mm-hmm.
So I couldn't figure out what it was that woke me.
Yep.
If it was a loud sound, or if what. So I just. What was that? And I stepped on, and I stepped on a body, and it moved.
Yeah.
And I went, what the hell? And I jumped on like this and grabbed, because I thought it was like a little kid or something. I didn't think it. And then when it was bigger, well, at first I thought, a man had broken in, but it was too small for a big man. So then I thought it was a little boy or some teenager got in or something. And then she shot out, ran out down the hall through the kitchen and down into the basement.
Okay. I'll follow you, ma'am. Thank you.
Basement?
So, and you definitely saw this person hang a left and go down?
I was right behind her. Okay. And I still thought it was a boy. I never, until you guys told me it was Nicole, I didn't know. Okay.
Carol Mitchell might be battling Alzheimer's, but this event will be something forever etched in her mind. She told the 911 dispatcher she stepped on a body. She told it again to Chief Todd. Again, it's the little things that prove lies. Then, ladies and gentlemen, we come to the testimony yesterday that she lied to the officers 4 times because she didn't want to upset Carol. Yet, we've heard from 2 defense witnesses, Nancy Lund, honest, trustworthy. Jay Brody talked about her raving reviews as a commander, her honesty, trustworthy. Then we look at the context of the defendant's testimony yesterday. She said she was very stressed out, never had a gun pointed at me before. Yet she wants you to believe that she was capable of this quick lie, this plan, because she didn't want to upset Carol Mitchell. I encourage you to review the defendant's demeanor on the body camera footage. I submit to you she was telling the truth on April 22nd, 2024. And if you believe that she was telling the truth to the officers, then you know she had the intent to steal. She told you. She told the officers. Again, maintain number 12. She maintained that the lies to the police were so she didn't upset Carol Mitchell. But yet you look at her statements, many of them are after she's separated from Carol Mitchell. Back of the squad and at the jail. Then, ladies and gentlemen, number 13, we turn to the defendant's elaborate story of what she did in the house. Remember all the things she checked on, the important kitty litter box and deep freeze inspections that justified this home break-in? We're going to play Officer Wolthy's body cam for you at about the 21:35 mark.
What's your name? Nicole. Okay. Are those laptops in your backpack yours?
Yes.
Okay. She's saying she's missing 2 laptops.
I mean, I can show you one. It's got my kid's Minecraft game on it.
What's the other one for?
I have one for work.
Okay. And then she's saying something about tin box. That was a question. It was in question last time. So.
I literally had just got in the house. I hadn't had time to do anything.
Okay. All right.
I'm clearly not good at this, but
yeah. So, sounds good.
Again, she
hadn't had time to do anything. Again, another classic over-explanation. Item 14, regarding the checklist in her backpack. She testified that delete texts and contacts actually means that she wants to make sure Carol didn't delete people from her phone. That's her checklist, her shorthand. Another over-explanation. What does your reason and common sense tell you? I'd like to circle back to the most important issue here, the defendant's claim that she was lying to the officers on April 22nd. Ladies and gentlemen, don't forget, she's had 15 months to think about this and prepare for her testimony yesterday, to craft her story around the evidence. Officer Sternhagen is a highly trained officer, and I submit to you he would have noted deception by the defendant. Defendant's spontaneous and truthful statements to law enforcement on April 22nd, 2024 are extremely damning to her. So yesterday she had to come up with a story. What the defendant said in those tense moments after being detained by the police is the truth, period. She said she was there to take items, and that readily proves her intent to commit a theft. I ask that you find her guilty. Thank you. What they say is related
to the context of the situation. Mr. Brody testified to this morning. When we search our own consciences, when we know that we are fundamentally honest people, we all know that we have told white lies. Nicole Mitchell, a month ago, told a white lie to her children because something terrifying happened, and she did not want to terrify her children. Does that call her character into question? The thing that she said to those kids was not true. But she said it because if she had told them the truth, it would have caused a trauma that few children would ever experience. At the beginning of this case, before opening statements, when we were asking you questions to determine who would sit in this jury, one of you being questioned was asked about Alzheimer's patients. And she told us, and she told you, in her experience, that sometimes you say things that aren't true so that you don't aggravate the situation. We all know the difference between a white lie and a meaningful, damaging one. The problem is that this happened in the context of something that was a terrible mess. A mess that Nicole made, but it was a mess. And the state wants you to fixate on that because the actual evidence in this case is contrary to what they want you to believe that those white lies were about. And let's really think about what the state absolutely needs you to believe. The state needs you to believe that Nicole Mitchell, a person who has spent 30 years in the military, a legislator, a mom, a lawyer, and a daughter herself to two separate moms, each with Alzheimer's, would drive 3 hours to take a shirt that had already been promised to her, that she would throw away her entire life for some things she knew she was going to get anyway. If somebody believes she was there to steal, she never would have left the basement. That's where Rod's things were. If somebody believes she was there to steal, she never would have gone upstairs. Going upstairs means welfare check. The state can't have it both ways. The moment you understand the real reason she was there, the welfare check, Nicole's white lies make perfect sense. And the state has focused on things that are not relevant to the accusations in the instructions. That Nicole Mitchell exercised poor judgment about how she did the welfare check. She told you as much. That's not a crime. The state wants you to feel bothered by that and create the illusion that somehow that's a reason to convict her of these crimes. She's not charged with lying. Once Rod Mitchell died, no one else on the planet knew Carol Mitchell truly better than Nicole Mitchell did. And she knew that Carol was deleting texts and isolating herself from people who cared for her. I resent, and I think you should too, that some of the testimony about how Carol and Nicole Mitchell had an acrimonious relationship somehow means they don't love each other. Has anyone had an acrimonious relationship with someone they love? Is that really beyond reason and common sense? I suspect if you on the jury are like most of the rest of us here, most of your most acrimonious relationships are with people you care about and people you love. It's because the love binds us, and sometimes we don't get along. So what? One thing that is often true about a prosecutor's case, when they don't have the right facts, they will misstate the law and ignore the facts that create reasonable doubt. The state told you to use your common sense. The expression common sense is in the instructions the court gave you. But the standard is reason and common sense. If we use pure reason, we look like logic robots and we can make silly mistakes. If we use pure common sense, we activate our biases. The other set of instructions that you were told you about. You must use both if you are faithful to the instructions the court gave you. Do not let the state deceive you from that. Sergeant Glander testified that you cannot ascertain a person's intent from damage to the window. He agreed that a point of entry of the window could be consistent with other things, trespassing, damage to the property. You can't ascertain a person's intent from that. Now, there was testimony from 2, possibly 3 state's witnesses, law enforcement officers, about the mistakes that they made in the investigation. And the implication was that everybody in this case is to get grace except for Nicole Mitchell. It's okay that law enforcement makes mistakes. We are fallible human beings. It's not okay if those mistakes cut against the citizen accused. And let's be really, really clear about this. There is only one side being tested here. There is only one case here. It is the state's case. And there is something that criminal defense attorneys who protect people's rights are always afraid of. That when they call witnesses, which we don't always do, that it creates the illusion in the minds of the jury that there's a case here and a case there, and that we have to prove something. We have to prove nothing. Every piece of evidence that we brought up, whether it was through cross-examination, which is evidence, whether it was calling witnesses, whether it was introducing an exhibit, is solely to do one thing, to point out the reasonable doubts in the state's case. There is only one case here. That is what you are here to evaluate. The state decides what charges to bring. They decide what tests they're going to take. It is such an important test that the standard is extremely high. And the way they have to pass the test is by meeting the standards imposed by multiple parties. The court obviously has a special role, and you will get a copy of the instructions. These show the exact standards that the state has to meet to pass this test. The defense is tasked with pointing out every single mistake that the state made. And the jury is tasked with judging every single piece of evidence, deciding what weight to assign to every single piece of that evidence, including no weight at all if the jury decides that. Looking at every single reasonable doubt that the defense points out and finding reasonable doubts on their own. The fact that I may not talk about a reasonable doubt here doesn't mean it doesn't exist. You get to investigate and find your own. And that is part of your professional charge here. That is professional. It's part of your obligation here to find those reasonable doubts. What has the state spent the most time trying to prove? That Nicole Mitchell came up in the middle of the night. That she wore dark clothing and a black cap. That she parked on a side street. And that she came in through a window. That's the how, which we know and basically everybody agrees on. But the state has, in my estimation, pretty shamefully tried to convince you that the why doesn't matter, that the intent can be ignored. But the intent is everything. Now, before I get into an argument, my argument for you, we're going to talk about some of the reasonable doubts that are clear. Carol Mitchell is clearly and obviously struggling with Alzheimer's. It would be an act of unkindness and unhelpful to go through it in any aggressive way. It was clear from the beginning. It was clear based on what Jonathan Keel said that Rod's death really set it off. But I want to talk about a few of them to make sure that we remember that this really is a problem, that this really was something that Carol's struggling with. And some of them are little. Carol says it's a lavender pry bar. It's very big, but of course in reality, it was much smaller and blue. I had never seen that before in a trial in my career. This woman who's doing the best she could literally says that's not the crowbar. Carol testified to you that Rod Mitchell died in 1993. That is the kind of mistake, literally a generation apart in terms of when he passed, that attests to the deterioration. Nicole Mitchell was not added as a contact in Carol Mitchell's phone until March 10th, 2024. This is exactly what Nicole Mitchell feared. That Carol Mitchell deleted texts and deleted contacts on her phone. We know this for a fact. There's text messages introduced that show they had communication. Special Agent Vic Mark testified that when he looked at Carol's phone, there were no text messages between Carol and Nicole. It's just patently mistaken. We know that they were there. And this raises a mistake, a scary mistake, a mistake that endangers Nicole Mitchell's future, that they did not extract that phone. Special Agent Vic Mark testified that he had Carol Mitchell's phone, but he didn't do an extraction. He never even testified whether he asked her if he could do that. So we don't know all the exchanges. We don't know whether she'd been scammed. What we do know is what Nicole Mitchell experienced through her exchanges with Carol Mitchell, through her exchanges with people that are close to her. And the evidence has shown that nobody is actually deeply taking care of Carol Mitchell. It is poignant to me that if you were to talk to Carol Mitchell and you didn't know her and talk to her for a minute or two, she would seem like a completely put together human being. That it takes time to see the breakdown. It takes time to see the forgetfulness. Pam Muxfeld wasn't really taking care of her. Pam Muxfeld didn't see it as a big deal when Nicole contacted her. Pam Muxfeld testified to you that in her estimation, it wasn't quite what other people thought. Jonathan Keel hadn't taken her to medical appointments. He lives in the cities. Mr. Jim Headland, the friend of the late Rod Mitchell, he made a commitment, a promise to help her, but it was clear from his memory, from his abilities, he wasn't in the position to genuinely help her. Dee Lindholm, Pam Muxfeld testified that her mom, Dee Lindholm, was too old to be power of attorney, much less manage someone else who was struggling with Alzheimer's. And certainly not her neighbors or friends. I have a duty for someone who's a neighbor or a friend to take up for someone. Another reasonable doubt is that Nicole clearly believed in her heart that Carol was struggling. We have seen this evidence. We have seen that no one was stepping up for her. It is a misrepresentation by the state. He misrepresented it in his cross-examination of Ms. Mitchell yesterday. I submit that he misrepresented it in his closing today. That Nicole didn't express concern about Carol Mitchell's paranoia or Alzheimer's when she was in custody for that period of time. Nicole Mitchell does tell Officer Sternhagen about Carol's paranoia. Nicole Mitchell does bring up Alzheimer's repeatedly. It does come up. We expect state witnesses to tell the truth and to tell the whole truth. And it is problematic when every single law enforcement officer who testified on direct did not admit that Nicole Mitchell had none of Rod or Carol's belongings until after I asked them that question. That is a fact that should have been readily presented to you straight away. It should not have been hidden from you. Nicole Mitchell didn't have any of these possessions. And I ask you, when you go back and you're deliberating and talking, these other things about a laptop, which we know had nothing to do with this. The bobber, which wasn't there, had already been sent to Nicole. These other things, they're not part of it. But Nicole Mitchell didn't have any of these things. Every law enforcement officer said, well, one, they were all reluctant to testify about it. I didn't see this, I didn't see that. There were no piles of items or mementos staged by these windows. There was no bag of anything. And there were certainly none of these things in Nicole Mitchell's backpack. Just keep coming back to the basement. That's where Rod's stuff is. Why on earth, if somebody intends to steal something, would they not just do it and leave? The state needs you to ignore that. Nicole Mitchell says, I'm clearly not very good at this. Clearly. She's not. She failed to help to get Carol the help that she needs. If Nicole Mitchell had been good at this, she would have been able to take pictures. She would have been able to document things make good notes. She would be able to make sure that Carol Mitchell's location was known to the other people who actually lived in the area. So at least that they would have been on notice. We know Nicole Mitchell wasn't good at this because Carol doesn't understand what's going on, and no one is fully helping her to this day. When Carol Mitchell testified, she was being asked very simple questions, very easy questions. You may recall she was searching through the courtroom for answers, and the judge did have to remind her she wasn't able to do that. She's not getting the help she needs. The note that the state lost, but fortunately was preserved in a flash on a body camera. The note shows what Nicole Mitchell intended to do, and it shows that she was right. Checking for deleted texts. She was right. And nothing on that note says anything about the state's claims of intent. Can you imagine if that note had said, go find a shirt, go find mementos? Good Lord, that would be the whole case. The note shows Nicole Mitchell's intent to go check on Carol Mitchell. And in the context of all this relationship, this strained relationship, her love for her stepmom, a love for her stepmom that was different than the love for her own biological mom. She was also loyal to Carol Mitchell because Carol loved Rod, Rod loved Nicole, Nicole loved Rod. It was entangled. She was loyal to her dad and by extension loyal to Carol, above and beyond her loyalty to Carol Mitchell. Jonathan Keel really seemed to struggle to testify about a lot of things. He actually didn't remember a conversation he had had just a few weeks before with an investigator. I mean, a few weeks before this trial. But he did tell Sergeant Glander, and Sergeant Glander put in his report, there was never a disagreement and that Carol had been holding items of Rod's for Nicole and her boys, knowing that they would want those items. So let's think about the only item that really seems to be at issue here. The flannel shirt. The flannel shirt was hanging all by itself. The flannel shirt was hanging by itself with a bunch of other clothes. The flannel shirt had not been taken off. It hadn't been crumpled up. It hadn't been put in a bag. It hadn't been put by a window. It was hanging there. Nicole Mitchell had wanted that shirt. That would have been a pretty easy thing. She turned the lights on. She went in the house, used the bathroom, and turned the lights on. It would have been so easy to take this shirt, and it wasn't touched. When we think about intent, let's think about the facts. There's an expression in the military that we don't rise to the circumstances. We fall to the level of our training. That's why the more specialized someone in the military is, the more training they need, because when things get crazy, you've got to be able to think clearly. Nicole Mitchell intended to check on Carol Mitchell, and of course, everything exploded. And it was her fault that it exploded, but it exploded. And law enforcement was right to deploy their firearms. But that doesn't change the fact that that's a traumatic experience. When Correction Officer Eric Scott testified, he said that Nicole Mitchell at the jail So this is like 40 minutes later. Did not seem to be intentionally uncooperative, but more seemed to be able to not be able to focus on the directives given her. This is a surreal experience for Nicole Mitchell. You can blame her for causing the circumstances. It is surreal. The state's really fixated on this finger flashlight. I've always thought of it as a silly thing. It's not a flashlight I would want to buy. I want to talk to people, and they think it's a perfectly good idea. She said she had it for camping, and importantly, it is absolutely in evidence it was purchased before Rod Mitchell died, like February of 2023. So we're literally talking about a year and 2 months before this incident. So it looks fancy, it looks weird, it looks specialized. It's just a thing she had. She brought 2 flashlights. She brought this flashlight. She brought this flashlight that has a sock on it that's held there by a rubber band. This is not my exhibit. I've never been able to touch this flashlight. But Mr. McDonald invited you to look for her son's name under the sock. It's his exhibit. Do it. Do it. As we talked about, it is okay that law enforcement make mistakes sometimes, but it's not okay to hold those mistakes against the citizen accused, against Nicole Mitchell. The state didn't secure the backpack. They didn't secure the keys. They didn't secure the note. The state wants to hold it against the citizen accused who can't execute search warrants, who can't seize things, who can't find records using government power, that she doesn't have these things. It is the state's responsibility to preserve evidence. We talked about this a little bit, but let's really go through it. In the 37 minutes between when Nicole Mitchell has law enforcement contact and when she gets placed in her cell, she knows that law enforcement is going to keep talking to Carol and telling Carol Mitchell what Nicole Mitchell says. Why does she know that? For the same reason you know that. Because we have body camera videos where Carol Mitchell is literally milling around this situation. Carol Mitchell and Nicole Mitchell are having a dialogue. It's going back and forth. Nicole Mitchell knows very well that whatever she says to law enforcement is going to get back to Carol Mitchell. You can see the officers going back and forth inside and outside the house. Nicole Mitchell tells them the truth in that moment, and Carol Mitchell will find out. She has to maintain that white lie to protect Carol Mitchell. As somebody who is a criminal law practitioner, I know very well that alleged victims don't drop charges. Doesn't work that way. Does not work that way. That is a sentiment, a feeling that a lot of people have. Maybe it's from TV, maybe it's because it used to be more common in years past. Nicole Mitchell believes that Carol Mitchell can drop the charges. And she still believes that telling this white lie about these things is the right thing to do until she is in the jail. And the officer, when she asks, can she drop charges? The officer says, that's not a thing. If you watch that video again, that is the moment, that is the instant Nicole Mitchell stops talking about it. That's the instant she realizes that this family spat, that this confused mess that she created is not going to go away when Carol Mitchell realizes what's going on. When she realizes that this white lie is not going to do what needed to be done, it's not going to protect Carol Mitchell, it's not going to protect her, it's not going to serve the interests of anyone, she's done talking. And she had a personal experience about it. She knew from personal experience that people can drop charges. It's problematic in a case like this when the state uses its power to get pieces of evidence that tell part of the story, but not the whole story. That tell part of the story that they want, but not the story that the jury deserves. That there was a search warrant for what they call the audit log of Carol Mitchell's Sanford My Chart, but not a search warrant for Carol Mitchell's medical records. Nicole Mitchell testified to what she saw on that Sanford My Chart account. And that is absolutely unrebutted testimony. The state failed to get those records. They failed to let anyone in this case see them. And the evidence that we have is the evidence that came in through Nicole Mitchell. I'm embarrassed to admit this, but someone pointed out a reasonable doubt to me that I hadn't thought of, which is that Nicole Mitchell had been to this residence like at least 5 times following the death of Rod Mitchell and before the incident. 5 times. She was down in the basement to reprogram the television. First to set up the Roku, and then to reset it and put the DVD player, install the DVD player with the television. 5 times where opportunities to retrieve these things would have been so easy. Carol's not remembering much. The state wants to impute this bad intention, but also impute this sophistication. If that was a person's intention, why on earth wouldn't you just do it when you had permission to be there in the middle of the day when Carol Mitchell wouldn't have noticed when you're downstairs? This is evidence against this intent claim. This is a doubt based on reason. We will talk about what a real reasonable doubt is. But any one reasonable doubt as to the element of intent is enough. We need to keep exploring for each and every one. As I said, you are entitled to assign any weight to the state's evidence, including no weight at all. You can evaluate it within its context. The reason we have reasonable doubt is actually not what most people think. Reasonable doubt exists to protect a jury. You are here to evaluate whether the state has met this extremely high burden. And by being subject to this extremely high burden, they have to prove to you that every single doubt based upon reason is ruled out, that there can be no doubts based on reason. And why? Because a jury who is sworn to sit in judgment of another human being has to live with their verdict for the rest of their lives. That is the main reason for proof beyond a reasonable doubt. We are glad, we as a society are glad that proof beyond a reasonable doubt protects citizens accused, that only those where the burden has been met can be marked with that guilty conviction. But its core purpose is to protect the jury, because the weight on a jury of a wrongful conviction lasts forever. 18 years ago, the 35W bridge collapsed down in Minneapolis. It was a pretty new bridge. It was designed with modern techniques and modern materials, but it had a structural weakness. It was a structural weakness that would have been easily noticed if the right people had thought about it. It was always a deficient bridge, but no one fully noticed it until it was too late, and 13 people died. A prosecutor's case is like a bridge. If there is any reasonable chance that the structure could fail, then it has to be scrapped. It doesn't matter if it's mostly good. It doesn't matter if it looks good. It doesn't matter how much it cost. It doesn't matter whose reputation is on the line. It doesn't matter who desperately wants you to believe that the bridge is sound. If there is any reasonable question about its integrity, then it should be scrapped, because the stakes are just too high. However, when a faulty criminal case is built by the state, and they have convinced a jury that their faulty case is really good, that mistake usually sits silently. It sits silently with the accused, who knows the truth, but is left to sit alone for years with its weight. The mistake also sits silently with the jurors. Because as much as the state wants to make this about Nicole Mitchell, it is not. It is solely about whether the state built a bridge so absolutely sound that they eliminated every single reasonable question about its integrity. So much that we would send our children and family across this bridge. Now, you're not bridge builders. You are inspectors. How does it feel to be an inspector who confidently thought the bridge was sound, only to see people fall to their death? Jurors in the past sometimes didn't listen to reasonable doubts and convicted, only to learn years and sometimes decades later that a human being's life was taken away by a wrongful conviction. How do we know this? We know it for a fact because of what are called DNA exonerations. Those defendants looked guilty. They looked guilty to juries just like you. Some of those defendants testified and were made to look inconsistent by prosecutors. Some of them even falsely confessed or had the meanings of their words twisted by the state to look like a confession. But the jury used their common sense instead of the reasonable doubt standard, and they convicted. You see, that's why it doesn't matter how much evidence the state piles up. A doubt based on reason and common sense is the way to avoid this. And that's why the reasonable doubt standard is so crucial. Those defendants who were exonerated looked guilty to those juries, because those juries sat in a courtroom where endless state witnesses piled things on and made the accused look as bad as possible. Problem is, and this is where we talk about some of the instructions. If all you have to use is common sense tells you where there's smoke, there's fire. When you combine reason and common sense, then you have to rule out the possibility of dust or fog, or the smoke came from somewhere else. When you combine reason and common sense, the government has to rule out the reasonable possibility that Nicole was checking on her stepmom, that she's may have even seen things of her dad's and ignored them, that she was focused on making sure Carol's phone was functional so that she wouldn't get lost and experience a tragedy. You can tell when the state wants you to ignore reasonable doubt because they will sneer at the defense and imply it's ridiculous. If they could rule out all the reasonable doubts, they would calmly do so. This decision is a decision that you cannot take back. There are two ways for a state to prove a case such that a jury is to find them guilty. They can prove beyond all possibility of doubt, and that is instructed to be guilty. Or they can prove beyond a reasonable doubt. And the court also instructs a jury to find them guilty if it is beyond all reasonable doubts. But anything less than that is not guilty. This is not like college. This is the toughest test in the legal system. Yes, it is hard to prove this. Why? Because of the effect on the jury and effect on the citizen. We do it this way because this is how we put a check on the state, a check on the government. Whether any of you think this is unfair, this is the way it has been for a very long time. And the danger comes when people don't take it seriously. Because as we talked about before, when there are reasonable doubts, there could be wrongful convictions. This is what it looks like. The state should always want to take up that burden. Let's talk a little bit about burglary and burglary tools. The state asks you to consider why Nicole Mitchell had the pry bar. She told you, because the screen door was sticky. She already admitted she was going to go in without permission. And she said that it actually bent when she kind of had to pivot and do this other thing in the basement window. The defense is always afraid when there are two charges like this, because a jury might want to split the difference and give something to the state, something to the defense. But as the burglary accusation goes, so goes the burglary tools accusation. Where there's no intent to steal, where there's reasonable doubt as intent to steal, there's no burglary. And where there's no burglary tools. As you look at this case and realize that there is reasonable doubt as to intent as to burglary, this pry bar is just a pry bar. Again, they could have, charged Ms. Mitchell with anything that they wanted. with anything else related to this problem. But when she is not guilty of burglary, she is not guilty of burglary tools. As I wrap up, I am reminded of something that Nicole said yesterday about an exchange that she had with her family, and I think it was in December of 2022. I didn't remember this. Some of you may have. That an elderly woman with some dementia got lost here in Detroit Lakes. And a state trooper figured out, he heard it on dispatch, and he immediately came back. He wasn't detailed to it. He just decided to check, and he kind of used his investigatory ability, and he found this lady in like November or December sitting on the riprap on the side of the lake, getting close to freezing to death. When we hear these stories, when we experience these tragedies, they resonate with us. They stick inside us. They shape how we behave. As a peacetime veteran, I can't help but having reverence for combat veterans like Officer Sternhagen. It's just wired into me. Nicole Mitchell feared the loss of people in her life. Those stories stuck with her. They shape us. The good things shape us, the bad things shape us. And with that cascade of tragedy and terrible news stories about near misses here in our community, it makes sense that she was so activated by all this. One of the hardest things for some juries to accept is that the questions the judge needs them to answer aren't really the questions they want to answer. Maybe you want to answer questions that aren't in front of you. Sometimes juries kind of wish they were more like a TV judge, like Judge Judy. You hear everything, you look at all the evidence, and you decide you did this right and you did this wrong, you did that right and you did that wrong, and I'm going to give you this and give you that, and this is what I'm going to order. To kind of put it all in a ball and fix it. You haven't been given that choice. You haven't been given that choice. You haven't been given the opportunity to decide what should happen because Carol Mitchell was justifiably terrified. You haven't been given an opportunity to decide how much Nicole Mitchell should pay for that window. You haven't been given an opportunity to decide what should happen to Rod Mitchell's shirt. You haven't been given an opportunity to decide how Carol Mitchell should be cared for. But you should feel comfortable knowing that your job in evaluating the state's work here, it still allows other disputes, other courtrooms, and other places. This job, the job that you have been given, is beyond important. A criminal jury is one of the only political bodies, and that's what you are. You are an assembled political body here to evaluate the state's work and decide whether it met the very high standard that we have had for hundreds of years. And once you are done, you as a political body will dissolve and you will have executed your duty. Yes, it is a heavy weight. It is extremely important. When you are deliberating, if one of your fellow jurors says, well, she said she was there for some of her dad's things, so she must be guilty, remind them that the state is required to rule out any other possible purposes of those statements. It is not our job to prove the opposite. This is the state's case. It is our job to show you the doubts, and it's your job to apply them to the state's case. The state doesn't want you to look at their bad facts. That's why none of the state's witnesses admitted on direct that none of Carol or Nicole Mitchell's stuff was found. Carol or Rod Mitchell their stuff was found with Nicole. You know, not guilty verdicts actually serve the state very well too. It is a crucial reminder to the state to do better, to choose carefully what criminal accusations to make, to think clearly about what justice is and how it is rendered. Ladies and gentlemen, there will be more cases. We, as citizens, want the right cases brought. We want them to be prosecuted in the right way. Not guilty verdicts tell the state to try again and do better. And that is important. This is my last opportunity to speak with you. In a minute, I'm going to hand Nicole Mitchell over to you. And I won't be able to do anything else. The state gets an opportunity to come up here and tell you a completely different story. And if that happens, I want you to be thinking about your responsibility. Why isn't he ruling out every single reasonable doubt? Now, both the possible verdicts on the verdicts forms are framed in terms of guilt. That's what the chart was about. Guilt is proven beyond a reasonable doubt. Guilt is not proven beyond a reasonable doubt. There is no third verdict that you will see. There is no third verdict form for innocence. It's not a question here. If somebody brings that up, please remind them. Did the state prove guilt beyond a reasonable doubt or not? You don't have the third choice, not in our system. The state needs you to believe that Nicole Mitchell would throw away everything, that she would throw away her career, that she would throw away her family, that she would throw away her ability to be a foster mom for a shirt she knew she was going to get. As we discussed at the beginning of this case, unless the state's evidence can rule out that Nicole Mitchell entered just to check on Carol, then the verdict must be not guilty.
Well, you have been watching our continuing coverage of the trial of State Senator Nicole Mitchell happening in Becker County Court in Detroit Lakes. She's facing 2 felony charges of burglary, and the other one is possession of burglary tools for an incident back in April of 2024, in which she was found in her stepmom's home in Detroit Lakes. And on the body camera video that we saw during this trial, she said she was there to get a few things, but now in the defense at her trial, she said that was just a cover story to not upset her stepmother, that she was really there to do a welfare check on her because of her Alzheimer's condition. And she thought that would upset her stepmother. So she said something else, which is why she's facing burglary charges, the intent to take items out of the home. And without that intent, then it's not burglary. The jury got the case at about 12:30 today and are in deliberations now. They began Monday, the case did, with jury selection. Testimony began Tuesday, and opening statements Tuesday, then testimony. Testimony wrapped up this morning, and then closing arguments, which we've been watching the replay of. And again, now deliberations for these 2 felony counts. Again, this has been big news in the state of Minnesota because of her role, her position as a state senator, a sitting state senator, and it turned into some political tug of war last session, and certainly this session, where with the 1-seat majority for the DFL, GOP, there was a big push that she should resign because of the charges. Others were defending her that she should resign only if convicted. And again, a lot of politics playing into that. Well, now we're on the verge of finding out whether she's going to be convicted or not. Again, the jury out for just about 2 hours. And so while we wait to see if we do get a verdict today, and again, it can be hours, sometimes it can be days, although only 2 counts to consider here. We're going to keep hanging out. We'll bring that verdict to you if it happens yet today. In the meantime, though, we are going to replay part of Nicole Mitchell's testimony in her own defense from yesterday. She was on the stand most of the day. And particularly what we're going to show for you now is the last bit of that, where she was being cross-examined by the prosecution about the explanations that she was giving for why she behaved as she did, was dressed as she did, why she said what she did on the body camera videos, etc. So we're going to play back now her cross-examination from yesterday afternoon. And if there's a verdict, we'll get back on here right away to let you know that. So here's the cross-examination from Thursday.
I had to lie to Carol a lot that year about things. I had to lie to my kids last month when there was actually something really scary happening at our home and I couldn't tell them what it is. So I know it might be hard to believe, because when it comes to family and protecting them, sometimes I have to make a choice I wouldn't otherwise. But I am a person that acts with integrity. I am a person whose word means something. And I'm not someone that would steal.
I have no further questions, Your Honor. Mr. McDonald. Good afternoon, Ms. Mitchell. Save your own skin. That's what you testified to?
If I use those words,
Well, Mr. DeCray asked you and you agreed, is that correct?
Yes.
Okay, so how do we know you're not saving your own skin right now?
I think I just explained that.
Ms. Mitchell, you were with Officer Sternhagen for roughly 37 and a half minutes. Would you dispute that?
adding in the drive time that was edited out of the video.
If that was the officer whose car I was in, I don't remember all the names. I would not dispute that.
37 and a half minutes from the time you were ordered to the ground till the time you walked into that cell. You understand that?
Yes.
0 times in 37 and a half minutes did you mention you were there out of concern for Carol Mitchell. Zero times. Do you agree with that?
I would disagree.
It's a yes or no question.
No,
You don't agree with that?
I do not.
Okay. 0 times you mentioned anything about medical information, finding out medical information.
I agree with that.
Let's back up a little bit. So, Ms. Mitchell, you agree here that you did not have consent to enter Carol Mitchell's house that morning.
I absolutely agree.
And that morning, I mean April 22nd, 2024.
I agree.
And here in Becker County, 709 Granger Road.
I agree.
And you agree that Carol Mitchell was indeed inside the residence when you broke in,
I agree.
that she was present.
I agree.
I'm going to bounce around a little bit here. So you did not object or contest the estate, correct?
I did not.
Your father's estate,
I did not.
and the entire estate was awarded to Carol Mitchell.
It was.
And you heard the testimony yesterday, correct?
Yes.
Your aunt Nancy,
Yes.
she testified that you, in her opinion, you were honest and trustworthy.
Yes, I heard that.
And you just told us that you act with integrity and you believe you are an honest person.
I qualified some exceptions, but generally, yes.
But you also obviously admitted to lying, claiming to be lying to officers repeatedly.
Yes.
So Mitchell, I want to circle back to the internment argument. Or could I publish defense exhibit? I don't remember the number. 243 and 248. So Ms. Mitchell, sorry, I just lost the exhibit. All right, I'm just going to ask you, you read those text messages?
I had.
Okay. I'm done with the publishing, Your Honor. If I could take down the. You understand that the Carol Mitchell's initial text that started all this said that they are going to call me. She thought it would be April, but they are going to call me.
I can't see it, but that sounds correct.
Is it? And then when she informed you later on in the other exhibit, which
we're more than happy to help you get the exhibit up, Your Honor.
we'll just fast forward. Is this 240?
We're looking through the electronic system right now. It's both gray. It's double gray. They're little small windows, Your Honor. They're hard to see. 1 second, please. 253.
253 of publishing, Ms. Mitchell.
Clerk catch up here.
Ms. Carol Mitchell tells you that, quote, David Donnerhauer funeral called me, correct?
Yes.
And so I guess my question is do you believe with, all the situations you've given us and presented us with the history, do you believe that it's possible that Carol Mitchell thought this had to be the day based on the tenor of the conversations from the funeral home?
Yes, that's why I called them to confirm and then told her that it could actually be other days.
And I'm not discrediting the pain that you felt, Ms. Mitchell, I assure you. I'm merely asking is, do you agree this was the disease that caused this miscommunication?
Yes.
So Ms. Mitchell, you walked us through somewhere around the nature of 4 years of history and examples and progression of Carol Mitchell's Alzheimer's. Would you agree with that?
Yes.
Roughly. And then we had the argument over your father's ashes, the internment.
Yes.
And you said that you were upset and, quote, needed a break.
Yes.
And you agree you did not call, see, or text Carol Mitchell until you were in her house on April 22nd.
Yes.
Let's talk about the medical information. So first of all, who gave you permission to access Carol Mitchell's medical information?
I did not have permission.
And you, on April 20th, you read something that was very concerning to you.
I did.
It was so concerning that you didn't tell your aunts? Yes or no?
I did not.
You didn't tell Jonathan Cool?
No.
Didn't tell Pat Muxfield?
No.
Didn't even try to reach out to Carol?
No.
And so you specifically arranged for your stepfather to watch your children?
Yes.
Okay, and so when you were arrested, that created a little bit of a problem in terms of getting back on time?
Yes.
And so your biggest rationale for what you characterize as deceiving, lying to law enforcement is that you didn't want Carol to get upset with your statements.
That I thought if we calmed it down, she would drop the charges.
Sure. But the problem with that story is that you were with the officers much longer outside of her presence than with her presence, right? And you continued the story. You repeatedly said you were there to take your dad's things, even when Carol wasn't present. Correct?
Correct.
So when you said, I have never done anything like this, was that fact or fiction to the officer?
Fact.
Okay. When you said, you're going to find out I'm a military commander, for God's sakes, is that fact or fiction?
Fact.
Okay. What was the purpose in telling him that?
I think that's when it was dawning on me that, just any interaction with police, I would have to tell. And also, I think it was just like, I'm not this crazy person.
And you said that, and that was a fact.
That was a fact.
That was the truth.
Correct.
And intertwined with that same sentence, you said, there's just a couple of my dad's things I came to get. So you were able to, on the spot, think to craft a lie mixed in with something truthful.
Correct.
Well, you're an honest person, correct?
Typically.
When you said, I'm hoping this mistake won't completely fuck up my life, were you being truthful or deceitful?
Truthful.
How about when you said, I know I did something bad?
Truthful.
Truthful? Brutally honest?
I had scared Carol out of her mind. That was horrible.
So checking on a loved one is something bad?
The part that was bad was the fact that I was doing everything in my power to not upset her and escalate it, and I ended up doing the exact opposite.
And I just wanted to get a couple of my dad's mementos, and that's all, in the back of the squad. And that was a lie. That's what you're telling us here today.
Yes.
Such a lie that you were able to come up with the next sentence and say a couple pictures and maybe one of his flannel shirts. You were able to spin that on the spot and come up with the items.
Those were actual items I had wanted.
You did want them.
They were items I had wanted at points because I also said the ashes. And I believe I had taken that particular question as what things had you wanted, because I included the things I'd asked for to include some things that didn't exist anymore.
And then later on, when Officer Wolfe questions you in the back of the squad, asks you about the laptop, you went out of your way to say, I just wanted to get a couple things before anything else gets destroyed. And you were able to spin that on the spot?
I don't recall saying that. But
If it's on the body
yes.
camera, would you agree you said it?
If it was on the body cam, I would agree.
Ms. Mitchell, I'll have you back up a little bit further away from the mic. Thank you.
So when you were asked what got you to this situation, you said the ashes. Was that truth or fiction?
So when I watch it,
Just pick one, please. Truth or fiction?
I was talking about to the point of the check, and that was truth.
Now, you elaborately, eloquently described all the things you did in the house after you broke in with the crowbar. Is that fair to say?
Correct.
Okay. Yet, when you were questioned in the back of the squad, you said, I had literally just gotten into the house, hadn't had time to do anything. Clearly, I'm not good at this. You recall that?
I do recall that.
Okay. So, again, just a brilliant lie you were able to craft under the pressure of being arrested.
The other officer had just, I believe, asked me, I had to kind of watch the body cams to figure out why I might have said that. Had just asked me, did you drive down? Did you stay at a hotel? And I was very confused. And then the other officer, I believe, then asked something about the timing. And I think I believed he was still kind of asking, like, if I'd driven or stayed in town. And so I was kind of conflating those two questions. But
I had literally just gotten into the house. There's not much room for interpretation there, wouldn't you agree?
Yes.
And then finally, before you're put in the holding cell, Officer Sternhagen asks you if there's anything else you want to add. And then he says, what made you so you got to do this or whatever? He said, something that's weighed on me, especially this past month, a lot of sleepless nights, couldn't sleep and thought about it. Truth?
True.
Military issued pants you had on?
It was a long underwear set that I bought at Target.
And the stocking cap was necessary for a welfare check?
I was trying not to be seen, and it was still April and cold outside.
If I told you it was 49 degrees that morning, would you disagree with me? At 4 a.m.?
That sounds about right.
Is that stocking cap weather?
For an extended period of time, and I had driven down there, probably keeping the window open to stay awake a little bit. Yes.
Well, you're meteorology, not me. Is that stocking cap weather?
For me, for an extended period of time, yes.
And your concern was not being seen by the neighbors, so you parked a block away.
Yes.
Tell us your stepmother's neighbors' names.
I can remember a little bit about them, but not the names.
Okay. You don't dispute that you entered through the egress window?
I do not.
You don't dispute that you used a crowbar to gain entry? Or pry bar, excuse me.
Yes.
That pry bar right up there, that's yours?
Yes.
That's the one you packed
Yes.
before driving 220 miles?
Yes.
I want to circle back. So you're very close to your aunts, Cindy and Nancy, is that correct?
Yes.
You trust their judgment?
Typically, yes.
And obviously, all this has been done out of concern for Carol Mitchell.
Yes.
And yet yesterday, your aunt Nancy told us, admitted on cross-examination, that your relationship with Carol was not stellar. Carol Mitchell. You understand that?
I hadn't heard a question.
Your Aunt Cindy gave a statement to the defense investigator as well. Are you aware of that? Cindy Markey, I believe her name is?
That is my aunt, yes.
Okay. Would it shock you if she told the defense investigator that your relationship has never been good from day one? Would that shock you?
I met her when I was 4. I'm not sure how that would be entirely accurate, but yes, we have had rocky times.
Let's talk about when you were in the house. Your testimony is that Carol Mitchell bumped into you when you were standing?
Yes,
So you're denying that you were laying next to her bed?
I am.
Again, is this truth or fiction?
Truth.
And your testimony is that Carol Mitchell followed you downstairs with her knife?
No, I heard her when I opened the door. I heard her. Would have been near the bottom of the stairs, and she would have been near the top of the stairs in the kitchen. And I heard her say she had a knife, so she grabbed it at some point in time.
You heard the 911 call, correct?
I did.
And so your characterization is that you gave yourself up as soon as the officers were there?
I do not believe I said that.
Well, tell us in your mind what happened when the officers arrived.
I heard them at some point. Again, I didn't understand that she didn't understand it was me, or so I was shocked when I heard the yelling and the screaming, and honestly, I was afraid. I didn't come out because being in the military, I mean, most people are wonderful. I was a little afraid to move or do anything. I kind of froze, to put it simply, because occasionally you have people, at least people I've worked, rare, but that are almost looking to shoot someone.
You didn't want to get shot?
And so I stayed in place until they came to that area. I opened the door and I stood there.
And you brought the flashlight with you, of course?
Yes.
Okay, and your testimony is that that was already modified for your son and that wasn't for this trip?
Correct. I believe his name might have even been on the flashlight.
And it was also necessary, of course, to throw in a pair of flashlight gloves for welfare check?
The flashlight gloves is what I primarily used. They're not as bright. So the other flashlight is actually very bright and it was kind of a backup. I just hadn't taken my kid's sock off it.
And in your testimony, it was necessary to remove your shoes to check on Carol, to check on the residents?
They'd gotten dirty in the well and we always take our shoes off. I didn't want to track anything through the house.
Now, you testified on direct that you did not have anything in your possession, correct? Any of Carol or your father's?
Nothing that was not mine.
Okay, and isn't that true because you were caught right away?
I had checked the whole house at that point. So I wouldn't agree with that.
Okay, you had checked the whole house, but you told Officer Wolfe that you had literally just gotten in there.
I would guess I'd been there about 10 minutes.
But you went out of your way to tell him you hadn't had time to do anything.
My main objective was the phone, and I had not gotten to that.
Your other objectives were checking cat litter and deep freezes?
If that's how you'd like to phrase that.
That wasn't me phrasing it, that was your testimony.
My objective was a welfare check.
And yet, in 37 and a half minutes with Officer Sternhagen, you never mentioned that once.
Objection asked and answered.
Sustained. Ms. Mitchell will have you back up again. Thank you.
Ms. Mitchell, when you started your testimony, you said that you retired from the military because of this, correct?
I believe I said I was also eligible, but correct.
Why?
Why? Because of this?
Correct.
Because I was in a position with a boss in general who wasn't always the most supportive person. And this was also high profile. I was told it was a distraction. He was also going for a promotion at the time and didn't kind of want the taint of any of this associated with him. So he asked me to put in my resignation.
You don't feel that you have any personal accountability in that decision?
It was clearly indicated to me that my life would be made very difficult if I did not. So yes, I had a decision, but if you've been in the military, you kind of know that sometimes even if you have a decision, you kind of don't have a decision. I don't know how to phrase that.
Now, you were charged.
I was really expecting the deliberation to be done by now.
To my knowledge, yes.
Okay, and, released from custody before noon that day?
I believe so.
within 3 hours, it was important for you to put out a Facebook post. Is that fair to say?
Yes.
A Facebook post that's completely inconsistent with the body camera footage in this case. Correct?
I'd like to remind everybody that's watching that we have a show tonight, 9
Why
o'clock
did you
Eastern, 8
craft
o'clock
that
Central.
Facebook post?
Grand jury. Don't forget to miss it. It's a great show.
So
Come on in.
originally,
Give us your
when I'd
opinion.
gotten
Chats will
in,
be
I
open.
was told I'd probably be released that morning. And then my arrest leaked to the media and it blew up, and I got to watch my life unfold on the jailhouse television.
Was there some political preservation involved in your Facebook post?
No, I wanted people to at least understand that all the craziness that there was more to the story. I also wanted to de-escalate it because I could see from what I watched that the press was starting to hound Carol, which really concerned me. She really values her privacy. I genuinely did believe it was a family matter, and I was hoping, especially for her sake, that we wouldn't go through all this.
She values her privacy. Is that what you just said?
She doesn't like having her picture taken.
Ms. Mitchell, I'm
things
asking
like
you,
that.
did you just testify that Carol Mitchell values her privacy?
Yes,
Okay, and yet you broke into her home at 4:45 in the morning.
correct.
Just one moment, please. All right, asked to republish Exhibit 21 at approximately 14:33.
All right, you may.
Ms. Mitchell, this is the list you testified about. Is that correct?
Correct.
In your testimony, if I understand it, was you're claiming that the line delete texts and contacts actually means to make sure that Carol Mitchell hadn't deleted contacts? Or please explain it to me.
Yes, and I think one of the officers even testified that she had just added my contact back in March, but I mean, my contact had been in there for forever, so I think that ended up being a valid concern.
In your testimony, explain to me again what the ad tracking means with your direct testimony.
Yes, as I said, sometimes she would turn off things on her phone that the phone really actually needed for functionality. I'd helped her with her phone a couple times when she'd had problems with it, and I had a concern, especially with her getting, lost even with mapping programs, that she had maybe turned off the more specific location devices that were needed for her mapping to function. And it would also be what police would use if she actually got lost.
Ms. Mitchell, was this a way for you to further control and track Carol Mitchell?
There would have been no way for me to do that.
Well, you were bringing a computer back to her, weren't you?
Yes.
Now, you've testified about watching Carol Mitchell's progression over the years. Is that fair to say?
Yes.
You've also testified about the loved ones that you've had that you've watched suffer from either Alzheimer's or dementia.
Yes.
And you've talked about paranoia and triggers and things of those natures. Would you agree with that?
Yes.
Yet, fully aware of all that, fully aware of Carol Mitchell's Alzheimer's, you still made a decision to break into her house that morning.
Yes.
Okay. That was, in your mind, that was the best course of action. Not telling anybody else, driving 220 miles and breaking into her house.
Objection asked and answered.
Sustained.
Ms. Mitchell, how many years was your father married to Carol Mitchell?
They were just about to have an anniversary before he died, and or after. So I think that would have been the 40th. So I believe 39 years.
And your father is no doubt proud of your accomplishments, correct?
I believe he was.
How do you think he would feel about you breaking into his own home?
I think he would be very sad by this whole situation, and that he would support me because he loved Carol, and even if I did it the wrong way, he would have wanted me to do my best to take care of her.
I don't have any further questions, Your Honor.
Mr. DeCray.
Thank you, Your Honor. Ms. Mitchell, on cross-examination, Mr. McDonald asked you a number of times before I objected why you didn't explain the real reason why you were there once you were outside of Carol Mitchell's presence. Can you explain why you didn't do that?
I'm so sorry.
And please try to get back. I know it's difficult, but please try to stay back.
So when we were in the house, again, I don't remember everything perfectly, but it really felt like she was almost just being allowed to wander around. And so there were times, even if I was, like when I was trying to get my shoes, I didn't remember saying it there until I saw the video, and I was like, why did you say it? And then I saw her in the different view, like wandering around in the background. And so I think it was because I knew she could hear it. But
What about when she's out of presence? Please focus on that. I know why you didn't do it when she was in the basement. When you're apart from her, that's what Mr. McDonald is getting at.
I apologize. So they were going back and forth and telling her everything. I could tell it, you know, like with the laptop and things, and they just kept talking to her. And again, I was hoping to calm everything down, and I had a belief that she could decide, you know, whether or not I would be charged. And I knew that even if I told the police at the station, they would just immediately go back and say, well, she did that. She said this is, can you verify it? Whatever else. And that would spin her up, and it would make it impossible to try and calm it back down. And I'm not saying every thought I was having in that state was rational, but that was what was in my head.
So even though she was apart from you, she eventually would find out.
I knew that they would tell her.
And you thought that would make her more likely to want to press charges?
Yes.
Okay. On cross-examination, Mr. McDonald asked a question about how you didn't express concern for Carol after you were arrested, and you said no. He asked you yes or no, and you said no. So I'm going to read a number of statements you made to Officer Sternhager, and I want you to tell me whether or not this was you expressing concern. You said, my dad died last year. She's paranoid. Now she's really paranoid. Was that expressing concern?
Yes.
You then said she's got severe Alzheimer's. Was that expressing concern?
Yes.
You said, after the funeral, my aunts tried to help her. She thinks they stole from her when they were just trying to get her affairs in order. She's progressively cut off the family to include promising us some ashes so we can bury them with the rest of the family. Is that expressing concern?
Yes, the overall behavior.
You say, she's got Alzheimer's. I know this doesn't help, but it's going to prove the point. She's gotten paranoid and thinks we are all out to get her and won't let anyone in the house. Concern?
Yes.
I used to be here all the time. Last time I was here, October or November, and then she just got progressively more paranoid. Concern?
Yes.
We had a fight over the acid situation, and she, at least right now, wouldn't talk to me. It's gotten progressively worse. Concern?
Yes.
So do you stand by your answer to Mr. McDonald that you did express concern about Carol Mitchell after you were arrested?
I wasn't going to say the reason I was there, but all of those things were the real things, and the real things that got me to where we were.
Is the reason you told both Carol Mitchell and the officers that you were there for some certain things of your father's because Carol Mitchell had previously promised you that you could have those?
Yes.
Did you think that would make it more likely that she would believe that and then calm down and possibly, to your knowledge, not ask for you to be charged with a crime?
Yes.
One of the things Mr. McDonald brought into issue was whether or not you were laying down in Carol Mitchell's room or standing up. Do you remember that?
Yes.
And Carol Mitchell said that you were laying down, correct?
Yes.
Did she also say that you and Jonathan had never met? Jonathan Keel?
Yes.
Did she also say that she had attended Rod Mitchell's interment alone?
Yes.
Did she also say before the lunch break that Rod Mitchell died in 1993?
Yes.
Were any of those things true?
No.
Mr. McDonald also referenced a Facebook post that you posted after you were released from jail. In that Facebook post, what was the true statement that you were talking about?
I'm not sure I understand. I apologize.
Did you mention that this was related to Alzheimer's?
Yes,
Was this related to Alzheimer's?
yes,
Was that the truth?
yes.
No further questions, Your Honor.
Mr. McDonald.
So when you're expressing these statements of concern to the officers, are those truths or are those more lies?
They were true.
But yet they're intertwined with your statements of why you were there.
Correct?
And now on redirect examination for the first time, you're telling us that Carol Mitchell previously promised you these items. Yes?
Yes,
Okay. Wasn't covered in your initial direct, but now you're telling us that. You testified earlier that you've gone through hundreds and hundreds of text messages, yet we have nothing saying that these items were ever promised to you.
we also had a lot of conversations.
So if Carol Mitchell told a 911 operator that she stepped on somebody, you're saying that she's lying?
I am.
I have no further questions.
Mr. DeCray.
Did you hear the testimony of Nancy Lund where she testified that Carol Mitchell was going to give some of Rod Mitchell's possessions to her in order to give them to you?
Yes,
Did that form your belief that those possessions would be yours?
there were a number of conversations about different possessions. So I'm not sure. I already knew that we talked about some of the things, and then some of the things she'd said she would say, she got confused and gave away. I'm not sure. Maybe I don't understand the question.
Do you recall testimony from Jonathan Keel where he was asked about whether or not Carol Mitchell would have a problem giving you any of those possessions and he said no?
Yes, I remember that.
No further questions, Your Honor.
All right, you've been watching a replay of the cross-examination of State Senator Nicole Mitchell that occurred yesterday afternoon in her criminal trial in Becker County Court in Detroit Lake. She was on the stand for most of the day yesterday, wrapping up around just before 4:30 today. So that was the very end of it yesterday. Now to recap where we are today, there were a couple of final defense witnesses that were fairly quick this morning before closing arguments from the prosecution and the defense. The jury then got the case to begin deliberating right around 12:30 this afternoon. So they've been going for, over 2.5 hours now since they got the case. They got it at lunchtime. So they're eating lunch while beginning their work. But again, right around 12:30 is when they left the courtroom to go back to the jury room to get ready to start their deliberations. So we've been waiting for this to see if there's a verdict. Sometimes these could come quickly, sometimes they don't. You never know, but we will bring that verdict to you as soon as we get it and bring you the live stream from the courtroom as well of that verdict being delivered. We've been on a 10-minute delay from our video and audio from the courtroom throughout the trial. We've been told that for the verdict, that is cut down to a 5-minute delay in our audio and video from the courtroom. So there will still be a delay. We'll bring you the information as we get it and bring you the stream as we can bring it to you under those conditions. And we will be back here on this when that occurs this afternoon, if it comes yet this afternoon, or if it comes after 5 p.m., certainly then we will let you know about it in our on-air newscasts on Fox 9, which go from 5 until 7, and on Fox 9 Plus from 7 until 8. So we'll be standing by. We'll let you know as soon as we know something. And again, bring you that feed from the courtroom of the verdicts being delivered when that occurs. Thanks for joining us for this coverage, and we'll be standing by to let you know when a verdict comes.
Just, I don't know, normal family stuff.
You mentioned that Carol was like a second mother. What was your favorite things about Carol?
She loves animals. She will tell you all day long about her cats. And I think I'm not
I'm kind of surprised you're not done deliberating now.
I didn't kill a spider. But I think I got my respect for animals in part because of that. She's very artistic, which is not how my brain works at all. So I was always kind of impressed by some of the things that she could come up with and do. She was...
For the almost 700 people watching, I'd like you all to remember that tonight we have the grand jury, 9 o'clock Eastern, 8 o'clock Central. Feel free to come on in. We've got it on YouTube. Of course, we have it on all the rest of those places where you go to get all your streaming.
We've got it on YouTube, X, Rumble, and we're going to try to go to Facebook Live tonight. So we'll be on 3 platforms with the grand jury tonight. Sorry,
Facebook sounds great.
We've had some technical issues that I've been trying to deal with. One of the feeds died on the audio.
No worries, no worries. I'm kind of surprised they're not back from deliberation yet, Joe. I was kind of expecting a shorter deliberation on this point.
I did. They could have opted for lunch, so subtract an hour. And you know what? They're deciding somebody's fate. So give them. I'm not mad at them. I do think we'll have a verdict today. I don't think this goes over the weekend, or I don't think it goes past 5 o'clock. But you know what? Maybe there's someone in there that sees it different than we've seen it. Maybe someone thinks that her actions might have been reasonable. I don't see them, but it's possible that someone could. What's B say? 4 hours. 4 hours for what? They have not been deliberating for 4 hours. About 2 hours and 45 minutes.
Are you saying you expect to get the verdict at the 4 hour mark there, B?
Yeah, clarify yourself there, B. 4 hours. That's ridiculous. That would put it 4:30 Central Time, if B is correct. You guys, excuse me for just a moment. You know what? While we're twiddling our thumbs, waiting on that, let's do a couple of different things. Let's take a look at the Range Minded podcast. For those of you that have not seen the Range Minded podcast, you should give it a watch. It's a weekly podcast put out by our friend Range with Range Minded, and he touches on a lot of freedom, individual freedom topics, but mainly 2A, and he also puts some gun trade crap in there on different types of weapons, does reviews. He has some range dates, but he's really good at keeping up on what's going on in the legal field around challenges to the 2A and, of course, proponents of Second Amendment fighting back at some of these. But take a look at the Range Minded podcast. You can find it anywhere you can find a podcast. I watch it on Spotify. But wherever you find it, give him a follow, give him a subscribe.
Have you ever wondered to yourself, man, what time does the store close? Or where's the best cheeseburger near me? Well, I'm not going to answer those questions. That's what your damn phone is for. Use that. Instead, if you have stuff related, to the 2A world, I'm your man. My name's Steve. I run the Range Minded podcast. On the podcast, we talk about all things Second Amendment, whether it be new guns or gear. Maybe we talk about some training. We'll dig into Washington and the shenanigans they get up to. Sometimes we talk about the Supreme Court and the crap that they're doing. It's always a good time, a little smorgasbord of the 2A, if you don't mind me using that narrative. Either way, you can find us whether on YouTube or Rumble, Range Minded Podcast. I'm also on all sorts of streaming services, wherever you listen to your podcast, Range Minded Podcast. You can jump on the website, rangemindedpodcast.com. Maybe stop by, buy a patch and some other things there. You can link to the social medias and all that other stuff. Hope to see you there. It's always a good time. Anyways, you guys have fun, stay safe, and always stay range-minded. See you guys soon.
Yeah, folks, that's the Range Minded podcast. You won't be let down by giving him a watch, and give him a follow. He's a small content creator just like myself, and we struggle to get our messages out there and produce content that we hope is appealing. But definitely, we're fans of the Range Minded podcast. Now, speaking of self-promotion, tonight we do have the grand jury. For those of you who don't follow us, we do it every Friday night, 9 to 11 Eastern. I take 5 volunteers, new volunteers each week, and set them as a 5-panel grand jury, mock grand jury. We watch police use of force videos, the kind that you normally see, but these aren't commented. They're not edited. These are full either FOIA or agency-released videos, and they're recent. I'll have videos that you haven't seen or may not see. We ask them to set as a grand jury, view these through the lens of a grand jury. For those that have been watching this, you heard the jury instructions, which in this case are very detailed. We don't go that far with it on the grand jury show, but they do have a jury charge, how we ask them to review these, what the law says when it comes to self-defense and the use of force. And these guys take on 5-6 cases every week. And it's very interesting. Their deliberations we get to hear, unlike on this trial, we're in the dark until we know what they decide. But here's a promo for tonight's show, and you'll see this week's volunteers.
Do you ever get any money from Costello?
No.
And did you ever get any money from Meyer Lansky?
I never got money from any of those fellas.
None of those
fellas. None of these that I've been reading about, and none that I knew. They never gave me anything.
None of the Shetties?
No. I don't even speak to the... I mean, I met that Charlie once or twice. I don't even talk to him.
You don't like him?
I was conscious of the fact that he had a reputation for being an outstanding bookmaker.
You ever hear him referred to as the Prime Minister of the Underworld?
That term I did not.
Also known as Duck Corella. I refuse to answer on the grounds of made offense of got any business? I refuse to answer on the grounds of offense of criminal. You have any profession? I refuse to answer on the grounds of made offense. Have any occupation? I refuse to answer on the grounds of made offense. Are you a known racketeer?
An incarcerated individual's use of institutional telephones constitutes consent, and your calls may be provided to law enforcement agencies. Thank you for using Securus.
Yep, folks, so that'll be tonight, every Friday night, same time, different cast, and the same crew, though. Big Ron's our producer. Fidji helps. She actually runs a companion space on X that we do tie in. We have a special case just for them for the members of that X space. We'll decide make a decision on that one. I won't say decide, but make a decision and give their opinions on a particular case throughout the show each week. We have some expert witnesses. One from, folks from Minnesota. Jason is a 30-year law enforcement veteran. And he's been with us since the very beginning, doing this for about a year. And he's been the expert with us all the way through. He's a great guy. Big Rob, what else does Jason do? He just recently retired within the last month from 30 years of law enforcement, but he's been doing something else for a while. What is that?
I'll tell you what, Joe, I'm glad you bring that up. My wife's a school teacher, and one of the things that I worry about every day is if she's safe enough at school. And our friend Jason has come up with a phenomenal system that takes the worries out. I wish my state had it. I've seen it in his state. I went and toured the system, and it blows my mind. I think we've got a video, Joe, that we can show these people about exactly what we're talking about.
I do have a video, but remember, you have seen it. I have not. You've seen this in person, but this is a 3D response. This is a company that has a patented school safety system, and it's a complete system from beginning to end to early detection, response if for God forbid it does happen, and then aftercare afterwards. But take a look at just a little glimpse of the 3D response system.
I see you entering, take a right. You're going to proceed down the long hall, all the way to the end. You're going to go till the end where you're intersect to the classrooms. Keep going, I see you moving forward. Subject is held up in classroom 203.
Law enforcement is on the way. Law enforcement is on the way.
You know, for any folks we have listening in Minnesota, which I think we have a few, I've had some DMs and some interaction with some of you folks up there. Of course, this is a big local story for folks in Minnesota. We just find it interesting outside of your state for you guys. And this has been a hot topic. But the state legislature, the House there, has taken up a bill this last session called the SHIELD Act. And the SHIELD Act, what it does is essentially establishes a safety code like a fire code that we have in our schools. And we've had in our schools mandatory since, I think, 1959, which, by the way, 1958 was the last time we lost a child to a school fire. Prior to that, you would be shocked. Go pull some headlines. I've seen headlines of over 300 kids dying in one day in a school fire. This was before they had a unified fire prevention and fire response system required to be in a school before you put kids in a desk. But the state of Minnesota has taken that up. But don't worry, folks. Your politicians there didn't disappoint you. They put it off. They put it off. And I say put it off because it's very discouraging, because the fire code that became mandatory across the nation in 1959 was passed in 1908. They just grandfathered everybody in. So it wasn't a big deal if you didn't have a fire code. It wasn't mandatory that you didn't have a fire evacuation plan and suppression plan and a notification plan, a response plan for a fire until 1959. And after they've lost, and I forget what it was 30 some odd kids and some nuns in a school in Chicago. But don't worry, the state of Minnesota, they're going to get to it as soon as they can. If you go back and look at the bills they passed this year, you'll see, no doubt, everything they passed was way more important than establishing a safety code for new schools that are built in any school that goes under any substantial renovation to make it safer for our school, for our kids. So, and I say that, and I'm in the great state of Texas, and my state legislature spent no time on it. So it's a push we're doing down here as well. We really hoped you guys in Minnesota were going to get that across the line. I know that you got some pretty strong advocates for it there, but evidently just quite wasn't important enough this session, but I'm sure it will be next session. It will be top of the line next session. You know what's also weird about this SHIELD Act is that mothers that demand action don't demand much. They put out a letter, said, we're just kind of neutral on this. We're neither here or there on school safety or do anything to preserve kids. But if you go to the website and check out their Act Blue link, you'll see how much money they raise every time one of these horrible incidents happens. So everyone else sends thoughts and prayers, but Moms Demand Action wants you to send cash. And that's what they're really after. And I feel pretty passionate about this. When you take the time to do the research on it and you look at school fires, it's horrifying, pure horrifying how many lives were lost in school fires for simple things about varnish on the floor. The fire in 1958 started in the basement of this school. And then the stairwells acted as a path for it to travel, but it was like a blowtorch because the hot air as it moved up sucked more air to it. So it was like a blast furnace, and there was no way for the kids to get out. Now, after the school code, 1 year later, that stairwell would have had fire doors on it. So when a fire happened, them doors are automatically going to close. Why? To prevent the spread of the fire, to isolate the fire to wherever it started, wherever this bad thing is happening in the school, let's isolate it there. Let's remove the children from it in a safe egress out of the way or to a safe place. Let's apply some water with it with fire suppression systems. Maybe even some fire extinguishers placed somewhere so that maybe a school teacher could even help or someone else could help suppress the fire, keep it down. And then let's notify the fire department as quick as possible. Many of you may not know that if a fire alarm is pulled or triggered at your child's school, no one calls 911. Not one call. It goes directly to the firehouse. And back in 1959, they run this a hard line, little wire that went to the firehouse. So when there was a fire in the school, wheels are already turning. Fire's already being isolated. Fire's already being suppressed. Kids are being moved away from it to safety. And fire trucks with hoses, wheels are already turning. This happens almost instantly. And folks, what I just described is the 3D response system for school shootings, for this type of event. It isolates the children where they're safe. They're in areas that bullets cannot penetrate. They're behind doors that teachers don't have to find keys to lock. They lock with the push of a button, and you ain't getting it open. It's stuck. It automatically notifies law enforcement via text message. In the video that we watch, you're seeing training. This has been installed in almost 20 schools in the state of Minnesota. They're all private schools because, you know, public schools can't figure it out. But it provides the same protection we do with fire. We provide it with 3D Response provides it with their system. And it's kind of ironic. Let's go back to 1957 before they did this. It would be like Moms Demand Action of 1957 would say outlaw fires. We need to ban fires. That's how we fix this problem. And then people that say armed teachers would be, their argument would be with the fire system, just give teachers buckets. Give them buckets and everything's going to be okay. And there could be a third tier there. Then find retired firemen and just stick them in the school. And everything's going to be okay. When we talk about fire and all those solutions that I just said, they sound ridiculous. Do they not? Of course they do. They sound ridiculous. But yet these are the same arguments that we hear when it comes time to protect our children in school from some maniac that shows up for God knows whatever reason. I hear people talk, well, we've got to stop it from happening. Well, that hasn't worked. Maybe we can't do that. But I want a backup system in case. I want 3D response in every school in America so we don't have to see these horrible events happen where some parents' hearts broken and the community's hearts broken. It's horrible. It's the worst thing ever, and it can be prevented. So hopefully you guys in Minnesota can be ahead of the game. I'm sure it's going to happen this next legislature session, 100%. There's no way. Hey, Big Ron, see when you come in and it goes to the small screen, could you hit that one and make it full screen again? There you go. Back to my point. I believe that you guys are probably going to get it right this time. I have confidence in you. But just in case I'm wrong, you might want to reach out to whatever representative you have at the state, whether it be both your senator and your state representative, and you might let them know that it's kind of half-ass important to you too. Maybe that should be something you guys should talk about. I watched hearings on it. It went through committee. It was ready to go to the floor. And it just didn't have time for it. These other things were more important. And there were some really good bills that were put out there that are going to save lives and change things. I'm sure of it. But this one's real simple, in my opinion. Pass it, drop it down. And then when they build a school, it forces architects and school builders to consider what happens if some jackass comes to our school and tries to kill our children. That's off. I'm off my soapbox with that. And that's how I feel about it. And those of you maybe just watching, we're still waiting on a decision. Hadn't heard of notice yet. I'm pretty sure we will get some sort of a warning that it's happening and give us a chance to get in there.
Well, we've only got like an hour left in the day for them, right? Hour and 15 minutes.
They could go late. I doubt this is not going to go. They're not going to reconvene the jury on Monday. And I tell you, the judge is not going to want to. I promise you, he did not schedule this to be more than 1 day in deliberation. This ends on his scheduled calendar. It ends today. B thinks.
But Joe, they're
well, go ahead.
They're deliberating. This takes time. They're deliberating on a liberal white woman's need for attention. Well, she didn't want the attention that night, did she? I cracked myself up. And her need for control. I'm sorry, her caretaker at heart characteristics. So this is really the jury should deliberate a long time on this. This is It's bad.
Well, look, they probably had lunch, so subtract an hour. So they're roughly at 2 hours at it now by
After
subtracting
breaks.
lunch. 45 minutes or so. They got some business they've got to do. They got to elect a foreman. There's some paperwork with that. They've got to go back and reread the jury charge. You heard how long it took for the judge to read it. So there's some time in there that just aren't in deliberations, but they're definitely into deliberation at this point. But I think we'll get a decision here pretty quick. I don't think it'll go past 5 o'clock Central. I think these guys will get out and get their weekend started and feel good about their decision.
Well, while we're waiting, why don't you you got a particular case coming up next week on interrogation, or why don't you tell us about that show?
Interrogation. I've got about 3 of those that are loaded, ready to go. I'm not sure which one we'll do next week. Interrogation, I'll be honest, it's just I don't think it's for everybody. It's kind of dry. We're talking about the tactics and the methods used by law enforcement to get people to confess without saying I want an attorney, just keeping them right on the edge until they give up the goods, so to speak. But yeah, interrogation definitely on Wednesdays. Anybody that's interested in that, you might catch it. It is interesting. We do have the following we got's pretty strong on that. But I have been told that it's kind of dry.
Interrogations are a little dry, but I find it interesting, and I'm okay with it. I'd rather listen to that than jury instructions, to be honest. But I find the interrogation interesting. And what's funny is you started that show, and I was flipping through channels one night and found a show that was interrogation, like a TV produced show on that, right? And I watched it and just to see how it compared, right? And I think yours is a little bit more interesting than that one.
I would say anything that comes out of Hollywood or from that genre is going to be BS. I've yet to see anything that I thought people, even shows people say that, oh, The Wire is exactly what Wire's. No. I mean, there's some elements that are true, but it's very loose.
This is where they actually show footage from interrogations.
Oh, actual interrogations.
Okay. Yeah. It's very similar to your show. Your show is better, though, and let me tell you why it's better. It's better because you give the commentary. And if people watch interrogation, yeah, it might not be for everyone, but you know what? That's actually pretty helpful when you think about it. It helps people to read others a little bit better, like if you're at work or anything having to deal with corporate politics or anything like that. Or, I mean, like, I used to play pool. I see a lot of things in there that I used to read on an opponent while I was playing pool. And it's pretty good to get a handle on tells that people have and when they're lying, when they're not, when they're sincere. I think it's a pretty cool show. I think it's a helpful show to watch.
Yeah, you know what? Honestly, I think it could help people in sales. If you do it correctly, you learn to listen, to learn how people tell stories, to learn how people are going to give you information. Take this compassionate caregiver at heart, Senator. When she began, and you see her now, you can't even hear her audio, but she's animated. She's really giving it to you. She is being very sincere. But when she was challenged, once she had committed herself with all the things that she said, which is very similar to an interrogation in the beginning, you let them talk, let them commit themselves to the story. Of course, you ask questions because you want to steer the conversation, but you want them to give you a commitment. I was not there at this time. Well, then how did we have you on video? Or how did we get your fingerprints? How do you lay that out later? But if you go back and we may be here waiting long enough that with this video will run through with the prosecution does the cross-examination, but you get through the cross-examination, she's not waving her hands anymore. She's not making the facial expressions. She's not wiggling around. She's not surveying the room as she speaks like a good public speaker. She's hunched over. She's in a defensive position, and she's not as free-flowing with information when she's being pressed. Now, this tells you that what you heard before, she's selling you something. She's not telling you the truth. Now, if her demeanor did not change all the way through from prosecution to defense, that would lend some credibility. Would it not?
It would. And it did change. She got snappy. She would correct herself right after she got snappy. You could see that in her whole demeanor when she messed up, when she brought it back, how she tried to recover that. So these are all things we've seen in interrogations as well.
That's exactly my point. You'll see the similar tactics used. Of course, on the witness stand, you don't really have a choice. You got to answer those questions. You raise your hand and swore that you would. An interrogation, though, you've got to add the extra variable is that the person you're talking to can say, I want an attorney at any time, and I don't want to answer any more questions. So there's all of that little dance that good interrogators have to do when they first sit down with someone. But we've had some great examples on the interrogation show. I'm really I really think that the grand jury on Fridays is probably more people's cup of tea. I think it's more entertaining. We get a very varied mix of videos each week, and we have a brand new jury each week. So it's like a brand new show each week instead of it getting old hearing the same old things.
And I know your concentration is what's going on StreamYard while you're streaming for the grand jury. That's where it needs to be. But really, guys, a lot of people have fun in that space that rides alongside of it. I think people really enjoy kind of feeling tested, like a game show, and it really is the whole experience is pretty cool.
Yeah, we have a lot of fun doing it. We've been doing it for a year. Now, we did change the format considerably. We are on the 10th episode. 10 weeks ago, we changed the format considerably. We used to do it where Fidgy, Big Ron, and a few others, excuse me, I got a phone call, and a few others. I had law enforcement folks. I had attorneys, and we had civilians, and they would sit kind of as a mock panel, and we would just review police use of force videos as to whether we thought that use of force was justified or not. But we learned after doing this for some months that there was no longer any debate. Early on, we'd have big time debate. Well, he just had a knife. I don't think that's right. And we would have great debate in there. Sometimes we couldn't get through all the videos I had because the debates went on so long. But over time, we've learned as more people honestly got wised up to looking at it more from a legal point of view, which is what a grand jury is going to do. Just like this case here, these jurors, they're looking at the legal point of view. All the other stuff is maybe, maybe not. But they're asking you, the law's asking you, and you heard him, take the passion out and look at the law. And that's what we ask a grand jury to do. But after we've done that over a few months, some months, we weren't arguing anymore. There was no debate. Everybody's yep. We all agree. And quite frankly, the show got boring. It was Jason with 3D Response to come up with ideas like, man, we need to get new people in here to try to find volunteers. I was like, that's brilliant. Let's do it. And it's worked out great. Real happy with the change. Now we have 5 brand new folks each week. They come in and it's a fresh look for them each week, and it's they're listening to the deliberations. To me, is the most interesting part of it. It's not the video, it's not anything else. Listening to how they go back and forth and sort out how to make a decision that they can live with, that feels comfortable for them, in accordance with the law.
Well, we've sat on there for what? We sat on there for almost a year doing that. Like you said, it got a little stale because it's the same voices all the time, with these new voices and the combination of new voices each week. It really gives you a cool kind of perspective on how people think and, how they discuss things and prove their point as well. It's really cool. So if you think you're going to go out on a date tonight and it's not going to be a great date, go ahead and cancel. Stay with us, hang with us, so you'll laugh and enjoy the show. Guaranteed.
That's the only time that you can participate in a grand jury, and alcoholic beverages are encouraged 100%. But we have a good time with it. So, guys, if you hadn't picked up an episode, catch us tonight, 9:00. A little pro tip here: if you go to YouTube or Rumble, you can watch it on your television. And we'll see how Facebook works. I tried with Facebook early on, but they kept kicking it for violent content. Of course, it's police use of force videos for force, so there is some violence to it, I guess. But doing a little reading on the terms of service, I think with a couple of disclaimers, we might be able to slip that in. So I'm going to try Facebook tonight.
There you go. I used to be on Facebook a long time ago and had a big following over there, and yeah, then I got off of it, and now I keep it like kind of a minimal, you know. Otherwise, I would repost it over there for you too.
Well, I've got minimal over there too, but their algorithm is pretty good for live feeds, so I think I'm just going to start pushing it over there. We might have some friends on that side of the wall that could help us out a little bit that may have been on the show before.
Oh, that would be awesome if they would help us out. And hey, even if you haven't been on the show, go ahead and push it for us. We'll appreciate it.
Well, we're talking our good old friend Ken Walls.
Oh yeah,
yeah. He's you know, Ken has a huge following on Facebook. Sorry guys, I'm doing something here. All right, just giving you an update. That's what the live feed says. Senator Nicole Mitchell trial. So we still don't have a verdict or any indication of a verdict. I just wanted to throw that up there so that we could check. But yeah, no, Ken Walls with the Ken Walls show. He's on X, but he's also on Facebook. If you should catch it. He does a lot of different things, but the guy's really good on marketing and helping you kind of move your game down the road. Does a lot of political things as well. Him and Kay Daly. If you haven't caught the Kay Daly show on X and Facebook and pretty much anywhere else that there are live streams that you can catch the Kay Daly show. She's a good follow on X, and so is Ken Walls, by the way. But those folks do well on Facebook, and it's kind of convinced me that maybe I should not ignore it. And I think it's good advice.
I think it's excellent advice. Any way you can get your name out there, you go ahead and do it. That's what social media is all about, right?
I think more people that, and it's been this has held true. The more new people I can bring in to see the grand jury, especially since we changed it to the volunteers each week, it really has made a difference. We're getting it out there, exposing more people to the idea, exposing more people to our little form of entertainment that we do on Friday nights, and it's working.
I love that. This is a great group. You know, I discovered Joe about a little over a year ago, and I think you were the first space I ever got on too, and really enjoyed it. And whenever I go to other spaces, not to knock them, it's just not as much my thing because I'm so used to our formats and all. You know, I like gaining a lot of knowledge. I like having good conversation, and that's exactly what Night Court brings to the table, I think. It's
yeah, the whole
formula.
Night Court thing it has been fun. It's been an evolution. We started with spaces and trying to cultivate some debate. It's really difficult to do in spaces, though. But we've had fun doing it. We've had some great guests. We've had Dr. Moore, the doctor that the Justice Department just dropped cases on because he was saving people in Utah from having to take the vaccine. We've had some the Independent Cattle Producers Association and the Beef Initiative on. I really like those guys and the message they've got. We've met great people doing this over the last about a year and a half. But here recently, we've gone more into the streams. The spaces has, for me, seemed to be almost the same thing. Just change the topic, and it just kind of keeps going around. So, but folks, we still do after spaces. If you want to do spaces with us, we're in spaces all the time. I just don't really do the Night Court. We may bring it back for maybe a once a month thing with a particular guest or particular topic, but I just don't know that the as they say, the juice is worth the squeeze on the spaces for us.
Oh, I always consider the whole thing. To me, the whole thing, Joe Lanou is Night Court, as far as I'm concerned. Then you have subsets, the grand jury, interrogation, good after parties, you know, that type of thing.
Yeah,
But
you know what? We have fun, and we have a good strong following, and I'm very proud and thankful for the folks that have confidence to spend a little time with us, because that's what it takes. Friday night, 9 to 11, you got to have some confidence that you're going to be entertained. Otherwise, that's prime wasted time right there. But we seem to do real well with it. And you know, we get a lot of replays. I get more replays on the grand jury than I do live viewers. In fact, it'll double or triple some weeks. Last few weeks, it's been doubling for sure, and we tripled early on as well. So evidently, it's interesting enough, even if the time schedule doesn't work for you, that people are still watching it. So just want to get it out there. I take criticism too. Anybody that says, "Hey, you should try this or try that," give me the idea. I'm down to give it a shot.
Like I always say, grab a nice glass of bourbon and a good cigar and come on in and have fun, guys.
And for you ladies, that's
vodka,
wine.
But, you know, beverage of your choice is what I prefer. Beverage of your choice is welcome.
Yeah, Ron, why are you trying to restrict people to the type of beverage they drink? That's a little controlling, isn't it? Commie.
You know what? That's exactly how the next step is. You need to drink this. Next thing, you're going to be breaking into people's houses to get their litter boxes cleaned. That's how this works.
You can't get much more American than bourbon.
Well, yeah, there is that. I don't know, although the wine scene kind of came up pretty fast and good.
Okay, well, Big Ron's right. Bourbon is probably more American.
Yeah. Well, it has to be made in Kentucky to be bourbon, right?
Wine's a classic. It goes all the way back to biblical times.
Yeah, but the French thought they had a lock on that. They did not.
Europe's got a handle on everything when it comes to the Americas. We wound up doing everything better.
Yeah.
But while we're self-promoting, folks, if you like what you're seeing, if you like the content that we produce, help us out a little bit, support the show. There is an expense doing this. Just the StreamYard that I'm playing today, a little over $100 a month. But and I don't mind doing it. I do it out of other reasons, but like I say, tips are appreciated. There's links both on my X profile and the YouTube profile for Cash App and Venmo. Almost forgot what it is, but Venmo there. Like I say, anything that you feel happy enough to tip, I'm super appreciated to get myself and our little crew here. So help us out. Thank you very much.
So while we're filling time here, Joe, and you probably already talked about him, but let's talk about Dexter a little bit.
You know what? I haven't talked about Dexter just yet.
Well, let's not ignore the gentleman.
I don't have any of the content loaded up. You kind of caught me off guard. So why don't you start?
So Dexter is a friend of ours who he used to run a podcast, right? Called Carbon Mike. Really good stand-up guy. And when I say stand-up, I mean someone who has stuck to their principles more than I think some of us would have been willing to do. So he was an engineer, and being an engineer, he was pretty curious about stuff and all, and always trying to make things better, make a better way of life. And during COVID, I think one of the topics he decided to tackle was making firearms better for police. And so he had engineered up some designs, and he had printed those out, and they were in his house, and they'd never been loaded. They'd never been fired. I mean, I don't know if he ran. Well, no, I don't think they've never been fired or anything. So he made these quote ghost guns. I hate that term. And after they were made, after all that was done,
hang on. He didn't make ghost guns. What he took was 80% lowers. People in the 2A world will know exactly what that is, but it's kind of a hunk of metal in the shape of a receiver, and you have to mill this out. It takes some craftsmanship to do it. Our friend Dexter's a nerd, by the way. He's not necessarily, he likes firearms, but he's not a firearm enthusiast. He's not at the range in doing these kind of things. But during COVID, everybody's in lockdown in New York and the communist state thereof. And he had a lathe. Okay, think about this. In his apartment in New York City, he's got a lathe where he turns his own table legs. He builds his own furniture, built many things there. That lathe wasn't recent. He's had it for many a year. He sees that he can build 80% lowers by ordering the parts legally, of course. And so he does so. He winds up building, I think, 13 guns, 4 of them were pistols, semi-automatic pistols, and then semi-automatic rifles on more of an AR platform style with the receiver. New York passes a law, and this is in 2020. Most of the firearms were made between 2020 and late 2021. By 2022, there was a new law passed. This was New York's response to brewing. We'll have none of individual freedom here, sir, is what they say. So they dished up this new law. This new law requires you to buy a permit for every weapon that you own that is essentially a rifle or semi-automatic. And that if you if you have 3 or more and you fail to buy this permit, then it's a felony offense. And if they find ammunition located in the premises or nearby the firearms, not loaded, but just in the premises, then they're able to make the assumption that you had nefarious intent. In other words, in the eyes of the law, then they just caught you before you got to the school. So it'd be like catching the shooter as he's walking into the school before he shoots. That's how you're able to you would be able to convict him of the same things. And they did. He was convicted in New York under this law. Now, Dexter could have taken a plea bargain. He could have gotten probation or a very light sentence on this. But he stood on his principles that, by God, the Second Amendment means something. And just because he lives in New York doesn't make him a second-class citizen. They run a search warrant on him. They find out by all the parts that he purchased, legally, by the way, 100% legal on the federal level and legal on New York level. The permit part is not, but everything else was legal. He used his own name, used his own credit card, had to send his own address, nothing nefarious about this. These firearms never left his home, never took a picture of them. They can't find any post where it's like, hey, I'm trying to sell you this gun over here. Now, they call them ghost guns because these guns are unserialized, which is fine on the federal level. And in most states, you don't have to have a serial number on your weapon. You have to have a serial number on the weapon if you want to transfer it, give it away, or sell it. Now, that's a problem. You've got to have a serial number and you've got to record that transaction. But keep in mind, no pictures. These weapons had been made over a 2-year period. He had 12 of them. And quite the investment. If the man was going to make money on them, he'd have sold some of those already. But he didn't. Not a Facebook post. Nobody knew. Just weapons, firearms owned by a free American with no criminal history, 50 some odd years old, a professional, IT professional. They're in his home. The only way the government knows they're there is because they went and got the bank records and said, hey, look at all these firearms parts that have been purchased and sent to this one address in New York. ATF drives the warrant. New York hits it. ATF looks around and says, well, no foul here, no crime to be seen. ATF is gone, leaving the state to pick it up for the man and charging him for not purchasing the permits. Let's hear what Colin Noir's got to say about it.
2 weeks ago, I did a video on a New York judge who declared that the Second Amendment doesn't exist in her courtroom and convicted Dexter Taylor because he was building guns as a hobby in his home. When I released that video, he hadn't been sentenced yet, but now he has. And they sentenced this man to 10 years in one of the worst prisons in the country. People don't realize how vicious these people are when it comes to their desire for control. None of this is about safety. It's about controlling the people. Notice I didn't say criminals. They need criminality to justify their heavy-handed control. They don't care that they're destroying a man's life just to set an example. I mean, they practically admit it. Today's sentence should send a message to anyone who, like this defendant, i.e. a regular citizen, who would try to evade critically important background checks and registration requirements to manufacture and stockpile these dangerous weapons. Do you really think criminals give a damn about this 10-year sentence? These criminals are committing crimes that will get them life in prison. What's a 10-year sentence? They're laughing at this dude and the system because they know this will do nothing to make New York any safer or make their jobs any harder. It's a dog and pony show to scare the normies who obey the laws. They know this man isn't a threat to anyone. He wasn't selling these guns to criminals. They act like this man was Victor Bout smuggling weapons across the world. He had 5 handguns, 4 rifles, and 50 rounds of ammo. That's nothing. I have more guns than that on the wall behind me. This is 50 rounds right here. 50 rounds. I have more than 50 rounds of ammo floating around the inside of my truck. But because I live in a state that recognizes my constitutional right, I'm walking around free as a bird. But this man's life is being destroyed for having what I have in this room because his state wants to make an example out of him for exercising his constitutional right. I see people saying, I'm all for the Second Amendment, but he did break the law. He should have known better. I'm sorry, but when did state law trump the Constitution? It's written plain as day on the ATF website as well. A license is not required to make a firearm solely for personal use. However, a license is required to manufacture firearms for sale or distribution. The law prohibits a person from assembling non-sporting semi-automatic rifles or shotguns from 10 or more imported parts, as well as firearms that cannot be detected by metal detectors or x-ray machines. In addition, the making of an NFA firearm requires a tax payment and advance approval by the ATF. He wasn't selling guns. None of them were NFA items. None of them were made from 10 or more imported parts. He's being sentenced to 10 years in prison because of made-up state laws that is clearly in violation of the Constitution. But New York leaders are so anti-2A, they don't care what the federal or the Constitution says, because they know it'll take years and years before a case will get to the Supreme Court before it's shut down. Also, keep this in mind. 2 months ago, I did a video about how Visa, MasterCard, and American Express will start tracking gun and ammo purchases. So American Express, Visa, and MasterCard have decided to start tracking your gun and ammo purchases.
Tonight, some major credit card companies are working to comply.
This is a gun registration, nothing more, nothing less. And anyone want to take a guess what caused the police to even go to Dexter Taylor's home in the first place? Because it wasn't like he was out shooting and robbing people and then they came back and found the guns. No, if you said they tracked his purchases online, you'd be right. This shirt and the hat that I'm wearing hits a little different now, doesn't it? New York has been playing fast and loose with the Second Amendment for a very long time. They've been crafting these unconstitutional gun laws, basically throwing a challenge to the Supreme Court to strike them down. And they know just how long that can take. For about 100 years, the average Joe or Jane in New York couldn't even think about getting a concealed carry permit. That was until the Supreme Court stepped in with the New York State Rifle and Pistol Association, Inc. versus Bruin decision on June 23, 2022. The High Court knocked down New York's old law that forced you to show proper cause to carry concealed. The Supreme Court said clear as day, the Second Amendment backs the right to carry a loaded handgun in public for self-defense, knocking New York's unconstitutional law right out of the park. And they're doing the exact same thing again with this so-called ghost gun laws. Ghost guns are nothing more than guns made on their own by citizens. The only difference now is technology makes it so you don't have to be a full-blown gunsmith to do it. And guess what you can't do if people can make their own guns? Confiscate them. That is, unless you violate people's right to privacy and monitor their online transactions and then raid their home because you don't like their hobby. It's disgusting, and now this man's life is ruined for it, while the real criminals are running around free as a bird with all of the guns they want because criminals don't buy legal parts online to get their guns. So, I ask, what's the point of having a constitution if states can pick and choose which part of the Constitution they want to recognize? And for those who don't care because you don't care about the Second Amendment, I hope you feel the same way when a state starts blatantly violating a constitutional right you do care about. Now begins the long process of trying to get this case to the Supreme Court, while a good man sits in prison rotting away, put in there by a judge who literally fixed her mouth to say the Second Amendment doesn't exist in her courtroom. Now, politicians and tech giants also don't want two-way content recommended to you. And we're all fighting this culture war together, so you can help do your part by liking, commenting, subscribing to the channel. But the most important thing you can do is share this video with at least one person, because together we can stop the suppression of our 2A rights and get this story out to as many people as we can. And don't forget to click the link in the description section of this video.
Yeah, that's Colin Noir talking about the Dexter Taylor case, and he says that he does a pretty good job of explaining it. And that's where we're at with the Dexter. We had a benefit for him. Did a kind of a cool live stream and space on thing on X on Saturday. We had a band that called No Quarter out of Oregon that played some killer blues. Quite frankly, I didn't know how good this was going to be. We started putting it together, but I was mesmerized by the music. It was it almost just didn't get better than that. But we were able to raise over $1,220 just that night, and we picked up another $600 from the K Daily Show. And we're going to ask you to do it here as well. I'll post the Give, Send, Go link for the Dexter Taylor Legal Fund up here in a moment. But since we're still waiting, let me check to make sure this jury decision could come quick. You'll be disappointed to say that it hasn't come yet. Or disappointed to hear, I should say. But let's listen to Dexter. Now, this is an interview from CBS. They're absolutely not for your gun rights. But this is an interview that they did in while Dexter was in prison. So this is Dexter in his own words what happened, and some video of the actual raid.
Now to the story of a quiet, studious man from Brooklyn who's doing hard time upstate. He openly admits to assembling ghost guns at his home, which is illegal, but he says his constitutional rights are being violated. Tonight, our conversation from behind prison walls, beginning with the moment his life was upended. 6 o'clock in the morning, you're lying in bed.
Yeah.
What happens?
I hear a bang, and I see underneath the crack in my door, I see like weapon lights flickering back. I said, ooh.
Hands up. Get out of here right now.
So I said, hello, hello, hello. I'm Dexter Taylor.
My name is Dexter Taylor. Yeah, we know your name. Come on, come on.
Why are you looking for me? Because I still thought they had the wrong house. And then they said, yeah, we're here for you.
Police department, search warrant.
April 6, 2022, an elite NYPD unit forces its way into Dexter Taylor's home in Bushwick, Brooklyn.
Come out. Come on. Keep a gun up. Keep a gun on that thing.
Why are you looking for?
Maybe it's the rifles you got laying around everywhere.
They had a search warrant at this location? Yes, sir. I know it's probably real, but can I see it?
It was an hours-long search of Taylor's packed home.
2 weeks ago, I did a video on.
Now to the story of a quiet, studious man from Brooklyn who's doing hard time upstate. He openly admits to assembling ghost guns at his home, which is illegal, but he says his constitutional rights are being violated. Tonight, our conversation from behind prison walls, beginning with the moment his life was upended. 6 o'clock in the morning.
All right, folks, we're back. We have a decision. She's found guilty on both counts.
I would like to say I'm shocked.
Let me get some audio here. Give me a second.
Leave here, I guess, momentarily, but we're talking about what happens next. All right. Thank you to our Fox 9 viewers for joining us for this. Nicole Mitchell found guilty on both felony counts, and we'll return you to programming. More coverage to come at 5 p.m. All right, Marsh, as we continue on with our streaming viewers, again, we talked about what happens next, a pre-sentence investigation and then a sentencing to be set sometime within the next, sometimes you see these where they take a month, sometimes 2 months before you get to a sentencing date.
Yeah, generally, I've just found probation's getting really backed up across the state on some things. They're a little slower than they used to be. So an 8-week outdate is a lot more common now than it used to be. And in that time, she can get letters of support put together for her from various people. They'll review her finances, her prior record. They'll do a long 10, 20-page report about who she is for the court, confidential, sealed for the public. And then she'll prepare a statement that she can read. They'll have a statement that Carol, the victim in this case, the stepmother, can come to court. She can read it or have someone read it for her if she wants to. Other family members can step forward. And like I said, we've got this 6-month mandatory minimum that I think the judge is going to, at the very least, impose that.
And you wonder, though, again, because of this sort of family at the heart issue, we don't know. I mean, she did testify this week, Carol Mitchell, and, some reports about her, thinking her husband died 30 some odd years ago in 1993. So I don't know where her mind is, but, is there a chance this family comes together after all the hurt, the pain after this?
Come together.
And takes a position
Right now over me. I don't want to hear their proposition of still what's going to go on. Okay, so she's guilty on both counts. No shocker there. I think most anybody watched this all the way through is not surprised by the verdict. It looks like they're talking about a 6 to 8 week delay before there's a sentencing, and there will be. The things they talk about are true. Typically, it's a probation department that does some sort of a pre-sentencing report. Talks about you as the person that provides it to the court. It seems like 8 weeks, a long time after you've been found guilty of 2 felonies to stay out and free, but I guess that's the way it's done up there. In the great state of Texas, you'll go into handcuffs at the moment the verdict comes down, the gavel goes, and typically they'll sentence you right then and there. But the jury does the sentencing there. In this case, the judge will do a sentencing because I guess that's the way you administrate justice versus deal it out. But that's the way it's done in that state. Any comments from you guys? Any shock? You shocked by it?
I'm not shocked by it, but I feel a bit robbed. Why didn't we get to see Nicole's face when they read the verdict?
Yeah, you know what? That might have been on me. I'm not sure I was watching it close enough there. I thought I was. Let me look on the feed.
All I saw were the commentators.
Yeah, that's all I saw as well. I saw the this part right here.
Yep.
That's all I saw. So yeah, but you know what? Maybe they didn't. No one. Maybe they didn't want to. They didn't want to read that out, and who knows? I don't know why. But it is what it is, and there's our answer. There's a burglary tool. I've already got some other folks from Minnesota that sent me some information on another trial that's coming up here and shortly that they think would be interesting to watch. So good job, you guys in Minnesota, keeping up with some great content and give me a lot of cannon fodder to talk about, without a doubt. We do like you guys in Minnesota, without it, from Texas down here. So hats off to you. Some of you guys. And other ones, man, I don't know. If you're breaking in somebody's house to change your cat litter box, you should probably stay in Minnesota. We don't want that kind of BS down here. We don't understand that.
If you're putting tampons in boys' bathrooms, you can stay in Minnesota. We're not happy with you in Georgia either.
our boys don't need tampons down here. Typically, it's not the way it works. So yeah, I like the way every time I bring this up, we have to talk about tampons. I'd like to negate that. It's a weird topic.
Okay.
Breaking into somebody's house where I live to change the litter box would probably be detrimental to your ability to live.
Yeah, we don't like you to break in and clean our houses down here. Maybe we're rude, but we're not real cool about breaking into my house to clean it or to clean my contacts up on my phone. I don't want you to do that either. I just have to deal with that myself.
But hospitality down here, we're not elitists who have that expectation of others doing that for us.
Well, most of us aren't smart enough to know that we're smarter than everyone else, and we need to go change their lives and interject ourselves into it. But you know what? That's enough talking smack. We don't want to talk smack about our Minnesotans because really, we've learned a lot. I've come to know a lot of you folks up there, and I've got nothing but admiration for you and some love. I do feel bad about. I feel you guys are getting raked over the coals on a lot of stuff, so that's. I feel bad for that, but you guys can fix it. Y'all got some things working your way there, I think. That could come to be a positive thing. But you know what? With that, guys, I've got stuff to do to get ready for tonight's grand jury. I'm gonna leave you with the grand jury promo so you can see what's going on tonight. That's on X. If you want notifications, you can follow me. You can follow Vigi. You can follow Big Ron. You should follow all of us on X and hit the notifications every time we go live with one of these. Sometimes we wouldn't have a chance to promote it. And it's difficult to promote streams on X. I will say that. You'll know that we're up, and if you can come join us, then we'd love to have you. But with that, I want to just a second.
Oh, hey, one thing, not to go over it, Joe, but to anyone watching, this changes the balance of power, I think, in the Minnesota State Assembly as well.
You know what? I'm not sure exactly. It definitely, it's going to remove one, subtract one. But I think there's, it could. The way I understand it, there's like almost a tie split right down the middle between both houses. So yes, that could make a difference. But of course, she's coming from a district out of close to St. Paul. I understand this is a very liberal district, so she'll just be replaced with the next super white liberal that's here to change everybody. And maybe we get some laws passed, man. Let's. Mandatory. If somebody's not cleaning the cat litter box, go in at 4 a.m. Be quiet, don't get caught, but go in at 4 a.m. Let's get these cat litter boxes clean. Take your rubber gloves in case you need to check the expiration dates in the refrigerator. And then, of course, obviously, if you have the opportunity, a clandestine style, get a hold of the phone and make sure their contacts are cleaned up and they haven't deleted text messages they should, or delete text messages that they need to. If you need to do 2-part authentication to keep a good eye on their bank account, just in good measure, then you should. I think we should do that in Minnesota with the next legislator. Don't pass the SHIELD Act, though. Let's don't do anything to keep kids safe in Minnesota. And I'm saying, and I say this again, I'm saying it's in my great state of Texas. Let's not pass anything like that. We like the other laws that are ridiculous and that are 5,000 pages and nobody can understand. We don't want things that are simple. That's not the American way. We want you to chug up the wheels with as much grease and crap as you can. But I say all that facetiously and with sarcasm. All right, guys. We're going to end this. I've got some more video cutting to do for the grand jury tonight. It's going to be a great show. We've got a great set of volunteers. You won't be disappointed. I've met with all of them, and their points of view will be interesting. And our good friend B says, thank you. Tip your host, Joe Lanou, on your way out. I do love me some B. She is a loyal viewer and a good friend of the show. We appreciate each and every one of you. I'll catch you on the next court case, but catch us tonight for the grand jury. Thanks, Fidgy. Thanks, Big Ron.
Did you ever get any money from Costello?
No.
And did you ever get any money from Meyer Lansky?
I never got money from any of those fellas.
None of those
None
fellas?
of those fellas. None of these that I've been reading about, or none that I knew. They never gave me anything.
None of the Shetties?
No.
You
I
think-
don't even speak to the... I mean, I met that Charlie once or twice. I don't even talk to him.
You don't like him?
I was conscious of the fact that he had a reputation for being an outstanding bookmaker.
You ever hear him referred to as the Prime Minister of the Underworld?
That term I did not. You're also known as Duck Corella.
I refuse to answer on the grounds of negligent. Got any business? I refuse to answer on the grounds of attempt criminal. You have any profession? I refuse to answer on the grounds of negligent. You have any occupation? I refuse to answer on the grounds of negligent. Are you a known racketeer?
An incarcerated individual's use of institutional telephones constitutes consent, and your calls may be provided to law enforcement agencies. Thank you for using Securus.